ಬಾರಮ್ಮಲ್ಲಿ ಸ್ವಲ್ಪ ಕೂತ್ಕೊಳ್ಳಿ. ಸೌಂಡ್ ಏನು ಇದ್ದಂಗಿಲ್ಲ ನೋಡು. ಅದೇ ಸೌಂಡ್ ಅದು ಮಾಡ್ತಾ ಇಲ್ಲ. ಹೇಳಿ. ಸಾಯಂಕಾಲ ಬನ್ನಿ ಮಾಡೋದು. ಸಾಯಂಕಾಲ ಬನ್ನಿ. ಹೌದು, ಏನು ಬೇಕಲ್ಲ.
ಮೇಡಮ್, ನಿಮ್ದು ಆಫೀಸಿಂದ ಡಿಸ್ಟರ್ಬೆನ್ಸಸ್ ಆಗುತ್ತೆ. ನೀವು ಕೇಸ್ ಕನೆಕ್ಟ್ ಆಗೋವರೆಗೂ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ರಾಜಗೋಪಾಲ್ ನಾಯ್ಡು. ಹಲೋ ಸರ್. ಯಾವ್ದಪ್ಪ ಅದು? ಸೇರಿಸ್ಬಿಟ್ಟು ಹಂಗೆ ಸೀರಿಯಲ್ ಮಾಡ್ಬೇಕು. ನಂದು ಕಾರ್ನಿಶ್ ಬಂದ್ಲು ಟೇಬಲ್ ಫೈಲ್ ಕೊಡ್ತಾರೆ. ಹಂಗೆ ಆ ಬುಕ್ಸು ಎಲ್ಲ ಈಚೆ ಇಟ್ಬಿಡು ವೆಂಕಟೇಶ್. ಸ್ಟೆನೋ ಬುಕ್ಕು, ಮೆಮೋ ಬುಕ್ಕು, ಆ ಬುಕ್ಸ್ ಈ ಕಡೆ ಕೊಡ್ತೀನಿ. ಇಲ್ಲಾಂದ್ರೆ ಆಮೇಲೆ ಅವಳು ಬರೀ ಮೊನ್ನೆ ಹಂಗೆ ಅಲ್ಲಿ ಅವಳು ಕೊಡ್ತೀನಿ. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಸ್ಟೆನೋ ಬುಕ್ ಇದೆಲ್ಲ ಅಲ್ಲ. ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಬುಕ್ಕು ತಗೋಬ ಅಂತ ಹೇಳಿದೆ ನಾನು. ಇನ್ನೊಂದು ಬುಕ್ಕು ಇಂಡೆಂಟ್ ಹಾಕಿ ತಗೊಂಬ ಅಂತ ಹೇಳಿದೆ. ಡಿಸ್ಪೋಸಲ್ ತೆಗೆದು ಏನ ಒಂದು ನಿಮಿಷ ಯಾವ್ದು ಪ್ರೊಸೀಜರ್ 11 ಯಾವ್ದು 9 ಅಫಿಷ್ 155 2 9 ನಾನ್ ಸರ್ ಇದೆ ಸೈನ್ ಇಲ್ಲದೆ ಇರೋ ಕಾಪಿ ನಿಮಗೆ ಬಂತು ಸೈನ್ ಆಗಿರೋ ಕಾಪಿ ಕೋರ್ಟ್ ಇಲ್ಲಿದೆಯಲ್ಲ ಪಟ್ನ ಕಬ್ಬಿಲ್ಲವಲ್ಲ ಹಾಂ ಆಯಿತು ನಿನ್ನೆ ಅದು ಸೈನ್ ಇದ್ದಿರೋದು ಪಿಕಪ್ ಮಾಡಿದ್ವಿ ಈಗ ಸೈನ್ ಆಗಿರೋದು ಬೆಳಿಗ್ಗೆ ಬಂತು ಆಯ್ತು ಹೌದಾ ಏನೋ ಕರಿತಾ ಇದ್ದಾರೆ ನೋಡಪ್ಪ
Madam, court officer.
ಹೇಳಿ
No,
ಮೇಡಮ್.
madam. ಈಗ ಲಿಸ್ಟ್ ನಂಬರ್ 5 ಹೇಗೆ ಇನ್ ಆರ್ಡರ್ ಆಗಿ ಕರೀತಾರ ಇಲ್ಲ ಫಸ್ಟ್ ಇದ್ ಮಾಡ್ತಾರ?
ಅದೆಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್. ಮೇಡಮ್ ಬಂದಾದ್ಮೇಲೆ ವಾಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಐ ವಿಲ್ ಕಾಲ್ ದ ಲಿಸ್ಟ್. I think it is in that JJ's folder.
Worship, one submission, Your Worship. List number 4, serial number 6, Your Worship.
No, they will first out of the list mentions. Yes. Huh?
In this case,
What happened
I
to
for
this?
the respondent.
So Mike use பண்ணுங்க.
In this case, I for the respondent, my lord, the honorable court has granted interim order to deposit 50% of the amount. He has deposited 50% amount and further direction to him to pay the order as passed by the trial court, my lord. Almost 4 months elapsed, he has not paid the amount.
Yes. Look at it and as per the convenience. Yes, any other?
And there are one more petition. Mine is enhancement also. I have put.
Yes.
Memo for posting, Your Lordship. One, this is arising out of an order of 7 to 11 filed by us, wherein we've sought for dismissal of the restitution petition, Your Lordship, because there are parallel proceedings going on in the High Court with regard to the stay of decree proceedings, Your Lordship. Your Lordship, it may be taken up today, Your Lordship, at 2:30, Your Lordship. There's urgency, Your Lordship. Tomorrow is the matter for evidence, Your Lordship. The evidence, if it,
When is the order passed?
Your Lordship, 4th of July, Your Lordship.
Where are we now? No urgency. Let
Lordship,
it come.
kindly have it tomorrow, Your Lordship.
If it's a fresh matter,
Please.
office objections are complied. Accordingly, it will be listed. Yes.
Please.
List wise.
List number, page wise adjournment. List number 1, page number 2, page number 1, serial number 2, 3, page number 2, serial number 4 to 8, page number 3, serial number 9 to 15, page number 4, 16,
16? No, where, like, have you informed the other side? Because he has not served, if you are here, he will serve. Yes.
Second list.
Yes.
Cause list 2, Your Honor. Cause
She
list.
will call number wise, then you can make mention.
page wise adjournments in list number 2, page number 3, serial number 7, 8,
CL number 1, my lord.
It's a
For this,
password matter, it will not
my
be.
lord, it is settlement going, my lord, for respondent. Kindly have a wait.
No.
Settlement is going on, my lord.
My
Lord,
Lord,
serial number 2, my lord. List number 2. I am applying for petition, my lord.
Dismissal, that also will
My
not
lord,
be
Allah,
done.
senior is out of country, my lord. My lord, Allah, IA, respondent, IA to be filed, my lord.
Yes, I'll not grant adjournment. Please come.
My lord,
whatever you want.
respondent,
Lord, serial number
IA
8,
to
my
be filed,
lord.
my lord. Objection to be filed, my lord. 2 weeks time, my lord. Respondent is
Call the name.
page number 3, serial number 7, 8.
She's calling. She said 3 to 5. In that your matter is there, you please mention.
7 and 8.
Please understand what's happening.
7 and 8.
Yes. In which case, 7 or 8? Have you informed the other side?
My lord, serial number 8, I appear for the petitioner. My lords, I'm not aware of the counsel on the other side.
I'm here.
Yeah, but
Wait till the matter is called.
my Lord, serial number 8, my Lord, I am for respondent. I have intimated to the other side. He is my colleague, my Lord. He is my colleague, my Lord.
She says that they are not aware.
my lords, I wasn't aware of him as her colleague.
My Lord, I am intimated to the...
When do you want?
Tomorrow, my Lord.
How can you say that it's not about knowing him? It is about whether you have informed, you've been
My
informed.
humble apologies, my lords.
Yes. When do you want?
Tomorrow, my Lord.
Yes, tomorrow.
Serial number, page number 4, serial number 9 to 12. List number 3, page number
My lords,
3,
my lords, list number 2, serial number 24, my lords.
List number 2.
page
20.
List number 3, page number 4, serial number 11 to 13. Page number 5,
My lord,
serial number 14 to
serial number
16.
15, serial 15, my lord. Respond from left for time. They've intimated the other side.
Because I'm not able to understand who is mentioning from where.
I'm for
Nobody is
respondent.
following what is the court officer calling.
That's cause list 2.
Cause list 2 is not been called out.
Cost list 2, my lords.
ಇಲ್ಲ ಕರ್ದಿಲ್ಲ
You have to
sir.
complete cause list two.
Cause
Is
list 2
there
Serial number card list 2 only I called my
13 to 22?
13 I'm for petition my lord. Filing memo for withdrawal.
Please take that.
ಅದು
Use the mic, Anita. Use the mic when you're calling.
Mike is here.
Yes. Ask them to keep it this way.
That's cause list.
Cause list 2, 22, 24, 21, 2, 3.
Memo is fine. I think today something is thoroughly wrong with everyone. The memo is fine. Seeking to withdraw the petition. Memo is taken on record and dismissed as withdrawn. Yes.
My lords.
Cause list 2, Your Honor. Serial number 24, 21, 24, 1, 2, and 3, Your Honor.
It is second page is 13 to 22. Anybody?
Cause list 2.
13 to 22. Yes.
Second is 17.
Huh?
Second is 17. Serial number 7.
Yes.
Time. Really compromise ಆಗ್ತಾ ಇದೆ.
Have you informed the other side? Huh?
ಹೌದು.
You have informed us. You are for the respondent or the petitioner?
Petitioner.
Land counsel for the petitioner he seeks time. It is submitted that the same is informed to the land counsel for the respondent. List this matter in the month of November.
My lord, serial number 2, list number 1, my lord. This informed other side, my lord.
That I will not adjourn serial number 2 in list number 2 because it is in the caption.
My lord, in the settlement is going on, my lord. Family
Let it
mediation.
go. Let it go. But I have already rejected your request. Why are you reiterating that?
My
Yes,
submission, my lord.
Page number 6, serial number 23 to 27. Page number 7, serial number 28 to 35.
That's
Serial
number 31, my lords. Serial number 31.
Yes.
There's an OS suit filed, my lord. I'm to the petitioner, my lords. An OS suit is filed for mutual consent, my lords. The matter is settled.
It is settled.
Yes, my lords. Today it has been advanced, my lords. This petition also may be this one. It may be filed for. It may be even for mediation, my lords.
No, mutual consent divorce is filed before the court.
Yes, my lords.
Then where should this be sent?
No, this may be also referred
This
to
also will
mediation.
go as per the order of that.
Please, my lords.
When is it coming up before the
Today
trial
it's
court?
been getting advanced, my lords.
Yes, list this matter on 24th of September.
My lord, serial number 35. I am for the respondent.
Yes.
We seek 1 week of time, your lordship.
Have you informed the petitioner?
Kindly, your lordship, rest it.
He is asking for time. It is agreeable to
Yesterday
you or
night we
not?
have informed.
Huh? List the matter on 25th. Yes.
Kindly.
Page number 8, serial number 30. That is
Yes, next list.
number 3. Page number 2. Page number 4.
Yes.
11 to 13. Page number 5, 14 to 16.
And serial 15, my lord. Response comes next time. I intimated the
Serial
other side, my
number?
lord. 15, my lord. I informed the other side, my lord.
Yes, at request, list this matter in the month of November. Yes.
Page number 6, cell number 17 to 20.
Yes. Next.
List number 4 referring to Lok Adalat matters. List
1 minute, one minute. What is this notice to R3? R3 is already there. Yes. Next 2 is what do you say? Delete this matter. Delete this matter from this list of referring to the Lok Adalat for steps to your for issuance of notice to R2. P. R. Govindaraja. R2 is the insurance company.
Your Lordship, I request a week's time to file my wakalat. I just received a wakalat from the insurance company.
Delete.
R2.
Delete. Yes, yes.
My lord, serial number 2, my lord.
Serial number?
Serial number 2. Insurance company has filed this appeal. There is no chances for the settlement.
So it is deleted.
Serial number 2, my lord.
I am only referring to 2 only. One is already over. One is over. One is to the Lok Adalat. 2.
To challenging the liability and
They are referring it about two, not one. Not about one. One who is representing. Nobody has represented one. They are representing about two. Two delete from the list. Yes, next.
Serial number 3.
Delete from the list and post in the usual course. Yes.
Serial number
Yes.
6.
Yes. Delete from the list, post in the usual course.
Serial,
Yes.
serial number 24, list 2, 1, 2, and 3. The connected matters is on 18/9, Your Honor. It is posted before the CCH2, Your Honor.
Lords, interim order may be extended, my lords, say in the matter, serial number 24. Interim
Pause
order may
list
be.
2, 24, 1, 2, and 3.
Pause list 3 now. Pause list 4. Yes. Call the list to wait till the matter reaches. Yes.
My lords.
Yes. Call the list. Waste of time, nothing else.
List
For
number
half
1.
an hour.
My lords, please, my lords.
List number 1.
It will not be adjourned. Please wait. Yes.
List number 1, serial number 1, Ranjan Kumar K. For dismissal, Rajgopal Naidu.
I represent the respondent, my lord.
Yes, argue.
There are arrears more than 18,000.
During the main matter itself, forget about the arrears. Yes. Switch on the mic. Otherwise, they can't hear.
20,000.
Yes.
My lord, 20,000 is awarded
Yes.
to the child, my lord, and nothing is awarded to the wife.
Wife is seeking an
No, my lord.
maintenance.
Maintenance was sought, my lord, 50,000. Trial, the court appreciated the evidence of, my lord, the petitioner and
Please come to that paragraph where the maintenance to the wife is discussed
para
and
13,
rejected.
para 13, my lord, page 17.
Please read.
Marriage of the petitioner and the respondent dated 13/4/2014 is undisputed fact. Out of the said wedlock, one child is born, that is petition number 2 is also undisputed fact. It is admitted fact that she is getting 54,862 and also admits that in the month of November 2019, she is getting rupees 64,342
Get the other one. Yes.
per month. Both salary documents are marked as Exhibit R1 and R2. It is admitted fact that the respondent is MBA holder and she is employee and getting more than rupees 60,000 per month. Petitioner in her cross-examination denied the suggestion that now the respondent is unemployed since March 2017. Considering Exhibit P1 and R1 and R2 documents, petitioner is not entitled to any maintenance from the respondent. It is admitted fact that out of their marriage, petition number 2 was born and it is the bounden duty of both parents to take care of the child and to give good education to the child. Petitioner is taking care of the child and she has also produced
You
schools.
are getting an income of 54,862.
Not me, my lord. That is the wife is getting.
Yes.
This is, my lord, the petition by the husband.
Seeking maintenance from the wife.
No, not maintenance. A wife, my lord, filed maintenance petition
But I
seeking maintenance.
understand. Please come to the order. Come to the order.
Yes, this is,
Who
my
is the
lord.
petitioner now?
Petitioner, my lord, is the wife in this miscellaneous.
No. Before this court.
Before this court is the husband.
So you are questioning the 20,000 that is granted to the son.
Yes. I sought for, my lord, I'm seeking for reduction of the amount because what has happened.
Your income.
My income, my lord, I have produced exhibit, my lord, R3, page number 27. I'm getting a salary of rupees 17,234.
234.
My lord,
What is the discretion of the court with regard to your income?
my lord, the court has.
Even though respondent not filed affidavit regarding, why did you not file?
My lord, what has happened is, my lord, that I was there in Mangalore, my lord, and I could not, because of the financial crisis, I could not come
File
over.
before this court?
My lord,
Did you file before this court?
yeah, my lord.
Did you file before this court your statement of assets and liability?
No, I have not yet filed.
Court will not take it on its face value.
That is the reason why, my lord, I want to contest this case because of my financial ability, financial.
This is a RPFC of 2024.
Yes.
According to the court, you have seen the findings that assets of statement of assets and liabilities is not filed. If there are bona fides on your part,
No,
you would
I
have
did
filed
not.
some application.
My lord, I did not appear. My lord, what has happened is after filing of the objections, my lord, I was in financial constraints and therefore, my lord, I could not come over to.
Before the court Mr. Counsel, you are understanding what I am referring to. I said,
Before this court, I should have filed, my lord. I
I have
understood
not
that.
filed, so we will not consider. An adverse inference has to be drawn against everyone who is not following the law that's laid down by the Honorable Apex Court. And this is not a matter of procedure that every matter will come, will pass through the High Court, the Family Court, High Court, Supreme Court. That's not. When you are supposed to do something, you are not done. And the judgment says that adverse inference has to be drawn. We will draw the inference and we'll continue this 20,000.
My lord, 20,000 he is unable to pay because, my lord, out of 17,000, he has to look after his parents who are ill, my lord, under the treatment. And, my lord, he has no sufficient income at all.
Were you not represented by an advocate before the court?
My lord, only till the objection is filed and thereafter he has not appeared.
Then that is all the more a problem that
Because he could not come over and, my lord, he could not cross-examination and also could not lead evidence and subject himself to cross-examination. That is why, my lord, I am saying one opportunity may be given and remanded back so that I'll continue with.
Not any opportunity. First of all, then when the matter comes, you don't appear before the court.
No, I am extremely sorry, my lord. That moment, my lord, I came inside, my case was called and it was listed for dismissal. On the other day, I was held up in another court. I came running, my lord, but my apologies, my lord, for that. And, my lord, I may be given a chance to, my lord, file my assets and liabilities within 2 days, my lord, I'll file
A
it.
writ petition that is filed in the year 2024. What is the date of the writ petition? 2012-2024. It has not come up before the court because you are not complied with the objections till 4/3/2025. Then, after that, you will not take steps till 22/7/2025, till an order is passed by the court, a default order is passed. Then later when it comes on 29/8, you will not appear before.
No, I'm extremely sorry. I was there in the court. I was held up. The moment, time I came here, my lord, it was called and listed to dismissal.
Here that it is not a matter of routine procedure.
No, insofar as, my lord, my submission is this. My endeavor.
Before the family court.
No, my submission, the family court, I've already, my lord, the wife has already taken a divorce. It's only with regard to maintenance.
Maintenance only.
Yes, my lord. Now, one submission, my lord, I may be given sufficient time, at least, my lord, 2-3 days, so that, my lord, I'll file my assets and liabilities here.
Did the court has to advise the client?
No, not that, my lord. Usually what happens, my lord, that the objection will be raised in the office. It's not done in this case. That is why, my lord, it's not filed. I'll file it, my lord, in 2 days, so that, my lord, can be considered thereafter.
An application can be filed before the court saying that I want to file these documents additional. Court will consider that. I do not find any bona fides in this case, and the kind of litigation cannot be entertained by the court like this.
Yes, then I leave it.
Please come. Read with orders passed in criminal miscellaneous number 480 in INM in criminal miscellaneous number 480 of 2017 dated 18th October 2023, whereby the court had granted 20,000 maintenance to the child. The husband is before this court. The wife had filed a criminal miscellaneous seeking maintenance of an amount of rupees 60,000 per month and litigation expenses of rupees 50,000. It is a case of the wife that the husband is an MBA graduate and employed in a reputed company in Gulf and drawing rupees 1 lakh per month, and her salary is rupees 54,862. The court has held that as a wife is earning, she is not entitled for maintenance. Then when it comes to the husband has not filed his statement of assets and liabilities and drawing an adverse inference, the court, considering the facts and circumstances, had granted 20,000 as maintenance. This order is passed on October 2020, 18th of October 2023. Against that, the writ petition is filed on 20/12/2024. That is after 1 year, after more than a year from the date of the order. The learned counsel appearing for the petitioner submits that the petitioner was in a financial crisis. He could not approach the advocate. He could not file his statement of assets and liabilities. As such, one more opportunity may be given to the husband, and he could not cross-examine the wife. It is submitted that husband is not having the financial capacity to pay 20,000 to the child. Learned counsel appearing for the respondent submits that in spite of an interim order passed by this court, same is not complied with, and the court, considering all the facts, has rightly granted the compensation, and there are no grounds to interfere with. Next, having heard the counsel for the so and so. An order that is passed on 18th of October 2023 is questioned before this court on 20/12/2024. And the matter has come up before the court for the first time because of his objections were not complied with on 4/3/2025. Then on 4/3/2025, an interim order is passed. Thereafter, for paying the process, it took till 22/7/2025. The main reason on which the court had dismissed has granted 20,000 is the husband has failed to file his statement of assets and liabilities. The reasons that are stated that he is in financial difficulties. He has not filed his statement of assets and liabilities. And if once such opportunity is given, he will file the statement of assets and liabilities. There is no force in the submission of the land counsel for the petitioner husband, and this court do not find any reasons to entertain that. The family courts are burdened with work in view of the huge litigation of this matrimonial matters. In each and every case, at least in every alternative case, the writ petitions that are come before this court is that the statement of assets and liabilities are not filed before the family court. Hence, an opportunity be given to them to file the same and set aside the order and remand the matter. The litigant has to understand that the judicial time is valuable, and court will not, in a routine manner, will not permit the parties to first not comply with the mandate of the Supreme Court and then come before the court seeking for remand. In this case, the order that is passed in 23, which is questioned in December, and which is waiting till May of 2025, shows that the petitioner has no bona fides. When the order discloses that as assets and liabilities are not filed when an order is passed, the petitioner has not even taken any steps to file the statement of assets and liabilities even before this court. This court finds that these kind of petitions cannot be entertained, and if entertained, it becomes a routine practice for the litigant to approach the court after taking convenient, considerable time for the court. In that view of the matter, this court do not find any reasons to interfere with the order passed by the family court, accordingly dismissed.
Cell number 2, hearing on interlocutory application, K. Srihari for petitioner.
My lord,
Praveen Kumar Appaya.
observation regarding, my lord, the income which has produced, my lord, as Annexure 3, 17,000 is getting estimated, my lord. An observation may be made.
It is submitted with the land counsel for the petitioner that he is getting 17,500.
And 2,034.
Huh?
17,234.
17,234, yes.
Here for the respondent.
Hmm.
My lord, kindly pass on. Some hearing, my lord, hearing of the interlocutory application.
Delay application, my lord. Hearing on delay application.
Yes. No, Passover may not be possible. This is matter in the month of November.
Cell number 3, Mohan Chandra P for petitioner.
Number 1, there is a delay of 188 days, my lord.
Why? What is the reason for 188 days delay?
My lord, I was placed before the trial court ex parte. Thereafter, the trial court has passed the final order.
Why you were not appearing before the trial court?
Because summons was not served to me. The notice issued by the trial court not served to me, and so because thereafter I was placed ex parte, and final order was
not served on him.
Notice after service of notice only, my lord, he was placed ex parte before the family court.
Thereafter filed the execution petition. At that time,
the trial court record is there.
No.
Registry is directed to call for the trial court record. This is matter next week. By the time the registry shall ensure that the record is before the court. If what submission you make is not correct, we'll dismiss it.
One more submission. The procedure followed by the trial court is totally illegal.
First of all, you should appear before the court and tell the court all this.
No,
why you are not appeared?
Procedure followed by even as per the provision of CRPC 125.
We will see. We will see.
Yes. Yes.
See, then let the record come. Yes, for.
Cell number 4, Gaurav Subramaniam, for petitioner Ashok Patil.
For 1 and 2, for R1 and 2, my lords, here in this respondent number 1 and 2 are the parents of the petitioner, my lords. Since 2016, I am not getting any money from them.
This is
Moreover,
for
the
dismissal tomorrow.
copy
Not-
not has been served on us, my lords.
He's
Kindly
not
tell.
here. Let him come.
Afroz Pasha,
No
cell number
representation
5.
for the petitioner.
For
Also,
petitioner, my
the
lord.
respondent is present. This is a matter for dismissal. Fine.
Afroz Pasha.
There's a delay of 241 days, my
Yes,
lord.
notice to the respondent.
By hand may be issued, my lord. By hand,
To whom you will serve? No hands. Yes, emergent notice.
Lord, because the execution warrant has been issued, my lord. So, sir, by hand may be issued, my lord. Notice, my lord.
Execution is pending.
Yes, my lord.
The petition is permitted to take out hand summons on the counsel appearing before the executing court and shall file a memo to that effect. Once the memo is filed, is the matter.
For admission matter, cell number 6,
Offering for respondent.
Keshava
My lord, objection copy received, my lord.
Have filed
For
statement
reply,
of objection.
No
for reply one
objections.
date.
We will look at the order impugned. No objections are required in this. Please come to the impugned order.
No, my lord, today only got objection copy. For reply.
I'm not looking at his objections. What objections in RPFC? I don't understand.
It is regarding memo of calculation. They filed the memo of calculation, to that I have filed.
At request of I'll decide this matter. I'll decide the main matter. Whatever or the amounts that are pending, you will see before the executing
Then
court.
pass over, my lord. Senior will come next.
Yes, next.
cell number 7, Rudra Papi, for petitioner.
I am for the respondents in this case, Your Honor.
Matter settled, my lord, but day after tomorrow they will come.
Mediation reports received as settled. Non-filing of
They have deposited the amount, my lord, but it will be posted day after tomorrow, my lord, Thursday. Parties will come, my lord, on that day.
This is matter on Thursday. The party shall appear as it is submitted that the matter is settled between the parties. Yes, next.
Much obliged.
Cell number 8, cell number 8, Chandrasekhar P. Patil.
I am for petitioner in this case, my lord.
My
Petition is,
objection, my objections are ready, Your Lordship. I'll file it in the office.
Objections or what?
Now
Come to
it's
the impugned order.
this petition,
Where is the impugned order?
please, madam, page number 47, madam, 46, reason starts. This petition is filed against the interim arrangement made in this case, madam, because last time Your Lordship said how it is maintainable. But previously,
I saw that also.
Please.
That's why what to do.
now Your Lordship may
Pass
kindly see, my lord, page number 47, para number 8. The respondent has filed objection contending that the petitioner number 1 and 2 are not his wife and daughter, and the petitioner number 1, by creating some forged documents and photos taken at the time of tour and by colluding with the one Indramma who was working in their house, has filed this petition, and he has married one Srimati Reshma, and out of the wedlock 2 children are born to them, and as such he marrying the petitioner number 1 does not arise, and further stated that the petitioner number 1 had married one Raghavendra, and she had filed criminal miscellaneous number 1114/2013 against said Raghavendra, and same came to be disposed of in Lok Adalat held on 28/3/2015. And as such, he marrying the petitioner number 1 on 15/11/2013, that is during the existence of our earlier marriages, does not arise at all. The parties have made allegations and counter allegations against each other, which are to be adjudicated during trial. At present, the petitioners have filed this petition claiming that they are the wife and daughter of the respondent, and that they are unable to maintain themselves, and the respondent has not made any arrangements for their maintenance, and he is capable to pay maintenance. The petitioners have produced some photographs. Please, now Your Lordship may kindly take, my lord, page number 78. 78, my lord. This is the marriage photos, my lord, with wife of the petitioner. Wife of the petitioner. And the invitation card is also, Your Lordship will get it, page number F2, my lord. And he has got 2 children. That is annexer
No, the
F3 and
the court
F4.
had rightly said that.
Please.
All these issues will be adjudicated during the
Please.
course of trial. Now, the basic, as
Please.
of to consider this IA,
Please.
there is, she filed a birth certificate showing that
Please.
you are the father to the child. Your
Please.
name is there in the birth certificate. Court has also considered your submissions and said it will be decided during the course of trial. So what is wrong with the order?
Your Lordship may kindly take page number 126, my lord.
Yes.
The respondent has married one Raghavendra, and with him, my lord, the matter was settled. Your Lordship will get at 127, my lord, page number, bottom. That is 21 to 2015. That means from up to 21 to 2015, she is the wife of Raghavendra. Now she claims that he has married in 2013.
What is the date of birth of this child?
18. 2015, that Raghavendra's settlement was
6/7/2018.
Thereafter,
Birth of the child.
birth of the child 2018.
18.
But she claims that
According to her, when is the marriage?
Marriage, your lordship, it is according to her in 2000. In 2013,
Then what do you say about this document?
Lordship.
21 to 2015.
Yes, of course, your lordship, there was a family dispute was going on between the previous husband and wife. It was pending. She was out of the house and she was, your lordship, living with the petitioner after getting married in a temple. Now, your lordship, to prove that whether the son belongs to him or not, your lordship, I have produced voluminous documents, your lordship, including.
That is correct.
Yes.
No, whether she is entitled for maintenance under the facts, forget about the child. Child we will
Yes.
decide it
Now,
separate.
maybe your lordship that at that point of time, she was not got the divorce as living, he was the husband or wife of the one Raghavendra. But that education was going on, and it, your lordship, it is maybe she was living on then it was, at the most it affects adult, your lordship. But your lordship, the prove that, your lordship, that she has married to this person, your lordship, there all materials are there. So it has to be educated, your lordship.
Whether he is legitimate, illegitimate, whether he is entitled for maintenance, that is the law on that is clear. Whether she is a legally wedded wife of the respondent, the petitioner, whether she is entitled for maintenance. Your own, I mean, the whatever that divorce that you have obtained on 21 to 2015 shows that even as per your averred by her in 2013, she is somebody's wife.
She was somebody's wife, maybe.
So
but
say,
your lordship,
as far as the son is concerned, that shall be decided.
child, your lordship,
Child is concerned, that shall be decided in the course of the trial, whether he is entitled for maintenance or not. And they will say this maintenance, whatever is granted, is to the child, not to the wife. Prima facie.
Prima facie.
Once she proves
No,
everything.
then your lordship, that's whether she's wedded wife or not, your lordship, that is also proved by the materials, your lordship. Now it has to be.
No, that's what, that eventual, that as of now, it's an interim application.
Based on only one material, your lordship.
No, interim application. As far as the child is concerned, whatever maintenance that is granted, that we will award it to the child. As far as wife and the entitlement of the child will be decided by the court in the final hearing. Yes, please come. Agreed with an order passed in I number 2 in criminal miscellaneous number 254 of 2023 dated. What is the order of the date of the order?
7/8/2023, ma'am.
2023, whereby the court had granted
5,000 to the wife,
maintenance
3,000
of 5,000 per month to petitioner number 1 and maintenance of 3,000 per month to the petitioner number 2. The husband is before this court. The wife representing the son had filed this petition under section 125(2) CRPC for grant of interim maintenance of rupees 50,000 per month. It is her case that her marriage with the husband was solemnized on 15/11/2013, and they led marital life for about 6 months. and out of the wedlock, and in the wedlock, the second, the son is born.
Daughter.
Daughter is born on
6/7/18.
6/7/2018. 6/7/2018. As she's not able to maintain herself, it's a duty of the
Lordship,
husband.
one second. He himself admits, your Lordship, before some authority that I have got married the respondent on 15/11/2013. That is the documents available.
It's a duty of the husband to
Because
maintain the wife.
to get the LIC benefits, your Lordship, to the child, he makes the declaration by way of affidavit.
That I'll record in your content.
Yes.
It's a duty to maintain the wife and children. The respondent, not respondent, the husband has disputed the same by stating that he is married to another lady. In that wedlock, he is blessed with the children. He has no relationship with the wife, the alleged wife, and the child is not born to him. He is not the biological father. And they have relied on a Lok Adalat award that is passed on 21/2/2015, whereby she has divorced her, where a mutual consent divorce or is a settlement. A settlement is arrived at between the first husband and the wife.
Raghavendra.
First husband and the wife. It is a contention of the husband that as on 21/2/2015, till 21/2/2015, when she is married to another person, her contention that she is married to this petitioner on 11/10/2020, on 15/11/2013 cannot be believed, and she is not entitled for any maintenance as she is not the wife. During the course of the trial, certain document on behalf of to substantiate their respective pleas, the husband on behalf of the wife, she has placed before the court the birth certificate of the child, that is birth certificate of the child. As per the same, the name of the
Father.
Father, the husband's name is shown.
Yes.
Ali's husband's name is shown as the
Rajesh.
father, as Rajesh, and her name is shown as the mother.
Affidavit has been produced before the authorities.
And according from the side of the wife, it is stated that what is the date of the affidavit?
That is, your Lordship, it is 11th December 2018.
That is
11/12/2018.
11th December 2018.
It is makes that I have got married on 15/11/2013.
That he has married the wife on the date as stated by her, that is on
15/11/2013.
The court had, by order impugned, had granted interim maintenance of an amount of rupees 5,000 to the wife and to 3,000 to the child, and the court has observed that prima facie she could prove that there is a marriage and the child is and then they have a child out of in the said marriage. Hence, all other issues will be considered by the court at a later stage. As of now, as far as the IA for interim maintenance is concerned, she is entitled for maintenance. Next one. When counsel appearing for the petitioner husband submits that the evidence on record clearly reveals that till 6/7/2008, till 21/2/2015, she is married to one Raghavendra. Question of she marrying the petitioner husband in the year 2013 would not arise. Whether she is a legally wedded wife of the petitioner or not, and all other issues needs to be decided. Unless and until that is decided, she is not entitled for maintenance. It is submitted that even the child is not the biological father to the child. Next one. When counsel appearing for the respondent submits that the birth certificate clearly reveals that the petitioner husband is the father of the child.
According to the affidavit. According to his own affidavit.
No, I'm saying about the birth certificate, and also the affidavit that is given to the LIC authorities also discloses that he is accepting the marriage, which clearly shows that he is that she is the wife and the child is the child in the marriage between the petitioner and the respondent. In these circumstances, the court had rightly considered and passed an order granting maintenance to the wife and the daughter, and there are no grounds to interfere with. Next part. Having heard the counsel on either side, peruse the material on record. According to the wife, the marriage has taken place on 21 to 2013. 21
15/11/2013.
15/11/2013.
2013. 2013. And the as per the Lok Adalat award, where she got a divorce from her first husband Raghavendra, is on 21/2/2015. The birth of the child is on 16/7/2018. And even the affidavit that is mentioned is also on 11th December 2018. As far as the marriage and the in these circumstances, the marriage, whether there is a whether she is a legally wedded wife or not, has to be decided by the court during the course of the trial. Looking at the birth certificate, where the name of the petitioner is mentioned as the father,
Rajesh.
and shows that she is he is a biological father, prima facie. In those circumstances, as far as the daughter is concerned, she is entitled for the maintenance. She is entitled for maintenance. In that view of the matter, the order of the trial court is order of the family court dated so and so is modified, and the modified as far as the order for of granting maintenance to the wife is set aside, and the daughter is entitled for an amount of rupees 5,000 per month.
3,000.
What has said?
Then number
Yes.
9. 9.
Partly allowed and accordingly disposed.
May I make one submission?
Yes.
Yes.
Tell number
Speedy
9.
disposal may be ordered
Share is this?
because it is 2013, 23 minutes.
Remember, Mrs. 23.
23 minutes.
23.
23.
Yes, next.
Please.
Till number 9. Rajita Rajshekar.
Please.
Yes.
Please, my lord. Appearing for the petitioner's call.
Yes.
Please, my lord. There is a petition for maintenance under 125 CRPC has been dismissed, my lords. May I pass on with? My lord, only on the one point.
Where is the order?
The order is in
Kannada, my lord. Entire
Kannada,
judgment in Kannada, my lord.
but the reasoning in the order is that she has refused to live with the husband. That's the
But I need to the
as well.
or we'll post it in the month. List is matter in the month of October, so you don't have to file the translated copy. Yes. Yes, next.
Till number
Please.
10.
My lord, I appear for the my lord petitioner in second matter, my lord, on 10.1.
Yes.
My lord, it's a 127 petition which has been filed by the my lord wife. Subsequently, my lord, even ordering my lord earlier maintenance for 4,000. My lord, that 4,000 was paid, my lord, by the petitioner till my lord the passing of the my lord final order in this case. But without considering that, my lord, the trial court, my lord, ordered 7,000 from the date of the petition, that is from 2017. When 4,000 is already been paid till 2024, passing the order. My lord, earlier, my lord, he was an employee of the BSNL. Now, my lord, he has retired on, my lord, on 2023, he is retired from service. When, my lord, when he is in service and when he is getting, my lord, 42,000, the trial court itself, my lord, after considering that 4,000 ordered. Now, my lord, he has retired on 2023. My lord, only.
Let me look at the order. This is a whole difficulty when the counsel is appearing online because you won't be hearing what the court is saying.
Sorry, my lord, sorry.
Order.
Page number
Kindly
13.
see the, my lord, impugned order next year, my lord, the portion is at, my lord, page number 32.
Counsel is here, let him tell the facts. Is enhanced to 4,000 to
7,000.
7,000. When is this miscellaneous file? In the year 2000?
17.
17.
Come to the reasoning part. You are seeking enhancement.
Please change the circumstance 127 CRPC.
No, now, before this
Now
court.
this is the petition. I am challenging that order. Earlier, I filed a miscellaneous number 42 for 2013. Final dated 3/2/2014. Kindly peruse the page number 21, para number
No,
13.
sorry to, my lord, interfere. My lord, let, my lord, I'll appear personally, my lord, if you have any inconvenience, my lord, in the hearing.
Understand. Yes, this is matter on 20.
I request this honorable court, if the parties are ready to settle the matter, kindly refer the matter for local adat. And they
What
list
do you
the
say?
matter for next month.
No.
Yes, this is matter on 24th.
Publish.
Yes, Levin.
Publish.
Cell number 11. Rupesh B.
11.1, my lords. We have filed for enhancement, my lords. I guess we'll have to take notice for that.
Will take notice, my lord. Let them serve copy.
Have a copy, my lords. So, lords, may fix a date, my lords.
My request to the advocates would be, your order and his order both are one and the same. He doesn't have to serve anything. Looking at the order, court is passing orders. You are ready with the matter, we can do it. Why again posting the matter just like that?
We'll have urged grounds in our petition, my lords. That is
Whatever are their grounds, you know how the court deal with it. Straight away come to the order, and basing on that, whatever are his grounds, I'm looking at the ground impugned order and passing the order. Even the other matter also, that's what he's saying. No, it is disposed of. Because all these RPFCs, writ petitions arising on against an interlocutory order, they don't require that kind of a roving inquiry before this court. It hardly takes 5 minutes to decide that. Yes.
Lords, may kindly have it next week, my lords. I'm not prepared.
Yes, next week. So and so serve the copy of the petition on the council appearing for the respondent. And in 11.1, Mr. Rupesh B is directed to take notice on behalf of the petitioner, on behalf of the respondent, and the counsel for the petitioner to serve the copy of the petition. Yes, next
Cell
one.
number 12. Ismail Mujib Musbah for petitioner. Dhananjay Kumar.
You have the respondent.
Yes, Your Lordship. Your Lordship, the parties have settled the matter, Your Lordship.
Huh?
Parties have settled the matter.
Settle the matter.
Yes, Your Lordship.
Where is the settlement memo?
I'll produce the documents pertaining to that in the next date, Your Lordship.
Please, we'll have it tomorrow. Get it.
Yes, yes.
It's this matter tomorrow. Then counsel for the respondent submits that the matter is already settled between the parties. Yes, 13.
Cell number 13. Mohammed Gafron for
125 final order, my lord. This is the ex parte order because the respondent has not filed the objection statement before the trial court due to the settlement process going on. So that the trial court has not provided the opportunity to petitioner for cross-examining and not
Why
provided.
it will give? No, when you are set ex parte, what you are supposed to do?
Because, my lord, we have appeared before the trial court and the trial court, I have produced the order. I am producing the order sheet, my lord.
It is there for the.
No, order sheet is not filed, my lord. At the
What is that order?
This is the order sheet, my lord.
Take that.
Let me see the page number 6. On that day, my lord, the petitioner changed her counsel in trial court and
This MC criminal miscellaneous is filed in the year 2003. When was the notice?
23, my lord. Sorry, my lord. 23, my lord. 23.
Yes, when is the notice served on you?
My lord, notice was served on me and I have.
You appeared on.
Yes, my lord. And I appeared. I appeared on 2/9/2023, my lord. 2/9/2023. Respond to the.
This served on you.
Yes, my lord. I have appeared. I appeared.
2/9/23.
Kindly come to my lord. After
Next,
that.
after 2/9/23, it came up on 5/10/2023.
Yes, my lord.
What is that petitioner?
Petitioner present, respondent absent. So and so advocate filed no objection, no objection.
So again on 5/10/23, you pray for time.
Yes, my lord. Thereafter on 25/10, the petitioner is.
1 minute. 2510,
2023, petitioner present, press time,
respondent absent.
respondent absent.
So,
Press time same by.
then on
Then
1711,
same by, because
1711, what happened?
petitioner respondent absent, both are absent, press time
Press
same.
time. So, fact remains is you are not present on the day. Then 12-12-23,
The PO is on leave.
PO is only. Then 21-12.
Both are
So
absent.
you are absent on that day also.
Both are absent.
No, we are not concerned with both. We are only concerned with you.
Okay, exactly.
Yes, 23-1.
23 and also.
That also, that day also you are absent.
Yes, exactly.
Then
on 24/4, last day of vacation.
petitioner present, respondent absent.
Respondent absent.
That is on 24/4/24.
On that day, she was appeared. She was.
Then on that next.
On that day, she was entered into witness box.
Petitioner is present, respondent is absent. Petitioner entered the witness box and filed her affidavit. So and so, respondent placed ex parte. You were set ex parte on, what is the date? 26/4/2014.
24/4/2024.
24.
Yes,
So how much time you want from the court? How many times?
Because there is
1, 2, 3, 4, 5, 6. Continuously from the month of September till the month of April next year, you were continuously absent.
Because due to this, there is settlement taxes going on.
So they are appearing before the court. Then when this order is passed on 26.
Very next day, kindly see the order sheet, my lord. On 35/2024, petitioner is present, respondent is absent. Petitioner
I am asking
no
you,
representation of the council for respondent.
the council, what did you do with this order? On when 26/4/2024, when order is passed, why did you not question it? Why did you not file an application to set aside that order?
Because the thing was, she was telling that the settlement is going on because there is another criminal case is lodged against the respondent.
Then be with that. Let it be settled.
Because,
So with all these apprehensions, years of delay will not be condoned. It is not a matter of course. I do not find not even one simple reason.
Kindly see the order sheet, operative portion of.
I've seen it. You have no right to question this because you have not, you kept quiet for 1 year. Now they must have filed execution.
Because no, my lord, the order was passed within the span of 10 months, my lord, after filing of the.
According to you, any duration is fixed for the Family Courts Act?
No, my lord. No, my lord.
Now I am passing order.
Kindly see the page, paragraph 13 of
within
the.
1 month they have to dispose of the order. Your court has given you a very long rope of 9 months.
Kindly see the operative.
I've seen. Nothing to interfere.
Because I have appeared, even though the court has said they have placed ex parte on 24/4/2024, my lord. Since the respondent is placed ex parte, cross-examination of the petitioner is taken, PW is taken as nil. And posted the.
Mr. Counsel, you are not answering one simple question of the court. Court had set you ex parte on 24/4/2024.
Though I have appeared, my lord.
Yes. So what did you do? What did you do against that order?
Because I have not.
Where are we now? When did you file the writ petition? This is filed on 24/1/2025. And when did this matter come up before the court?
On
It
31st.
will come first time before the court on 18/7/2025. What are you doing till 18/7/2025?
No, my lord, 31/1/2025, the matter was listed, my lord, and the stay was granted by the central court.
31/1/2025. 31/1/2025.
The respondent was not appeared, my lord.
Yes.
The respondent was not appeared, my
They
lord.
might have not. And I do not find one single reason why the order needs to be set aside.
Because I have not provided an opportunity to contest the matter, my
Of
lord.
course, you have been provided 10 times. 10 times, 9 months.
No, my lord, only within the span of 10 months, the order was disposed of, petition was disposed of, my lord.
What is the
Because the
submission, Mr. Counsel? What do you think that the matter has, how many months time you should be given? You can't be. Court has to dispose of all these IAs within 1 month.
My lord, this is the final order, my lord. This is final order I am challenging, my lord. The petition was filed on 4/8/2023 before the trial court, and the petition was done 10/6/2024.
What to do? 9 months time is elapsed. You don't file your statement of.
Because the settlement tax is going on, my lord, so that we cannot able to file objections.
That you can't tell the court. That you can't come to the court. Court has to assume it. I'm sorry.
My lord, kindly see the operative portion, my lord, because she was not filed the any kind of piece of evidence, my lord.
That the person who,
because
when there are lapses on your part, you cannot question all that. We are on the main ground on your ex parte order.
Yes, my lord. because there is a criminal case also lodged by the petitioner.
Let it be. Let litigants not think that they can take their sweet time and whenever they come to the appellate court, court will grant orders liberally. Yes, please come.
Madam, can you kindly see the operative portion, para 13,
Yes.
Madam.
Para?
13 of the order.
Yes.
Though the respondent appeared, but he has not filed the objection statement to the main petition, Madam. And at
All the time you're talking about the respondent, why are you not talking about yourself? You should first of all show what is right on your part and why you have not come and why are you concerned about what is wrong with her. Where is this section 5? And where is the condone delay petition?
it was allowed by the Honorable Court, Madam.
Huh?
It was
Where
allowed.
is that? Where, what did you say? Where is that IA number? Yes.
Not kindly come to page number 9 of the impugned order, Madam. Page 22.
Not impugned order. You have come to the court with a delay. RPFC is filed with a delay.
Yes, Madam. It was
Where is the section 5 petition?
Section 5 petition was allowed on 18/7/2025, Madam. By the
Where is that?
IA was IA number 2 but
How
1
many
but
days
25,
delay?
Madam. Yes, Madam. 135 days delay, Madam.
Is condoned.
Yes, Madam.
Yes.
Kindly provide me opportunity and kindly fix the time, Madam, so that I can produce the how she voluntarily left the house and she was filing this petition, Madam.
Even if she voluntarily left also, she is entitled for maintenance.
She voluntarily deserted the marital life, Madam, so that the in the proceedings before the family court in Dharwad also she was not appearing, Madam.
This is not a matter of written procedure. I am not convinced.
But kindly grant at least 4 months time to approach before the trial court and take disposal, my lord, and merits, my lord.
You 4 months time to approach the court.
No, my lord, to dispose the matter with liberty.
What happened to 9 months that was given?
But because due to the miscommunication, due to the settlement talks going on, it was may happen, my lord. I am seeking the only 4 months time, my lord, to dispose the matter on merits, my lord, because I will file my objections and I will contest the matter on merits, my lord.
303 of 2023 dated 10 June 2024, whereby the court had granted maintenance of an amount of rupees 7,000 per month to the first petitioner and 3,000 per month to the first petitioner 7,000, second petitioner 3,000 per month. The husband is before this court. Learned counsel appearing for the petitioner, husband submits that the court has not given enough opportunity to him and court had dismissed the court had set him ex parte, though he has appeared and passed this order. It is submitted that he has appeared before the court on 2/9/2023 and sought time for engaging an advocate. And finally, when the matter came up on 26/4/2024, after 9 months, the court had, though he appeared, court had set ex parte and passed this order. It is submitted that the court has passed an order within 9 months from the date of appearance and without giving a reasonable opportunity, court had passed the order. It is submitted that court ought to have given a reasonable opportunity. He has not appeared before the court for the 9 months as the compromise talks are going on. It is also submitted that no documents are filed on behalf of the respondent and there was no justification on the part of the court in setting the petitioner ex parte and passing an ex parte order and granting the maintenance. Learned counsel submits that a reasonable opportunity may be given to the petitioner, the order may be set aside, matter may be remanded back to the court and remanded back to the court, giving so that a reasonable order can be passed. Next para, though notice is served and the respondent, there is no appearance on behalf of the respondent. Next para, having heard the counsel petitioner peruse the entire material on record. When the petitioner husband has entered appearance on 29/20/23, the matter came up on 5/10/23, 25/10/2023, 17/11/2023, 21/12/2024, 23/1/2024, and 24/4/2024, and finally on 26/4/2024, the court had has said the petitioner, his husband, ex parte. The reasons that are stated for not filing the reasons that are stated for not filing the statement of objections before the court is that compromise talks are going on. This submission of the learned counsel for the petitioner, this court is not able to appreciate. Just because if the matter is being settled between the parties, there wouldn't have been a representation on behalf of the wife also. And after the order is passed in the month of June 2024, he comes up before this court in the month of January 2025. When he was set ex parte, even that ex parte order was not questioned by him at the earliest. All these shows the conduct of the litigant, who was not vigilant in prosecuting the matter. Court shall never come to the rescue of a litigant who is not vigilant. When the petitioner has taken the process of law for granted, and now without a valid reason, he comes before this court and seeks to set aside this order. In this routine manner, if the orders are set aside, if the orders passed by the family courts are set aside, there is no sanctity to the orders, and it becomes a matter of procedure. Hence, this court do not find any reasons to set aside the order passed by the family court, wherein the petitioner was set ex parte, as there are no bona fides on his part. Accordingly, the writ petition is dismissed.
Cell number 14, Mahadeva Swami P for petitioner, K.L. Srinivas.
This case appear for petitioner, my lord.
Yes.
The 125 proceedings filed by the wife, my lord. The trial court has dismissed the petitioner.
Respondent. Counsel for the petitioner is present. No representation for the respondent. List this matter tomorrow as part heard. If tomorrow also, if there is no representation on behalf of the respondent, orders will be passed based on the material on record.
Cell number 15, Devraj Jason for petitioner.
No representation. List this matter in the month of October.
For final hearing, cell number 16.
For petition. Second matter, my lord, copy has not been
Respondent, kindly permit me to appear online, my lord.
But you have to serve papers on the other side.
Earlier also, my lord, this honorable court has instructed to serve the copy to
It's
the
an
petitioner.
RPFC of 2024. Till now, you don't even serve the papers on the counsel for the respondent.
But I'm extremely, my lord, I apologize, my lord. I will be doing it right away. Today itself, I'll do it, my lord. Kindly have it next week.
Yes, list on some other day. You appear in which case?
In first matter, my lord, I am
You are the petitioner or respondent?
petitioner.
In RPFC number 183 of 2024, then counsel for the petition shall serve the copy of the appeal, a copy of the petition on the counsel for the respondent. List this matter. Next week, give a date when the basing on the matter.
19,
Yes, next.
Please, my lord, please. I go back.
Yes.
List number 2, parted matter, cell number 1, Suma for petitioner.
Do that.
Krishna S. Vas.
My lord, for petitioner, kindly pose the matter for 12th, my lord, Friday.
So
as
counsel for the respondent that he'll come up with an affidavit as per the order passed by this court dated. There is no there is inconvenience to learn counsel for the petitioner. How many times the inconvenience will
my
be?
lord, senior is not well, my lord. Maybe posted to 12th, my lord, Friday. This Friday.
Delete from Parcher. List this matter in the month of November. There is no representation on behalf of the respondent. Counsel for the petitioner seeks time. Yes.
Cell number 2 for dismissal.
I'm appealing for respondent, my lord.
Out of country, my lord, in America, my lord. 2 weeks time, my lord. My lord.
In the
we
forenoon
have
session, the matter was dismissed for non-prosecution. As there was no representation on behalf
I mean,
of
we
the
have
petitioner.
filed a year for the
Respondent has made a mention at the time the court is raising in the afternoon session that an amount of rupees 10,000 rupees,
1 lakh, madam.
1 lakh is lying.
1 lakh is
The
deposit,
arrears
my
is
lord.
3 lakhs more arrears is there in
Lord,
this.
28, 1, 2 and 25.
10 rupees they have mentioned. So by mistake, the clerical mistake, the 10 rupees has mentioned in the last order sheet.
Correct it in some brains should be used.
Lordship, there is a 3 lakhs for years amount has to be
My lord,
deposited
1
by
lakh is
the,
deposited, my lord.
Is there, he's submitting, please listen,
Hello.
have some patience to listen to what he says. Yes.
3 lakhs more has to deposit to the court, my lordship. They have to deposit only 1 lakh.
Where is the order?
Order.
Learned counsel for the petitioner
My lord,
undertakes
page
to
number.
pay entire arrears of maintenance within a period of 4 weeks.
1 lakh may be withdrawn, my lordship.
Yes.
Objection to be filed, my lord.
What objection?
Here to be 992 copy serve, my lord. Senior is out of country, my lord. 2 weeks time, objection to be filed.
No objections. You don't tell them what they have
My lord,
to do.
senior not in station, my lord. Senior is out of country, my lord.
Counsel
America, my lord.
respondent submits, as per the order passed by this court, an amount of rupees.
1 lakh.
1 lakh.
How much has to be deposited?
No idea.
Sir, how much?
I have no idea. I need to seek with the.
Just now you said 3 lakhs and all.
No, more than 3 lakhs. He said that advocate on record is.
Submitted that.
My
An
lord.
amount more than 3 lakhs.
My lord, interim maintenance per month 20,000, my lord. Yes, order 224 order, my lord. 1 lakh is deposited, my lord.
When we agree that 1 lakh is deposited, the thing is remaining amount arrears is
8,
there
1,
to
2 and
deposit.
25 is
That we
deposited,
have to get it, my lordship. That's what.
What is the order? Please look at the order. When is the order passed? At least before coming to the court, even for asking adjournment, at least one has to open the file and see what is the order, what is happening. When is the order? What is the date of impugnement order? Please come to the order. Neither of you come to the court and simply say whatever you want to say without even looking at the
My
file.
lord, I am senior.
Then don't have to so aggressively. Don't have to shout if you are not no. If you do not know the
Sorry, my
facts
lord.
of the case.
Sorry.
This order is passed on 18th July 2024. What is criminal miscellaneous of 2024? Order says interim maintenance of 20,000 per month to the petitioner from the date of application till the disposal of the case. So he has to pay that amount from the date of application. When is the application filed? At least if you look at from the date of order, it is 18th July. We are on September. It would be around 2,80,000 from this date. Please come. This court has passed an order on 28/2025. 2025, directing the petitioner to pay the arrears of maintenance. According to the petitioner, an amount of rupees 1 lakh is deposited. According to the respondent, the arrears would be more than 3 lakhs. The counsel for the petitioner seeks time, saying that the counsel for the petitioner is out of country. Even when the matter came up on 28/2025, there was no representation. The matter was dismissed for non-prosecution. In the evening, when the court was raising, a mention is made that an amount of rupees 1 lakh is lying, and the same he wants to withdraw. Hence, the matter is listed today. Again, today also, the petitioner the counsel representing the petitioner submits that petitioner is out of country and seeks time. Hence, the petitioner respondent is permitted to withdraw 1 lakh amount that is deposited by the petitioner. As per the interim order, dated, as per the order dated 2012-2024, the arrears of maintenance shall be deposited within 2 weeks from today, or else the writ petition will be dismissed on that ground. This matter after 2 weeks.
That's right.
Cell number 3, products matter. Cell number 3. Read the case.
Appear for petitioner, my
Show
lords.
her.
My lord.
Megha,
Senior,
show her the-
senior is not keeping well, madam. My lordship, my lordship is not able to argue the matter, my lord. Next week, any date, my lordship.
My request,
Please.
my lord. There is an interim order passed based on the misrepresentation by
No,
the petitioner's counsel leading to passing of an interim order. You want 20 permit, just 5 minutes. I will demonstrate to your lordship that the judicial fraud played in obtaining an order at the cost of the respondent, where his lordship has stayed the payment of school fee, which I was supposed to pay in August for this boy, and maintenance. My lord, the order was passed. May I request lordship? The writ petition was filed on 1/7/2022. For 3 years.
Anyhow, because we
My-
cannot, one minute, he's asking for time.
Yes.
Even
I
after
have no
hearing,
objection.
no,
Interim order.
Next.
after hearing your arguments also, court has to again adjourn. So why should we waste the time now? We'll
Next.
give a short date.
Yes.
I request my lord.
Please,
As
my
on
lord.
today,
Next week, one more.
He says
No,
senior is
I will
not.
submit. No, the interim order is operating, my lord. Interim maintenance of 6
This
lakhs
is
is not
matter
paid.
on
At least, my lord, let
on
him pay the
22nd?
maintenance and half the amount.
22nd, or which date? 22nd. Yes, this is matter on 22nd at the request of land counsel for the petitioner.
But the
In
interim order need not be
in the
extended, my
causal
lord.
is-
Why, one submission, my lord.
Please.
Now the execution have filed second one, 51,000 is still doing that. That also stayed.
No,
Now, my lord, this interim order that was on, may submit your lordship. Only thing is, IA number 5, there was an appealing for.
To want the
Please.
court to pass an order.
I only request my lordship that let him at 50% what is due. In
There
case,
is a stay.
in case I.
There is a stay by this court. Why will this court? No, that means you want modification of the order. Without hearing him, how can I ask?
No, the reason given, my lord, I will not suspect that. He's maybe unwell. I very much sympathize on that part.
Yes, this is matter on that day. Yes, next matter.
22/9.
Yes.
Cell number 4.
And on that day, no further adjournments will be granted. In the cause list also, it should be mentioned that no further adjournments. Yes.
Cell number 4. Raghupati A.
I'm for the petitioner before the trial court, my lord.
Yes.
Filed a petition for restitution of conjugal rights.
Where is the interim order?
Order dated 22/10/24, my lord.
There is it.
Page number 20, my lord.
The petition is hereby directed to pay sum of 8,000
Yes, my lord.
and one time.
Without
mitigation
calling
of
the assets and liabilities of the both parties and without
Without
given.
calling means the court will come to your house
My lord,
and.
my lord, the respondent has to be filed their assets and liabilities with application under section 24 of the Hindu
Your-
Marriages Act.
You have not filed.
Yes, my lord, I am also not filed. I am ready to file, my lord.
With that.
My lord, I was filed the petition for restitution of conjugal rights, my lord. The notice was served to the respondent and they appeared and filed the application under section 24 of the Hindu Marriages
Yes.
Act. At that time, my lord, the matter was posted for mediation. 3-4 settings, the mediation was
First
filed
of
and
all,
returned back
forget
to the
about all
court. my lord.
this, forget about all this. Tell the court, what is your income?
My lord, I am working as a farmer land. I am getting for a day 400 rupees. Respondent is working in Western company. She is getting salary of rupees 25,000, my lord. That is the reason I was challenging that
Where
order.
is the document to say that she's earning
My
25,000?
lord,
Place before this court, I'll pass order. Place before this court.
seeking the time, my lord. I will-
This is matter next week. By the time, whatever of the document that the petitioner is relying on shall be placed before this court, or else the writ petition shall be dismissed.
17.
Yes. Next.
Cell number 5. Monica Patil. Cell number 5.
Your Lordship, I'm hearing for the respondent.
Your Lordship had asked us to file a fresh memo for retirement with acknowledgement, Your Lordship. Your Lordship, we are trying to communicate with the client. She's not receiving our call.
Then that means if your client.
I
is
have
not
filed
coming-
my memo where we have.
That's not the way to file a retirement memo.
No, Your
We
Lordship,
have
I
to
have filed the
consider-
WhatsApp communication which she has not replied to us.
Take that.
We have called her several times. He's not receiving our call, Your Lordship.
When it comes to the petitioner, has filed a retirement memo stating that the client has taken away all the papers and they have issued an objection. Then this court has insisted that it should be in a proper form and they should file the necessary documents to show that the papers are given to her, the same are acknowledged by that the same is served on the party. Today, by way of a memo, the WhatsApp communication is placed before the court, where they have informed to the party about the matter being listed before the court and for filing a memo for retirement. And in spite of the same, what are the dates on 20? This WhatsApp communication is on 29th August.
And
wherein
yesterday, Your Lordship.
and also yesterday communicating that this matter is listed. The considering this, the petitioner is permitted to, counsel is permitted to retire from the case unless the registry is directed to print the name of the party, list the matter tomorrow. Yes.
Cell number 6, Nagesh Vinay, yes, for petitioner. Cell number 6, yeah,
May I please, Your Lordship?
Sudarshan.
Respondent party in person has filed recalling IA to reopen the case, my lord. It was disposed of on 26/6/2025. Matter was heard at length, my lord. The respondent was represented by advocate, my lord. Matter was heard at length. Now he has filed IA for recalling, my lord.
My lordship, regarding the visitation, I had given clear instructions to my previous counsel to ask for increased visitation and also for more frequent one, because we were already having more frequent visitation every alternate day between the,
Why, how an order can be recalled? An order that's passed by the court, how it can be recalled or reviewed?
my lordship, it can be reviewed, my lordship, and I'm asking for a record only for the limited purpose of the visitation part, my lordship. And I understand that it may not be the technicalities may not be there, but in child custody cases, the paramount interest is of the welfare. That is one thing, my lordship.
Paramount consideration of the child is one thing. In every case, you represent by an advocate, then the party comes to the court and says that because the child custody or the child welfare is paramount, every order to be reviewed, it can't be.
No, my lordship. That is why, my lordship, in my interim application, I'm attaching
Why
all
do you think that your client has not urged, your advocate has not urged all those grounds?
My lordship, you yourself asked the previous counsel, do you want more visitation, my lordship? And she said no. This is what happened on 26/6/2025, my
You were
lordship.
there in the court.
I was there, my lordship, but as I couldn't participate as I had a counsel, my lordship. And
instead of coming today, that time you should have come to your advocate and told him.
I kept telling, my lordship, I kept telling, but they somehow missed it, my lordship. Like I did the best effort.
Order.
My lordship, the order is, my lordship, it says my visitation is.
This order.
Order. I have not attached it to the IA, my lordship.
Order. They're seeking review of the order. Where is that order? What is the visitation he has sought for?
My lordship, if I may be permitted to answer this, in the family code, I asked for visitation daily between 2 to 8 p.m. and weekend overnights, my lordship.
How is it possible?
My lordship, let me explain, my lordship. My son was separated from me when he was only 10 months old, my lordship. Okay, now he is 3 years old. As soon as he was separated from me, I filed for this custody petition. And through the understanding between me and my wife, I have had continuous visitation for the 2 years, my lordship. So there is sufficient connection between me and my son. He has been coming to my home, my lordship. Okay. And
What is the distance between both the houses?
it's 5 minutes, my lordship, like 700, 800 meters only, my lordship. We live very, I shifted myself from my home. I've taken a rented accommodation so that I could live closer to my son.
What do you do?
My lordship, I work as a scientist, my lordship, in a company.
What are you working on?
My lordship, I have flexible working hours, my lordship, and I work for a South Korean company. So when it is 9 a.m. in South Korea, it will be 6 a.m. for us. So we usually finish our work by 1 p.m., my lordship. And afternoon,
What the wife do?
my lordship, she is at home, my lordship.
She's a housewife.
Housewife, my lordship.
Get instructions in this.
Okay.
Get instructions on what he is submitting.
My lord, the matter was heard at length, my lord. In fact, the arguing counsel has addressed our arguments at length, my lord. As far as review is concerned, I have caten of judgments, my lord. As far as review is concerned, once the matter is disposed of, it cannot be permitted once again addressing the arguments on same issue, my lord.
You will consider all that. Get your instructions on the maintainability. You can advance your arguments.
Please.
I'll address on the. I'll deal with that. That's not an issue. Please get instructions. Wife, even on that day also, no. It is wife has no objection for the husband to have the access to the son.
No,
Both of them, just listen to the point. Both of them are staying in a very within the close proximity. No, she stays at home. No, there is no difficulty. He says he'll come and pick up and drop him back within what if not 2 to 8 some other time without these video calls. Because they're staying it and the boy is too small, so you cannot say that the boy is not interested and all will not come up because of his age. Because even it's not possible for the mother to train him also to say against anything against the father. So please get instructions with regard to what would be the convenient time, so that every mother and parent, father should have a balance in all the things.
Please, paramount
So get
interest of the-
instructions,
Please.
and you can address your arguments on the review. I'll pass orders.
Please.
When can you get instructions?
3 or 4. Probably Friday, madam.
Friday may not be possible. We'll have it on Tuesday.
Tuesday, some inconvenience.
Wednesday,
Thursday, madam. 17.
Thursday.
My lordship, if Saturday or something is possible, we can. This Saturday is
Court has to be there for Saturday for you.
Okay.
Yes. This is matter on Thursday. Next
Much
Thursday.
obliged, lordship.
Yes, next Thursday.
Serial number 7, hearing on interlocutory applications. Arun
My lord,
Gopal.
I appear for the petitioner.
Sumana Abi.
Yes.
23rd of August, my lord had directed the respondent to pay the school fee, to reimburse the school fee paid by the mother and to report to the court. My learned friend sought time to seek instructions.
May I submit?
Yes.
Please, Lord. On the last date of occasion, Lord, Lordship suggested, Lord, posed a question: what efforts the father has done to build a good relation with the daughter? Lord, I may be permitted to.
Order.
Please, my Lord.
What about the order he's referring to?
There's no order.
No, he's saying that. But where is that order?
On 23rd, Your Lordship, my lord, this is what I've submitted on the last occasion when the matter came up, 23rd of August. My lord, but the order sheet only reflects only one line. I have the video recording of the entire order dictated by my lord.
Yes, where is that?
2:30, I will place it on record, my lord, at 2:30. Very unfair now on the learned friend's part to say there's no such order.
But that, my Lord, may I make one submission?
I have asked them to look at the video recording that day. What they were saying is, I asked them to struck off that order and just adjourn the matter. That's what asked for the video recording.
There is no order, Lord. On the last occasion, Lordship only asked me.
No.
Asked me to
What
furnish.
happened? I asked my office to verify that. They say they've looked at the video recording and they say initially the court has dictated. Then after that, they said struck all that, just struck off all that, just adjourn the matter to so and so.
Yes, Lord.
That's why it does
But Your
not.
Lordship, Yes,
And
but
orally,
my
my
lord,
lord,
directly, my lord said, my
posed
lord
me a
said took
question
time
was
not to find out.
what effort the respondent has put to
No,
build a
whatever.
good relation
No,
with the
if-
daughter.
if
But
you
I may be
believe-
permitted to
One
place the
minute.
material before your lordship.
If you believe that the court has passed such an order, whatever that day that is transferred in the court, you can place it in the afternoon. I'll look at it.
Yes, yes,
Not
but your lordship referred to his
May I make
Krishna
one
Judge's order
request?
earlier, which said the father will be on pain of arrest, he will have to pay the school fee, and directed my learned friend Manoj to instruct his client to pay the school fee. My learned friend sought time to, he said he's paying the school fee. I will
No,
find out from him
as
whether he's
far as,
paying.
as far as that order not being
false submission,
reflected
no,
or
Yes.
not being uploaded, for that they have verified the video
Understood.
recording.
Yes.
They say that it is, the court said, no, not all that, you struck it off, just
Yeah.
adjourn the matter. That's why they have
Very
not, that order has
Very-
not come.
But,
We'll hear the matter now. Or
May-
you
may I
want to
make-
come in person in
At
the
2:30,
afternoon?
I'm sorry, Lord, if your lordship permits me to come at 2:30, I'll come and argue at 2:30.
Because 2:30 there is another list, we'll take it up at 3:30.
Please.
3:30. Very good.
3:30.
And may I make one submission?
Till
And
number
may I
8.
make request before your lordships? There is no interim maintenance order. There is no maintenance order so far. Lord. Directly, my lord, they are claiming here. If the prayer is seen, my lord, only in respect of visitation rights, my lord, which is passed in the year 2021, Lord. Till today, my lord, so no, the
No, that's the
petitioner is not
reason.
at all allowing the
That's a
father.
reason, that's a reason why even this court is asking the courts to dispose of both the matters for the reason.
Please.
Now, if the father fails to take care of the child on a monetary aspect.
It has to be taken jointly, my lord.
No,
But there is
that
also a working
true.
lady.
But you also have a responsibility towards
Yes,
the
my
child.
lord, so far, my lord, I have paid. Lord,
You have
this, Lord, that the order is also recorded in the order sheet itself.
What are you paying
That
from?
last year it was paid. Lord, this year I have not paid because my father is suffering from a serious ailment.
Yes, I'll hear it in
Please,
the
Lord,
afternoon.
let-
Yes, next.
Cell number 8
3:30.
adjourned.
Obliged.
Cell number 9. JNTR for petitioner.
Appealing for petitioner, Your Lordship. I seek an apology for not taking hand summons due to inconvenience, Your Lordship. Tomorrow there is a regular date before trial court. I'll take hand summons and I'll serve it to local advocate of respondent tomorrow, Your
What is
Lordship.
that? Not taking of hand summons with the council, report of concerned principal, senior civil judge, Srirangapatna. Now, who passed impugned order? Excuse me? What is that? And then this is the repeated action to the Have you complied? Are you complying with the interim order?
Your Lordship, the trial court date is posted for tomorrow. So we are going, I have received the copy of interim order yesterday, Your Lordship,
When is the order passed?
on 18/8/2025, Your Lordship.
Why 18/8 order will be received yesterday? Ask the Registrar Judicial, when this order copy has reached the section, the signed order, and why is it taking till when the order is passed, everything goes from the chamber, a day or the next day? Even for interim orders also, why should it take this much time? I can understand the final order. It would be uploaded.
Your
It
Lordship,
will be uploaded. Order copy will be uploaded on the same day,
Please, Your
immediately after
Lordship.
it is signed.
But to advance the matter before trial court, we had to have certified copies, Your Lordship. Hence, it was delayed. Yesterday, on 8th, it got ready, Your Lordship.
That
Yesterday, I
also
have
should be
received and sent.
difficult. Why they want a certificate copy when everything is available on net? It is not that you have to file an application. If it is for questioning an order, you want a certified copy. To bring it to the notice of the court from the High Court website, would it be sufficient? They'll not accept.
Your Lordship, the regular date was on last month, it was on 13th, and this month it is posted for tomorrow, Your Lordship.
18/8/2025 is the order. My question is why the certified copy of the order is given yesterday? Ask the extrajudicial. Give that. Give that. When they have applied, when it is got. Give that.
Applied on 20th, your lordship.
18th is the order, 20th they have applied. The file is received from the pending side on 28/20/25 3:30 p.m. Order is on 18th. By 20th it is sent. Find out from her why is it taking this much of time. And why have you not taken hand summons? I said if you have not taken hand summons, the stay granted by this court stands
Your
vacated.
lordship, I was miscommunicated that.
No miscommunication. When you take
I
an
thought
order, interim order,
it has to be.
why I specifically passed that order is, I've been observing that in this court, matters, orders or stays granted in 2020 till 2025. Either you pay the process or you will serve the copy on the hand summons on the other
Your
side.
lordship,
No
I have
notice. It
paid
will
the
be pending
process,
for
your
5 years.
lordship. In this case, I have paid the
Process
process.
will take time. That's the reason why I say hand summons. You should have used by this time. You should have taken. I also it's very clear in the order. When you have taken the order copy, you know that.
Yesterday, I read the order copy, your lordship, and then I came to know that we have to have taken the hand summons.
What happened to the emergent notice? Yes, as per in spite of an order passed by this court, the petitioner has failed to take out hand summons on the counsel appearing for the respondent. List this matter on Tuesday. By that time, hand summons shall be served and a memo shall be filed before this court, or else the stay will be granted without any further reference to the stay will be vacated on the day and no further arguments will be considered. Yes.
Cell number
Grateful, your
10,
lordship.
hearing on preliminary hearing, VP Sidramaya, for petitioner, SV Prakash.
Respondent. The petitioner has filed petition for restoration of conjugal rights. Respondent has filed an IA for interim maintenance. 7,000 and 5,000 amount has been ordered by the.
Please come to the order.
That my submission is in similar miscellaneous number 107 of 2018 also, they have obtained the maintenance amount.
How much?
Well, 7,500, the very same amount my lord will get at page number 49.
Paying that?
Please, madam.
Are you paying that?
I think he has not paid.
No, my lord.
So how does it matter?
In both the cases, so.
Because it is filed, you will file appeal against this, and you will not pay that. What is already there is an order. So it is as if it's an honest in the eye of law, that order.
My lord, he is suffering from 75% of disability. I have produced the disability status also. He is fell down and
Have you
sustained
questioned that
fracture of
order
hip.
where 7,500 is granted?
Let my lord, the order passed in this specific restoration of conjugal rights petition may kindly be set aside. Let the execution be filed in semis. Let it be executed.
My lord, in
75%
total-
disability, I have produced the
You
certificate
can't
also.
have two maintenance, one from here, MC, one in criminal miscellaneous. How much money you?
In total, it is only for only 24,000, my lords. In that, 10,000 is for child. 9-year-old child is there, my lord.
What is his income?
He is getting income from house rent, my lords.
How
Kindly
much is
peruse
getting?
page number.
How much is getting?
Kindly peruse page number 45, my lords.
A disabled person with 75% disability.
But he has 3-storied building and ancestral property also, my lords.
How much is getting? What is placed before the court?
In the criminal miscellaneous, he admits he has.
Has the court taken note of what was granted earlier?
Hello?
Has the court taken note of the earlier maintenance that is granted? granted?
No. That has been suppressed. Subsequently, the criminal miscellaneous order has been passed, my lords.
No, have you disclosed that order?
Please, in the impugned order, we have disclosed that, my lords. Kindly peruse page number 24, my lords.
20?
It's 24, it's recorded. Para number 3, my lords. No doubt, the respondent had initiated proceedings in criminal miscellaneous number 107 of 2018 seeking maintenance.
So, the basis for granting this is no amount is awarded in that.
Please,
So, it is awarded.
please.
It's for you either to set aside this order or that order.
But there is no bar to grant maintenance in two
You
proceedings.
have to look at the financial capacity of the husband.
Please,
Or else I will set aside this order.
kindly
and
peruse
remand-
page number 45, my lords. He himself admits.
I will remand it to the court.
Kindly peruse page number 45, my lords. Para number 17, my lords.
Yes.
May I read? Further, respondent in his cross-examination has admitted that the property standing in the name of his father is transferred to the name of his mother after the demise of his father.
Which place it is?
Please.
This building is situated in which city?
It is in, my lords. Which para you are reading? 17. In Tumkur itself, my lords.
ಇಲ್ಲ ನಮಗೆ ಅದು ತುಮಕೂರು belongs to this wife respondent, that is her property.
Kindly peruse para number
All
14,
Tumkur
my lords.
properties are belongs to wife respondent.
3 houses or
Ninth line, my lords.
3 houses are let out for 2,000 per month.
It can't be believed, my lords.
If you want the court to believe something else, you have to place the document.
My lords, it is 3-storied building. It can't be leased out for 2,000, my lords. And then in para number 20, he admits.
Let us assume 3-story building. What is the extent of it? How much square feet each floor is?
And my instruction is that he is doing work from home job also. In para number 20, he admits that he has ancestral property also, my
from
lords.
that, it says about an able-bodied person. He is suffering with 70% disability.
The injury they have stated is not caused any disability, my lord. It is their case itself.
He has filed a certificate, he is saying, disability certificate. Where is that?
Issued by the district medical board.
Where do you get that?
That I have produced along with memo dated
Look at
14.
it. Have you given him the copy of the memo?
No, my lords, they have not served the copy.
I have produced the copy 14/7/2025.
Give it to him. You also should have an opportunity.
No, my lords, they have not served the copy.
Now also I am,
Kindly peruse
Department of
that.
Empowerment of Persons with Disabilities.
now also I am giving one more copy. It be recalled.
Kindly peruse, just 1 second, my lords. Kindly peruse their petition, my lords. In the ground number 15, my lords.
What is it?
They stated that he has only 47 guntas of land in Rangenahalli. But in the criminal miscellaneous cross-examination, he admits that he has a building which is.
He never said he. He said that building belongs to his father. After his demise, it is given to his mother.
Both are. Then they stated that he has to take care of his mother also. Then both are staying in one roof only, my lords.
In these circumstances, if you want, we'll confirm one order, but not two. Get instructions from your client.
Get instructions.
This is matter as part of tomorrow.
Please.
Serial number 11. Zara move.
Give that.
Serial number 11.
On 22/7/2025, when this matter came up before this court, there is no representation. Again, on 29/7/2025, at the request of Land Counsel, the petition, this matter was directed to be listed on 6/8/2025. Again, on 6/8/2025, there is no representation. Today also, there is no representation on behalf of the petitioner. This is matter for dismissal tomorrow.
Serial number 12. Fatima SK for petitioner.
It may be
Savaraj.
passed over, my lords.
Pass over.
Serial number 13. 13 disposed. 14 Ananda N.
Yes,
Lord, I'm challenging the order dated 9/10/2024, my
page
lord.
number.
Page number. Annexure A, page number 13, my lord.
1-3.
Yes, my lord.
What is the amount granted?
My lord, the trial court has been paused 25,000 as interim maintenance, my lord.
20?
25,000. I'm getting a salary of 76,000, my lord.
How much?
76,000.
And court had granted?
25,000 per month maintenance.
That is 10 and 15.
Yes, my lord. My lord, along with this, my lord, the MMTC magistrate court also granted 20,000 as interim maintenance, my lord.
Have you paid that?
No, my lord. Before this 25,000, the same trial court has been passed 15,000 maintenance order. For that, I have been challenged before this honorable court filing WP writ petition, and this honorable court has been remained back the matter to consider as fresh.
So as of now, there is no order.
No, madam.
Yes, that's the only order is this.
Yes,
When
madam.
Your salary is 75,000.
Yes, madam.
Children and wife and the child.
Yes, my lord. Moreover, my lord, she is also working lady, my lord.
1 minute. What is her earning?
She is getting more than 35,000 salary.
Was it established before the court?
Before the trial court, she has been established in the meet.
He filed a statement of assets.
Yes, my lord.
Has she
Yes,
stated that
yes, my lord.
she's earning
And as she recently she is stating that she has been resigned from the job. She filed a memo.
Pay 18,000.
My lord.
Pay 18,000.
My lord, 18,000 also it will be.
It's only 25%
My
of your salary.
lord, I'm also I need to pay EMI also for the flat, which is registered in joint name.
How much you're paying?
20,000, 21,000, my lord.
So you're left with 50,000.
Yes,
54,000.
Yes, my lord. And also I need to take care of my old age parents also, my lord.
Everybody has to do it.
Yes, my lord.
Yes, 14,000. Please come. When counsel for the petitioner submits that the court has granted 25,000 as maintenance to the wife, and his salary is 75,000. He has to pay the EMI of 21,000. Which is the property which is standing the joint name of the wife and the husband. The court has failed to consider any of these aspects and granted maintenance of 25,000, and the petitioner is not in a position to pay. Considering the same, they shall be stay of all further proceedings on the condition that the petitioner shall continue to pay 14,000 per month, that is 7,000 to the wife and 7,000 to the child, by 5th of every succeeding month, and the arrears also at the same within 8 weeks. Default on either of it, the stay granted by this court stands vacated, and the hand summons to the counsel appearing for the respondent and a memo to that effect shall be filed by 8th of October, or else the stay granted by this court stands vacated even on that ground. Yes, next.
Till number 15.
Bless me.
Dada R for petitioner.
It's a wife petition, my lord.
Seeking enhancement.
Seeking for enhancement.
Notice, same hand summons on the counsel to the respondent and to file a memo to that effect. Once a memo is filed, list the matter. Yes.
16 MC Ravi Kumar for petitioner.
No representation, list this matter in the month of October. Yes,
Cell
next.
number 17 urgent. Cell number 18 Nataraja BS.
For respondent, Lord,
Jairaj.
kindly press sign, my lord.
Why?
A senior is not there, my lord. Kindly have this matter for tomorrow, my lord.
Short question for consideration. Only I challenge the order of granting of litigation cost instead of one time they granted as a per month. There is order we are challenging for.
Tomorrow is part heard. Yes, next.
Cell number 19 Narasimha Prasad.
Appeal for the petitioner's counsel.
Yes.
My lord, here the main ground of attack is maintenance had been ordered. Main ground of attack is that she's worth crores of rupees. And after she left the matrimonial home, she has gifted crores of rupees worth property. entered into joint development got more than 20-25 crores. I've produced those documents. And in the assets and liabilities affidavit,
Produced before the trial court?
no, we did not realize that she was suppressing all this. She filed assets and liabilities. We found that considering her standard of living, how she was living, to what the assets and liabilities shown, there was complete suppression of all this. Then we located the documents. I filed under a memo dated 28/7/25.
Copy on him.
I've served. Memo kotilva. I'll serve a copy.
It is submitted that there are documents to show that the wife is having enough income and the same is suppressed before the court. The document shall be served on the counsel appearing to the respondent.
I'll serve it today itself.
And the counsel for the respondent shall file his objections, if any, to the same. List the matter in the month of October.
My lord, there's an interim order, my lord.
Interim order earlier granted is
As of this day, not even a rupee has been paid as an interim maintenance. Not even a rupee has been paid as an interim
Any
maintenance,
stay
right?
in this? Stays there?
Stays there.
Interim order, there is any?
25,000 they are supposed to pay from the date of application. Till today, they have not.
We will not grant, we will
No,
not
I
extend.
will pay whatever has to be paid. I'll deposit in court. I'll do it within 2 days.
Yes.
No, interim order.
As per the interim order passed by this court shall be complied with within 2 days from today, or else the stay granted.
Well, one submission, I'm instructed that the interim order has stayed that order of maintenance, my lord.
No.
Please, no, if it is there, I will see that it's paid, my lord. There's no.
Let's see.
From 1/4/2017, that is
One
from the
minute,
date of
1 minute.
application.
No order by this court to pay.
No order. As far as the trial court's order,
But
from
that
the-
order is stay.
not even rupee is being paid.
Anyhow, we'll hear it.
My lord, she is worth conservatively 250 crores.
Yes.
Say number 20, Ramchandra Nayak for petitioner.
The trial court, the matter is posted for judgment, Your Honor. On 22nd, it is posted for judgment.
Posted to 22nd.
Yes,
Give that.
for judgment. I could
Land
not-
counsel for the petition, no representation for the land counsel for the petitioner. Land counsel for the respondent is present. It is submitted that the matter is posted for judgment on 22nd September, considering the fact that already the matter is posted for judgment. Nothing survives for consideration in this petition, accordingly dismissed. Next, 21.
Cell number 21, Bindu U for petitioner.
Petitioner this
Keshav Kumar.
father's petition. In the GNWC proceedings, father had filed an application seeking change of the name of the daughter's name in the school records and other records, my lords, as per the birth certificate, my lords. In fact, there is a divorce as per the mutual consent between the parties in the year
No,
2007.
that cannot be done by this court. Why should we do it?
This is very much a matter you had the chamber conciliation.
I think
my lords.
I
Yes,
remember
yes.
this. You have a remedy. Every matter, everything under the sun, whatever the dispute, will not be decided with the family court. It has to be, there is a procedure for that. You have to, for change of name, there is a
No,
procedure.
it's not the entire change of name. As per the
Whatever
birth
it is,
certificate, my
whatever
lords.
it is, there is a procedure contemplated that you have to follow. The family court has no business to deal with all this.
No, if there is an entire change apart from the birth certificate, there is a separate procedure,
That
my
is
lords.
not within the
Here,
realm of
the
the
mother
family
respondent, she is the custodian mother, parent. She has to make an application to the
That
school
court
and
will
Aadhaar
decide.
card.
No, if the.
Only the
if
school
you're given-
records, only the school records and Aadhaar card we are compliant.
Say, even for that also, whatever is the remedy available to you under the other laws that you have to, family court cannot go into all those things. It
Direction
cannot
to the
direct-
respondent, my lord. So direction to the respondent to request her to the school, and she herself has the custodian parent to upgrade that Aadhaar. Also, there is a facility to
To
change,
change the
upgrade.
name in the school records, there is a procedure.
In the forms, they have to correct, they have to give the application as per the birth certificate. Annexure E, my lords, if your lordship look into annexure
That
E.
we
my
will
lord.
not, that we will not. Yes, next, what is the next matter?
Arising, this is a first petition, 1125, my lords. Arising out of IA number 3, 4 and 5, common order has been placed.
No. This change of name is IA number?
3, my lords.
IA number 3, yes. Next, come to next week petition, WP 10984.
11042, my lords, that is second petition, that
No,
is
that
the
is the third
direction to the
petition.
school, my lords.
to provide all details of the child's education details and PTM proceedings, everything. He should be made participate in the school.
That's
And
I
he
number
should be
4.
in the I number 5 also same direction to the school only. As per that, the school records has to be changed because he has approached the school. The
And I
fine.
number 3 is what?
I number 3 is direction to the respondent
Aadhaar.
to update the child's name as per the birth certificate, my lords.
So that is one.
And
I number 5 is?
I number 5 is seeking direction to school to update the school records in
To
with
have an
regard to the
access to
child's name, my lords,
To consider?
as per the birth certificate.
So IA number 3 and IA number 5 is all the more one and the
Yes,
same.
one is direction to the respondent. IA
One is
number
direction
3,
to the school.
IA number 5 is direction to the school, my lords.
These two
The
can't be
moment-
considered.
my
What
lords,
about the last IA?
that is IA number 4 in second petition 11042, my lords.
Father has every right to know what is happening.
My humble submission is this. All is deriving out of the settlement which they have derived with. It's a family settlement which took place out of the dissolution of marriage petition. Now, none of the things have changed from then to here. We are on, and they are in fact contesting the matter in GNWC. They filed the petition before the family court, which is pending consideration. They have adduced the evidence, we have cross-examined. We have adduced the evidence, they are supposed to cross-examine. This is a speaking order. My humble submission is this, that they're submitting, in fact, they filed one contempt petition against me where section 11 and 12 is not available, means I had to run through the entire the trial. They filed the execution petition against me for not giving.
Let me ask you one question.
Please.
About the last IA. Why
Please.
the father should not be part of the educational?
My lords, there is no restriction, my lords. He's not voluntarily participating.
Then we will give a direction.
No, I'm here to take no orders, my lords, with a great humility. My only submission is this: they're using.
What is that? I'm not able to understand. So you're not here to take any orders. What is that?
No, my lords, I don't want the petitioners to take any orders from any court. The simple reason is this, my lords. For schools, till now, the respondent herself, without having any source of income, has met up to about 8 lakh rupees for her educations. She is remarried. There is a deposition which is already marked in the evidence. He has moved on from life, but he's troubling the respondent. That's all his sole intention.
What is your contribution towards a
If
son's
your lordship
education?
look
As
into
of
the
today-
mediation- If your
What
lordship look into the mediation agreement, which is provided as
No,
part
not
of
the
their
mediation agreement. What is the contribution of the father?
Yes, my lords, para
Is he married?
3 of that mediation.
Is he married?
Yes, he's married in the year 2020, my lords. Still, he's taking care of whatever arrangements he has done so far with respect to the minor child. Your lordship will be convinced by looking into para 3 of the mediation agreement, which
It
is
is a-
furnished at the mediation settlement, page 10, para 3, my lords, of their objection, what they have filed.
Where are the objections filed by them? In which petition they have filed?
Common objection is available for your lordship's consideration.
Yes. Paragraph number?
Para 3 is about the visitation rights, what has been
Both the parties
granted to
state that they
the
have female
minor
child
child. Now, if your
residence.
lordship comes to para 4, the petitioner agrees to, the petitioner herein is the husband, father, my lords, agrees to pay some more rupees 5,000 towards full and final settlement of all claims with respect to arrears of maintenance and school fees of the minor child, which is incurred by the respondent mother by way of demand draft so-and-so, dated 3/7/2017, drawn on so-and-so in favor of the respondent.
Whether
The
he
said-
has complied with clause number 5?
Yes, yes.
Clause, my lords?
Clause number 5 at page number 11 of your objections.
No, this is ongoing. He's supposed to pay month or year on year, which he's stopped
Is
paying.
doing it or not?
No, 8 lakh rupees is arrears as of today. I'm speaking.
That
my lords.
is, they're
He's
talking
completely
about
stopped.
for the year 24-20. This agreement is of the year 2017. As per this, 5
Every
lakhs.
year
is-
you have to pay 1 lakh. How can arrears will come for 1 year, 8 lakhs?
My lords, your lordship, para 4, 5
If
lakh.
you want any order from this court with regard to that, I want you to clarify, your
Yes,
client
my
should get clear instructions, whether as per the settlement.
One by one, I'll take your lordship.
No, you come with instructions as per this memo, as per this settlement.
Yes,
From
madam.
the date of settlement till today, what are all the amounts
Till
he
the
has
year-
paid? What
yes,
are all
yes,
the
my
amounts he
lords.
has paid? How it is complied with? Please tell the
Till the
court,
year,
then we
yes,
will
I
see.
have the instruction, my lord. Till the year 2024, he has paid everything. And since they continue to violate with regard to the visitation rights, not sending
Where
the
is the
child.
which part of it deals with visitation?
Para 3, my lords. Both the parties state that.
Not happening.
No, my lords.
Yes, Mr. Counsel.
absolutely.
This is not happening.
Which
He's not giving,
Para 3.
father is not given visitation.
Lords, he is not coming. That's what is admitted in the cross-examination. Your Lordship also had the occasion of getting the child to the chamber to discussion. The child is being kept at home only to serve the purpose. It's not have. Lords, my question is this: in the cross-examination, it's covered. He's not bought one single thing apart from what is agreed here. Lords, the child also has requirements. The child has requirements for even I've asked questions specifically.
At least one.
Even birthday, the kid has not got what it's supposed to get. Lords, apart from agreement, he's only following that. As a father, as a biological father with love and affection, what he's supposed to do, none. He's admitted in the cross-examination. Lords, just to vent his frustration, he's taking the kid and putting it in the house where it does not have any attention. And that man is going on bike rides everywhere. He's admitted he's a passionate bike rider. The child is just sitting there and it is losing its patience. It does not have an attention. So one single penny is not paid. Moreover, why am I saying 8 lakh rupees? Your Lordship asked me. Lords, admission fees, school fees, all that he's supposed to take care from past 2 years is not paid. Now he's standing before this honorable court asking for directions. Lords, he should first show his bona fides to take care of the child, not exactly the agreement. Lords, every year it's not the same. It crosses.
By the next date of hearing, then counsel the petitioner husband shall file an affidavit before this court. As per the order passed, as per the settlement arrived on between the parties, whether he has complied with the said arrangement and made the payments or not. If made, how, when those payments are made, particulars of that shall be furnished. If the petitioner is adhering to the settlement and taking care of the maintenance of the child, then this court would consider the WP 1104/2023, where he wants to be included included in the school records with regard to the welfare, the progress and other educational activities of the child. When can you file?
17th, my lords.
Says list on 17th.
For the records, madam, I filed the execution petition for recovery of the 8 lakh rupees. Last year itself I filed it.
Yes.
Number 22.
Yes, 22.
Tejesh, N for petitioner, Veerabhadra Swamy.
No representation in the month of December.
Case number 23.
I appear for the respondent in this matter.
This petition filed against the order passed in interim order.
Seeking
passed in
enhancement or
family court, my lord.
by the husband.
Yes, my lord.
Where is the order, page number?
At page number 16, it starts, my lord. The reason is at page number 20. 21 is the first para of the reasoning that is given. Para 10. From 9 it starts, my lords. The reasoning and the order is at
16 to 25, my lord.
page number.
It's her petition, let her argue.
16 to 25, my lord. Impound order.
20,000 is awarded. And visiting rights on alternate day to Saturday at family court children visitation room is hereby directed to hand over the child in further orders. Family court. This is order is 35 2023. Huh.
Yes, ma'am.
So you're agreed by which order? Which part of the order?
Interim maintenance, sir.
The other visitation part you're not agreed.
Yeah, even that also, she has not at all showing the child also, my lord.
You can file
Even-
the contempt. Now please come to the order.
Yes,
What
madam.
what is your income?
99,000.
Then what is the difficulty in paying 20,000?
20,000 honorable court passed order.
That's what I'm saying.
Yes, yes,
What
my
is the
lord.
difficulty?
He has to take care his sick mother. And also, he is also not feeling well, my lord. He is having.
Court has perfectly, in fact, it's not even 25% of the salary court has granted. We can't interfere with this. Yes, please
No, my
come.
lord. Even told he is having operation also in First Hospital. He is having spinal cord problem. Even and his office also directed to resign the job. This is the condition.
Where is that? Once that condition that comes into existence, where in the change of circumstances, you can always file a petition seeking modification of the order. Right now, from here, we can't visualize that in times to come is going to be removed from service. Whenever he is removed from service, please go approach the court. That I will record.
At least 10,000 be reduced,
Not
my
at-
lord.
not at-
Is ready to
Agreed
pay.
with the award passed and agreed with the order passed in I number 3 in MC 2068 of 2021 and MC 4009 of 2021, dated 30th May 2023, whereby the court had granted 20,000 maintenance. There is no child.
The child is
Child
under
is-
the care and custody of the mother,
for the
respondent. my
filed by
lord.
the mother. Granted so and so to the wife, and also granted visitation rights to the father. Then counsel appearing for the petitioner husband submits that in everything parties are referred to as wife and husband. Then counsel appearing for the husband submits that the income of the husband is 99,000 and the court had granted 20,000. He is suffering with spinal cord issues and also has to take care of the old aged mother. The
Sick
amount
mother.
of
Sick mother.
a sick mother, the amount of maintenance that is awarded by the court is on the higher side, and the same needs to be reduced. In view of the
My
health
lord, she is
conditions-
working, my lord. Respondent also working. She is getting 40 plus 45,000 per
Where do
month.
you get that?
That is it. She only filed a bank statement, my
Let's see
lord.
how is it recorded by the court.
My lords,
Yes, my
my
lord.
submission with regard to this.
Assets
Your
and
lordship, come to
liabilities.
para number 20. That is recorded by the court rightly. my
There is
lords.
no para 20 in the
Sorry,
order.
page 20, para 9, my lords, point 1.
Yes.
It is recorded, my lords, that the respondent is earning, and my lords, the order of the court is this, my lords. At page number 24 is that IA number 3 filed by the respondent in MCE is hereby partly allowed. The petitioner is hereby directed to pay 20,000 per month to the respondent from the date of application. Here they have rightly mentioned that though taking consideration of the mother's income, the expenses of the child is also taken into consideration, my lords, because child is also suffering from seasonal conjunctives. So the child has some eye problem and the father is aware of that
It is
medical
submitted,
issue as well.
counsel
There
for
is
the-
a insurance, my lord. He is providing even both respondent and the child.
is submitted
Every month he is paying insurance.
that the wife. What is the age of the child?
My lords, is 4.5 years.
1.5 years.
So 20,000 because
Then
he
you'll
is.
reduce it to 15,000. Wife doesn't require any maintenance. The land council.
My lords, but my lords, the problem here is this, my lords.
We are ready.
The child has immune disorder also, that the father is aware of it. So
he's taking the policy and he's paying the
Yes.
medical
no, my
insurance.
lords, no, I've taken
Still
instruction
paying,
with
my
regard
lord.
to that, my lords. She says not even a single rupee is paid by the father, only 50,000 is paid till date and he's not taking care of anything, including the medical expenses of the child, my lords.
How much are the medical expenses of the child?
My lords, every month, my lords, she is almost till now, she spent about 8 lakhs together for the education and also the child's expenses, transport.
1.5 year, 2.5 year, what
It's
education?
not 2.5 years. He's in grade 2, my lords, 2B. So he's in second standard, he's studying in NPS. So no educational expenses has been borne by the father. And also medical expenses also not borne by the father.
Have you preferred any?
All of it is there in the.
Have you preferred any? Have you preferred any writ petition against impugned?
No, my lords, I have
So
not.
you're happy with whatever that's granted.
20,000, I'm happy with that order, my lords. That was the only submission.
What are the educational expenses of the child?
My lords, I have also submitted. My lords, education expenses per year is coming about 1.4 lakhs for the child. And also transportation expenses, plus he's also, they've joined him to all this music class, Olympiads. He's very, intelligent, my lords. So with this regard, all of it, the mother is taking care of. Mother is only telling with regard to the educational expenses as well as the health of the child.
The mother is earning 30,000 per month. And also.
Rent, she's taking care of, my lords.
30,000 and yes, she's taking care of the insurance policy. He has taken the insurance policy on the name of the mother and the child, and he has been paying the premium. Next, parallel counsel appearing to the respondent submits that the land counsel appearing for the respondent mother submits that the boy is in the second standard. His educational expenses and also medical expenses are borne by the mother. husband, the father has not taken care of the child. It is submitted that he is suffering with autoimmune disease, and for that he require a lot of amounts towards the treatment that was not taken care of by the father. It is submitted that though in spite of the fact that she's earning 30,000, she has to take care of herself and also take care of the expenses of the child. In those circumstances, the court had rightly considered and granted the maintenance, and there are no grounds to interfere. Next para, having heard the counsels on either side, there was a material on record. Undisputed facts are the father's income is 29,000, the mother's income is 30,000.
Mother income, 40 plus 5, my lord.
The court had recorded it.
In that it is, I brought assets, which she filed assets and liabilities.
My lords, court have recorded, my lords, 99,000 as on 2023. Now
No,
he is
no,
earning
that
more. We have not disputed that
Court
also.
is not considered
He is
because of
referring
that.
to she.
My lords?
She is referring to you, not to him.
Yes, my lords, 35. And the court has also recorded that I
Where is
am a
the
guest
35?
faculty, my lords.
Is here it is.
35,000 per month. The
30, my lord, 30, 40 plus 5, 45, it is there, my lord.
45,000 per month. 45,000.
And his insurance is there, yeah, medical expenses he is ready to bear. She is not
Ready to
received,
bear is
even
not paid.
certified copy produced before the honorable court, my lord.
Or else I'll do one thing, all the medical, don't pay any maintenance.
Yep, he is
All
ready
the-
to take.
All the medical expenses,
He
all
will
the
bear.
educational expenses of the child shall be borne by the father. No other maintenance required.
We are ready, my lord.
Get instructions.
We are ready, my lord. As a father, he has to take care of the child. He is fine.
Court has granted 20,000.
Yes, my lord.
It becomes 240 per annum. And she says educational expenses are how much?
1.4. That is 1,40,000 only for the fees, my lords.
Says medical expenses another.
And
Medical
transportation.
expenses.
I'll record that.
Insurance clear, no? Insurance
lord,
is
the
there.
Insurance will come provided he is hospitalized.
No,
not for
Yes, my
everything.
lords.
Insurance, that company only provides,
My
my lord.
submission.
Council, please understand, if you want to get instructions, fine, or else I'll record that. The council submits that entire educational medical expenses will be borne by the husband. Shall I record it?
He will change the school and he will give the.
How can it be? How can it be?
Different
Wherever
school.
she's studying,
Depends
wherever,
on
he is,
his,
wherever the child is there, he has to study. How will you change the school?
that next academic year, depending on his income.
Two options. Either you get instructions from your client with regard to this entire medical educational, or else I'll confirm this order. Please find out. We'll pass over. We can't adjourn the matter because I have already dictated half. Yes, next.
Definitely. Pass word.
Yes, next.
Till number 24.
Appearing for the response, my lords.
The visitation rights was granted by the Honorable Court, Your Honor. There is a contempt case in CCH-2 that has been adjourned on 18/9.
How does it matter? Whether the matter is adjourned before the CCH or wherever it is.
No, it is
we are
for the
only-
orders, Your Honor. 18/9, it is the orders.
Let it be. Let
After
it
the
be.
order.
This has to be heard independently.
After 18th, Your Honor.
No.
It may be adjourned.
If you want, I'll post it in the, this matter in the month of December.
My lords, interim order granted.
Interim order earlier granted is extended till then.
Till number 25.
Yes, next.
Till number 25.
For the petitioner.
For the respondent, my
And-
lord.
Lordship,
In
Lordship
applicant-
heard us, Lord, last occasion. Lordship may kindly see the order, Lord, that day. My Lord, main Lord, the ground was that 125(4). This is a petition under 125, Lord. 125(4), my Lord, she is not wanting to live with me. She is not entitled. The Lordship heard me on that day, my Lord. Then they were directed to find out whether any settlement is possible or not. Lordship gets that, Lord, orders on.
5/8. On
What is that?
5/8,
Please,
my lord.
124, no, this is a criminal miscellaneous.
Yes, my lord. I am for the respondent wife.
His wife doesn't want to live with the husband. If
No,
he
my
doesn't
lord.
want- Please listen to the court.
Obliged, obliged.
If this doesn't want to live with the husband, then no application can be filed under 125(4).
125(4), my Lord, she can't. She is not entitled.
Why?
That's the law, my Lord. 125(4) is very clear on that, Lord.
Not the law. She has her own reasons for leaving separate from the husband, unless and until a restitution petition is filed and the restitution is ordered, then you can say
No,
there is
yes.
desertion.
Restitution file, my lord, there are multiple, my lord, the suits here, multiple proceedings are
My lord,
pending.
may I, my lord?
No,
Restitution.
complete.
No, obliged.
but main ground is only this, my lord, 124, my lord, she is not entitled to.
Even the Honorable Supreme Court has said under 125, once the restitution petition is ordered and after that divorce is granted, even the divorced wife again, she can ask for the maintenance, notwithstanding the fact that the restitution petition is already ordered.
Yes, but the other grounds are that also, my lord, she is not similar maintenance, my lord, petitions way filed before the courts, my lord, in Tamil Nadu. That was also rejected, my lord. That is all suppressed. All those, my lord, facts are suppressed. Even, my lord, the affidavit of assets and liabilities, my lord, there's so much of, my lord, falls there. Now, this is on interim maintenance, my lord, we have come here. So now my request is, my lord, that now Lordship has, my lord, reduced it from 10,000 to 6,000 on a monthly basis.
7,500.
Now, all these matters, my lord, whether what is false, what is true, my lord, matter for trial.
By the court.
Matter for trial. Lordship, my lord, fix a date. My lord, they have been dealing separately from 2006.
MCs of which year?
My lord, 2008, we had filed for RCR, my lord. At that time, there was a
Multiple
divorce
petitions, my lord, multiple
by
petitions.
both the parties. By
I
both the
said
parties.
which year pending MC to be decided, which year it is?
23, my lord.
23, there cannot be any direction. We are living separate from 1995 also. There will not be any direction. We are only concerned with when the MC is filed. 23 MC, there cannot, which court is this?
No, not MC.
My lord,
Lord, this
may
is the
I-
125 CRPC.
125 also will not grant any direction. Which court is this?
Lord, this is 6th additional AC.
Family.
No family court of any matters of 23 will not be given any direction. Because they are dealing with other pending matters which are from 1960.
But if time-bound directions are not there, Lord, then Lordship is directed to be disposed of. Lord, let the matter for trial commence, Lord. We will prove it. Lord, all this, Lord, all matter for trial. Lord, affidavit of liabilities, Lord.
Because they are matter of trial, court has granted maintenance of 10,000.
Lord, that is
So
what.
looking into the
Lord,
assets
there-
and liabilities
Lord,
of
there
both
are-
the parties, it was
I
under.
request all the advocates, I have all the patience to hear to the advocates. Only where I get irritated is when the other advocate is submitting, have some,
Obliged, my lord.
how can I hear both of you at a time? Yes,
2006, Lord, they have been living separately.
yes.
Lord, she is the affidavit of assets and liabilities, Lord. She is worth, Lord, 8 crores. The properties where, Lord, it stood her name. Lord, that apart, Lord, the earlier petitions which were filed were all rejected. But all these matters of a trial, Lord, let the trial go on till such time, Lord, this arrangement could be continued.
Yes, what do you say?
My lord, the previous petition which he is referring to has been cancelled is after the divorce decree was set aside. All the pending IAs and all the other maintenance was disposed of. So after which again he went and approached the Supreme Court and he has filed one more divorce which is pending before the 6th additional. She had property, we had mentioned in the assets and liabilities about her property, and she had a rubber plantation out of which income she has built the matrimonial house. From 1993 she's staying in Bangalore, my lord. And the matrimonial house was built in 1995. From 96 she's staying in that house. His only aim is to vacate her from that house and to sell that house or to give it to someone else. And he has filed an eviction suit also against the wife, which has been pending for final arguments before the civil court, my lord. And this maintenance, after looking into the assets and
Petitioner,
75 years.
she is 66, my
65.
lord. And we tried settlement
From
through everything, and
2006,
she does not want to get a divorce, and she wants to be with her husband. We had filed RCR in 2008.
even now also.
Even now, we have filed counterclaim for RCR only in their divorce petition. She does not want to leave her husband. She is saying, did my parents get me married to him for divorcing me after this age? Next year, they'll be completing 50 years of marriage
Please
life.
advise her, please advise her.
She wants to live, but she's not ready to go to a native and stay with him in the native in a rented house and everything when the matrimonial house and son has spinal injury and
This
in
is
St.
what-
John's Hospital, they
This is the way she wants to fight. We will remand the matter. We will remand the matter. I'll set aside this order. What is this? How can it happen? You're living separately from 2006.
So
He's not
2007,
interested. He is not interested to live with you. In 2025, you say that I want restitution of conjugal rights. How will it happen? And you don't want to come with any kind of settlement.
No,
That
she
I'll
is,
join
she-
with the husband.
my lord, she is also trying. Both of them are on their own space. They don't want to come out of that space.
That is not possible. What is not possible from the last 20 years? How is it possible now?
So that's why
And
all
only
the matters
for
are being.
sake of litigation, they are fighting this. So that keeps them alive.
That is one point which keeps them running, I think, to the courts and everything.
Tell her either she come forward with the settlement, or else I will set aside this maintenance order. Tell your client.
My lord, apart from this,
Tomorrow. Tell your client, come back. Tell her that I'll set aside this maintenance order.
Serial number
Obliged.
26.
Day after,
Tomorrow.
day after.
My lord, next week, my lord. My lord, next week, Monday or Tuesday, my lord.
There is so many matters the court can't take up as per your convenience. Yes.
Obliged.
12-9. Serial number 26. Raja L. For petitioner. Gopinath KR.
Here on behalf of the respondent, ma'am.
Yes. Where is the petitioner? Any interim order?
No, my lord. Last deferring chamber visit has took place. So today both the parties to be, both the advocates we are supposed to appear. I don't know why they have purposely they have avoided coming today.
Then where are they? No
Your Honor,
representative.
I have
Any
for a
interim order
custody.
in this? Any
No, my
interim
lord.
order is
No,
there? No.
my lord, the kid now it is with the husband, Your Honor. Actually, is not taking care of the child.
This is the case where they're residing in the village.
Yes,
And the
my
boy
lord.
is
Yes,
not
my lord.
interested.
Yes, my lord.
No representation. Is this matter for dismissal on 24th?
Serial
Maybe
number
posted on
27.
22nd, my lord.
Not possible. There is so many matters.
24th.
This is the count.
Sorry,
Yes.
petition. I held up a court on some.
I think this is a case immediately
This
the
is
custody
only-
of the boy has to be shifted to the mother.
Which,
The boy custody of the boy has to be shifted to the mother. They live in a pathetic condition.
no, education is.
What education is having? He cannot speak 2 words in English. And you say that you're giving him good education. What kind of life you are living? What kind of life his mother is living? And why should the boy be in such a state? That's not right.
My final,
No, we
final
will
is
shift we will
pending.
shift the interim custody to the mother. He's
Middle-
he's having an eye infection continuously. And what kind of they're living in such a pathetic
least
condition. When the
this-
mother is living in Bangalore, she's earning enough. The father who is uneducated, who lives in the village,
At least
and,
complete
he,
the.
and the child is left with the grandparents who are also uneducated. Why the boy fate should be like that?
Even boys also not refuse the.
He will
mother
be.
custody.
He will refuse because that is the tutoring of the father.
Earlier, 1 week in the last year, 1 week.
No. That's in the interest of the boy. It has to be.
We have
The
discussed
custody
as far
needs to be shifted. Let the
At
mother
least
take.
this year completed the education.
What
then-
education is having there?
Allah,
I've seen
this-
him. I've interacted with him.
Allah.
Easy of his age.
My lord, is the mass card is produced, 90% is the.
Understand
Oh.
that pass card. Yes. Where is the order?
Order of annexure.
Agreed with
Annexure
the order
G, my
passed
lord.
in. Agreed with the order passed in GNWC number 332 of 2022, dated 19/2/2024, whereby the father is directed to hand over the temporary custody of the minor child to the mother after completion of the academic year 23/24. No, we are in September.
Yes, ma'am.
What would be the?
Yeah, we have inquired regarding the school, Your Honor. They are ready to admit
Take
in,
the child.
mid of the year.
After completion of the academic year 2023/24, that is after completion of his school examination, if any, if continued at Bidar, what is that? Bidar at Kote, Mandya district from the month of April 2024, the father is before this court. The father is staying in a village. Is it a village?
Yes, ma'am.
Staying in a village in Mandya district. Father is, what is his qualification?
In qualification is degree.
I don't
Not
think.
degree.
No. It's
Tenth.
say in the
He
petition.
said he is not.
Tenth, ma'am.
Huh?
I don't.
SSLC.
His qualification is 10th. And the mother's qualification is
Is engineering biotechnology.
engineering biotechnology. And she is working in Bangalore and earning salary of
Around 80 to 90,000. Yeah.
Around 80 to 90,000. In view of the disputes arose between the parties, the father has taken the child to the village, and the boy is staying along with the grandparents. This court had interacted with the father, mother, and the child. It is the contention of the mother, it is the case of the mother that from the last 6 months, the boy is suffering with the eye infection and it was not attended to. The father is going around here and there and is completely not taking care of the child. It is the grandparents who are looking after the child, and he is being a village, the kind of education he's getting is also not in the interest and in the welfare of the child. When this court has interacted with the child, this court could see that he's having a eye infection and it is persisting from a long time. The father is not, compared to the mother, is not educated, and even on the financial aspect also, the mother is in a better condition, is in a better position than the father. By all means, the welfare of the child is with the mother, and considering all these aspects, court had rightly passed an order on order dated so and so, giving the temporary custody to the mother. This court has inquired the learned counsel appearing for the mother whether in the middle of the year, that is in the month of September, whether he will be getting an admission in the schools at Bangalore. It is submitted that they've already had already had approached the school and they are ready to take the child, considering this court exercising the parent patriae jurisdiction and looking at the ultimate welfare of the child. This court deems it appropriate. This court is of the view that the trial court had rightly considered all the aspects and rightly granted the custody to the mother, and this court do not find any reasons to interfere with the said order. Accordingly, the petition filed by the father is dismissed.
Till number 27, Bindu U for
And the
petitioner.
custody of the child shall be within 1 week from today. The custody of the child shall be given to the mother. Number one. Number two, if within this 1 week, all the effort shall be made by the mother to secure the seat in the school, and he shall be joined in the school immediately.
My lord,
And
if
the
we
same
go there,
shall
they
be-
will not entertain us in this way, Your Honor. Though the mother is going there every now and then, but as far as the child is concerned, they are not allowing to take anywhere, Your Honor, my lord. This is the situation there.
Why are you
Since it is
telling
a
all that? No,
village.
the custody is given to you. Why are you bothered about all this?
Yes, ma'am.
Take if required, police help or from the go to the trial court, and immediately after the child is joined in the school, an affidavit shall be filed before this court, before the family court in that regard.
27, Bindu U for petitioner. PB Raju.
That they have joined the boy in the school. Yes.
For the petitioner, my lords.
No, this matter is adjourned for what?
Last occasion, my lords, I sought for a clarification of the order dated 30/8/2024, wherein your lordship has ordered 10,000 per month plus educational expenses. So there was
That's
a rejection
prospectively
from-
it is done.
My lords?
Prospectively it was done.
Yes, ma'am.
Prospectively, and also they are disputing that there is that is not fixed only for the year 2024 it was arranged. So that portion of the order has to be clarified and proportionately previous years also, my lords. And I have been directed to
I
take
said
instructions.
previous years we will not go. That's the instructions you wanted to get from your
Yes,
client.
ma'am. That is also there. And I had a check with my the party also. These are the expenses, the only with regard to the minor child, my lords.
What is his age?
It's my lord, so this is the child maintenance expenses incurred by the.
What is his age, I asked you?
As of now, my lords, 10 years, my lords.
For 10 years by what? Vaccinations every month?
No, in 2017-18, the child is born in the year 2014, my lords. And the synopsis I have mentioned. Date of marriage is 2013.
When did you file the IA seeking maintenance?
2018, my lords, because she has been thrown out from the matrimonial home on 7/4/2017, my lords. And she had joined her mother's house at Coorg. On 9/4, the summons in the MC case has been served on her within 2 days, my lords. Behind her back, while living at Bangalore in the matrimonial home, husband had filed the petition, my lords. And from 2017 to 18, the child started going to preschool. I have mentioned it in the down, my lords. In the year 2017, my lords. For that, she has incurred educational expenses of 25,000 only.
Then what is that on the right hand, 3,13,000?
That is means including the maintenance, my lords, maintenance of the minor child, food, baby clothes, toys, regular doctor visits, all those expenses, including everything I have put forwarded only for the minor child, my lords.
Even the court says 10,000. It would come to how much?
It will come
1,20,000 per month. Per year.
Yes, my lords.
Then what is this 3,13,000?
That is for that particular year, my lords.
Now she's going behind on last date of hearing, my lord.
Actual-
Not fair, my lord.
1 minute. Last time what you said, let this 10,000 go, let it be from the date, relate back to the day the application is filed.
If it is with educational expense, because the child is going from that year onwards, that will be counted under. That is the only submission. I leave it to the court, my lords. Yes, leave it to the court.
My lord said pay full school fees. I have been paying plus 10,000 from 2018, whatever is the calculation. I'll pay that within a period of 6 months. That is all. That is what was agreed. And she's now coming up with something new.
So now the expenses at 10,000 per month.
Yes,
from the date of application.
Yeah, from
whatever
2000.
that comes,
yes.
And whatever that you have paid till now will be deducted, and the remaining amount shall be paid within
6 months.
10 weeks from within
6
10
months,
weeks.
my lord, because my hoarding business is gone, my lord. I have pointed out.
Within 6 months from
Yes,
the date of the receipt of the order. Then what is the other thing left?
That is all, madam. As far as custody.
As for
enhancement of
that
the
appeal.
that is in your.
Yes.
What is the amount awarded by the court?
The award
Nothing is
awarded by
awarded
the
for her.
Trial court is 25,000 per month only to the minor child, with the litigation expenses of 35,000, and maintenance to the mother has been denied, my lords. So I am on this petition for enhancement to the minor child, also granting of maintenance to the mother.
Court has
also.
not granted educational expenses.
Together, both. It is 24 and 26
independently not
application.
granted.
No, my lords.
To the wife, nothing is granted having regard to her income. That is a subject that is on available material.
What is your petition? What is your writ petition?
My writ petition was that, my lord, this 25,000, because I was never given any visitation rights. I said 25,000 is too much having regard to my income, and she is capable of looking after the child, having regard to her vast source of income. Then this court said you pay 10,000 rupees and take care of the educational expenses. That I have been doing regularly. On that terms,
What about the visitation? Visitation, how it is
so
happening?
visitation should be continued, my lord. Weekends and holidays, sometime half. That is all I am asking. And my lord, a direction may be given that the MC may be disposed of at an early point of time.
Of this honorable court, visitation rights are being going on.
That can be continued, my lord.
Continue as it is. That also will continue. This as it is, like I have already said. This
Yes.
was my maintenance amount. 10,000 from 2018, and the prospectively the educational expense.
Yes, ma'am. BA.
Agreed with the next order sheet. Give the next in the next case also. Agreed with the order passed in I number 4. I number 4. Whereby the court had granted interim maintenance of an amount of rupees 25,000 to the daughter and 35,000 as litigation expenses for while the court had rejected the case of the mother for maintenance. The mother is before this court by filing WP number 17612 of 2024. Next. Writ petition. The father is before this court. Where is that order?
My lord, 17245 of 24. My petition, my lord.
In your petition, page number?
The order, my lord. Same order, my lord.
No, but where is it?
20.
Page number?
20 is
Impugned
the,
order, my lords. Impugned order by annexure A in
No,
17612.
in that order, it is discussing with regard to the maintenance. That's only question.
that is the only question.
You have not filed any petition for the visitation.
That
at all.
No, my lord. In the
That
course of when this matter was heard, my lord,
Yeah. Agreed by that. The husband has filed WP number 17245 of 2024 and the wife had filed WP number 17612 of 2024. It is the case of the wife that right from the year 2017, the day she is thrown out of the matrimonial home, she has been taking care of the child's expenses, and also filed an IA seeking for maintenance. And the court had granted only maintenance to the daughter at 25,000, and no maintenance is granted to the wife. It is submitted that the wife, it is particularly difficult for the wife to take care of the needs of the child and to maintain herself, and the court ought to have granted maintenance to the wife also. Next para. Land counsel appearing for the respondent, not respondent, land counsel appearing for the husband submits that the husband was into hoarding business, and as that has come to his business has come to a standstill. He's not having enough resources to pay the maintenance of enough income to pay the maintenance of an amount of rupees 25,000. When the matter came up before the court earlier, it is argued that the wife has not, though she is asking for maintenance, the husband he was never permitted to visit the child. Then this court has passed an order dated what when
yes,
is it?
one second.
On 30/8/2024, my lords. 30/8/2024.
This court has passed an order on 30/8/2024 as follows. And this is not altered. The same
No.
has passed the order as follows. Extract that order. And as per that, the father is exercising the visitation, and also he is paying 10,000 per month and taking care of the educational expenses. Land counsel appearing for the wife submits that right from 2018 when the IA is filed, from that day, whatever the educational expenses, whatever is the maintenance that is required, the husband has to pay, and it is the moral obligation of the husband to take care of the child and the wife. It is submitted that the wife is granting visitation to the father as per the orders of the court. Next, land counsel appearing for the father submits that the father is not in a position to pay the amount from the date of educational expenses from the date of application, that is 2018. As far as 10,000 amount that is awarded by the court, he'll be paying the maintenance from 2018, and the arrears also, if 6 months time is granted, he will be the husband would pay, and continuously he'll be paying henceforth in future whatever the educational expenses of the child are concerned, he is ready to pay. The land counsel submits that the arrangement that is ordered by the court with regard to the visitation, the same shall continue. Next part. Having heard the land counsel, the counsels on either side, peruse the material on record. The wife
Same continue.
had sought, the court had granted 25,000 maintenance to the to the child and no maintenance is awarded to the wife. It is a contention of the husband that the wife is self-sufficient, is having a lot of properties.
As regard to the maintenance of the wife, I will argue separately, my lords. As regard to the maintenance to the wife, I will argue we have received another account of the husband wherein he is having huge deposits and all, my lords.
Then how can we
I will
dispose
argue
of-
separately, my lords.
How can we dispose of this?
Only with regard to the child maintenance, that was the discussion that had been
That
happened
is
on
one
the
and
last.
the only writ petition. How can I dispose of one?
Only with respect to the child's maintenance and the ಹೇಳಿದ್ದು, my lords. Yes, my lords. I'm ready to address my arguments even today itself. With respect to the minor child, because that is the fashion.
You have questioned one order. Both of you have questioned one order. How can the court pass half of it and half of it you will argue?
My lords, on 38/2024, this was the observation made by this honorable court that at this point of time, we are not inclined to look into the maintenance awarded to the wife. Only as regard to the child's arrangement, we'll be looking into. And
That is
with
an
respect
interim
to
order.
that, I
Now
have
the
made.
court is going to pass a final order.
There are so many documents I need to produce, my lords.
Then
with respect
you
to
should have
that.
said that in the beginning. Why are we wasting the time like this? Writ petition, one
An
impugned
interim
order.
order with respect to the minor child only, my lords. Interim arrangement, which has been there.
Every time she comes up with such.
No, like that is untoward of an senior
Should
counsel.
have
my
told the
lords.
court.
All the time I am disposing of the matter. How can, just imagine, how can the court can pass an
It may
order
be passed
finally?
on. It may be passed on. I'll address my arguments today itself, my lords.
Yes. Yes, absolutely. Tell the advocates this list.
My lord, may I make one mention, my lord?
My lord, if she's
First,
giving
there are
any,
16.
she's filing any document, let her give it in advance, my lord.
Given you,
Because not fair, no, my lord.
type that and keep it. Type that and keep it in the file. This is matter on, because there is there are no dates in September. Don't have to type the list is matter in the month of October, whatever is the date.
My lord, one submission, my lord, may I permission, my lord? The serial number 16, your lordship has adjourned it for next week. At the same time, my lord made an observation, my lord, the extension of interim order. In fact, no interim order was granted earlier for extension.
It will not be extended. If interim
There
order
was
is
no
not,
interim.
it will not be extended.
Yes. Yes, ma'am. Yes. Highly obliged, my lord.
Adjournments now.
No, I'm not seeking adjournment.
Yes.
Lordship, serial number 16 I am ready. I was on my legs, sir. By the time I came, it has been adjourned. 2:30.
There are so many matters at 2:30. I
I
can't
was
take
ready,
it
your
up.
lordship,
But I can't take it up today because already whenever that is listed.
so it is listed in October, your lordship, because matter is there on 12th. Sir. She has filed the frivolous application. Already I have been paying maintenance to her. Again, once again, she has filed the maintenance application and it has ordered. Since the order is not complete, she has filed an application to reject my.
What to do? If you're not there, the court will not, court can't help it. Because in the month of October, the roster will change. I can't give all the dates for the next roster. That's why I'm not giving the dates.
So I am ready, your lordship.
You are ready, but the court, there is another list. I have to take it up at 2:30.
The time I entered, it was
List the matter somewhere on,
Tomorrow, your lordship.
no, not possible. List the matter on 24th.
So
Yes.
because she has filed an application, at least on 15th, I take a chance. Your lordship.
Already 15, there are 80 date given matters. Can the court take up all the matters? That's what the difficulty of the court also you have to understand. No.
2 seconds it took place to me to enter.
Yes. Anything else?
Lord, serial number 17, considered to adjournment without informing me. Date may be given. Serial number 17, list number 2. They have taken the adjournment in the morning, so it was called and said adjourned. I walked into the court. I didn't want to bother your lordship. The date may be fixed.
17th, is it recorded that it is informed to the other side? Look at it
17, list number 2.
in list number 2 because I'll record that the other side it is informed.
And then the date
That's why please wait. I have to find out whether they said that it is informed to the council or not.
That petitioner comes in seats time on the ground that this council is unwell. Hence, in the month of November, it is
No, whether it is the informed to the other side that must have been recorded. Look at dictation. Find out. Tell you in the afternoon.
The date may be given.
No, I can't. Let the file come.
Serial number. ಇವ್ರದ್ದು ಯಾವ್ದಿದು serial number? List 2 ನಾ? 24/9. No, that is 2. 24/9 ಗೆ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಬಿಡು. ಅಲ್ಲಪ್ಪ serial number 16 ದ 16 ಅಂದ್ರೆ ನಿನ್ಗೆ ಅವಾಗ list number 2
ನಾಡಿದ್ದು ಅಲ್ಲಿ ಇದೆ ಮ್ಯಾಟ್ರು ಏನ್ ಮಾಡ್ಬೇಕು ಆಗದು ಅವರು ಫಾಸ್ಟ್ ಆಗಿ
ಮೇಡಮ್ ಈಗ
Court officer. Court officer.
So, Madam Court Officer. Hello, Court Officer.
ಮೇಡಮ್ ಹೇಳಿ ಏನು
ಲಿಸ್ಟ್ ನಂಬರ್ 5 ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಏನಾಯ್ತಮ್ಮ?
ಅದು ಕಾಲ್ ಔಟ್ ಆಗಿದ್ಯಾ? ವಾಟ್ ಈಸ್ ದ ಹೆಡ್ಡಿಂಗ್ ಇಸ್ ರಿಫ್ಲೆಕ್ಟೆಡ್ ಮ್ಯಾಮ್?
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ತೋರಿಸ್ತಾ ಇದೆ.
ಅಲ್ಲ ಮೇಡಮ್, ಅದು ಟಾಪ್ ಅಲ್ಲಿ ಏನಂತ ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ತಾ ಇದೆ?
ಅಲ್ಲ ಏನಾಯ್ತು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲ ಮೇಡಮ್, ಅದು when the card list itself reflected at 2:13 ಅಂದ್ರೆ ನೀವು what happens ಅಂದ್ರೆ the list is not yet called out.
ಇಲ್ಲ ನಾನು ಅದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡ್ಲಿಲ್ಲ. 10:30 ಅನ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ. ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
Court officer, list 18 serial number 36. Court officer.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 36 5 ಗಂಟೆಗೆ ಇನ್ ಕ್ಯಾಮ್ರಾ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ ಅದು? ಏನ್ ಕ್ವೆಶ್ಚನ್ ಕೇಳ್ತೀರಾ ಅಂದ್ರೆ ಐ ಕಾಂಟ್ ಆನ್ಸರ್ ಟು ಯುವರ್ ಕ್ವೆಶ್ಚನ್ಸ್ ಅಟ್ ಆಲ್.
ಅಂದ್ರೆ ಪಾರ್ಟಿ ವೇಟ್ ಮಾಡ್ತಾರೆ. ಒಂದು 4 ಅವರಿಗೆ ಬಂದ್ರೆ ಸಾಕಂತ ಅದಕ್ಕೋಸ್ಕರ ಮೇಡಮ್.
ಅಲ್ಲ ಮೇಡಮ್, ಅಲ್ಲ ಸರ್, ಇವಾಗ ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟರ್ ಅಂತಂದ್ರೆ ವಿತೌಟ್ ದ ಪಾರ್ಟೀಸ್ ಮೇಡಮ್ ಪಾರ್ಟೀಸ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಕ್ಕಲ್ವಾ ಹೇಳಿರೋದು ನಿಮ್ಗೆ?
ಹೌದು ಮೇಡಮ್.
It is one is at 5 p.m. and another is at 5:30 p.m. You have to meet in the chamber. That is chamber matter.
ಓಕೆ, ಅದಕ್ಕೆ ಅವ್ರು ಅಲ್ಲಿ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ ಫೋನ್ ಮಾಡಿದ್ರು. ಅಲ್ಲಿ ಚೇಂಬರ್ ಹತ್ರ ವೇಟ್ ಮಾಡ್ಬೇಕಾ?
ಅದೆಲ್ಲ with party ಸಮೇತ, because ma'am wants to interact with the parties. That's why it is listed in chambers.
ಓಕೆ ಮೇಡಮ್. ಅಡ್ವೊಕೇಟ್ಸ್ ಬೇಕಾ ಮೇಡಮ್?
Sir, both advocates and parties should be present, sir. Without advocate, how can?
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗತ್ತಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
Madam, your queries, how you are asking the questions means I can't answer to your queries, ma'am, because I only don't know what happens. Wait, ma'am. I only don't know what ma'am's instructed me at 2:30 p.m. when she is resuming back. How can I tell that whether it is continuing or whether the other list is taken? How can I answer to your queries?
All right. Thank you, sir. Thank you.
But
On the 230 list.
230 list, list number 5. For orders matter, serial number 1, Jagdish HT.
No, the next list 230.
230.
Krish Ballare.
Which one?
230 is list number 6.
List number 5.
No, it's not 230 list. Why did they mention it 230? Anyway,
List number 5, serial number 1, HT Jagdish.
yes, Mr. Jagdish.
HT Jagdish.
Which is the insurance company, Shriram General Insurance. Where is Pradeep?
Pradeep.
Mr. Pradeep is directed to take notice on behalf of the insurance company. Then counsel for the applicant shall serve the copy of the appeal memo. Notice refer this matter, place this matter before the local adalat.
Serial number 2.
In this case, I prefer the appellant, my lord. I pray for a week's time to take steps to R2, respondent number 2. Otherwise, I will file a memo seeking dispensation of notice to R2.
Where is Renuka? Who is R2?
R2 is the owner of the lorry, my lord.
Liability is on whom?
On respondent number 1 and 3. 3 is served but not represented.
So now the process is complete.
Yes, my lord. Negligence is apportioned 50-50 on respondent number 1 and 2. Who is the owner of the lorry? I will file a memo seeking dispensation of notice to R2.
Where is the memo?
Memo, I will file it in the registry, my lord. Your lordship may kindly grant me a week's time. I will file it in the office.
Yes, it is submitted that the appellant will come up with a memo seeking the dispensation of notice to the R2. Less this matter after a week. R3, Sriram, R3, Mr. Pradeep is directed to take notice. Yes, 3.
Serial number 3.
Memo is for seeking dispensation of notice to R2 dispense with at the risk of appellant. I number 1 of 22 is filed to condone the delay of 784 days. Condone on the condition that they are not entitled for interest for the set period. Where is Mr. Krishnaswamy?
A. Krishnaswamy.
Refer this matter to the Lok Adalat.
Hearing on interlocutory application, serial number 4. Serial number 4. Shantraj K.
Yes, I number 1 of 23 is filed to condone the delay of 357 days. Condone on condition. Refer this matter to the Lok Adalat.
For admission, serial number 5. Syed Abdul Sabur.
Yes. Where is Pradeep?
B. Pradeep.
Is it a case of death or injuries? Let's see. Let's see that. Where is the Sriram General Insurance officers?
Sriram General Insurance.
Inform Mr. Pradeep at least to come. No, actually 2:30 that the officers will come. That's why the matters are listed specifically at 2:30 of Pradeep. Ask Mr. Shivanagowda to come because all matters are Pradeep's matters only listed today. Where is it? Let's see. Yes. Where is the officer? Sriram General Insurance. She didn't come. Yes. What about this?
Cell number 5. 8686.
It's a case of death. Which case you have given? MFA number 8686.
That is only 5. Higher the principal.
That is not that. What you have given is MFA 433. Yes, paragraph number. No, before that, pain and suffering, how many are the injuries? 3 grievous injuries. So we'll grant 60,000 under the head of pain and suffering. Medical expenses as it is. Then food and nourishment, how many days was in hospital? Huh? No, I said how many days he was in hospital. Huh? 17 days. Court has already granted 25,000. 25, 25, 50,000 is awarded. Huh? It is not. It is not your opinion. Will not interfere with that. Huh? We'll see. We'll see when it comes to the. Then what about? Huh? No, no, not amenities. Now we'll go to loss of earning due to disability. It has already increased to 60,000. Loss of earning due to disability. What is it? To the limb. To the limb. A court had taken. Let's see that particular paragraph. PW2 has evaluated the disability at 78.1%. It is admission of the petitioner. How can you get away with this? It is admission of the petitioner. He continued in service with similar payment prior to the date of accident. It is also the admission. The medical expenses have been reimbursed by the company. In view of the said fact, there is no question of loss of future earning. Amenities will increase. Amenities will increase by another 50,000. Because it is your admission that you are continuing. Please understand, this is your own admission. How can you submit something contrary to this? In view of the said fact, there is no question of loss of future earning. The petition entitled for compensation of 2,50,000 under the head of disability. But it is not having an impact on your future income. So court had granted 2,50,000 and then another loss of amenities 50,000. Mr. Counsel, we can't go into all that. We are only bound to look at the evidence that is available on record. That is your own admission, your own evidence. We can't go beyond that. So if you want, what we can do is we can dispose this off by granting another 1 lakh for loss of immunity, another 50,000, that is 1 lakh for loss of immunities. No. Now if you, then court has to dismiss it if I have to do it on because no grounds to, already court has granted enough amount. Court order. No court order. Yes. Loss of earning food and nourishment 50,000. Then disability 2,50,000. Loss of amenities 1 lakh. So what is enhanced is 50 here and 20 there, 60. 60, that is 3,97,000 plus 60. Not 60, 50, 70. So I have increased from 30 to 60, 30,000 there and 50,000 here, 80,000. So it becomes 4,67,000. Land council appearing for the insurance company submits that. Because if it is no on the merits of it, I cannot enhance not even 1 paise on this. It can be. That is, that order would be like for the Lok Adalat. It is submitted by the insurance company that they'll be paying 80,000. Yes. No. It's already on the higher side. 80,000 in addition to what has been awarded. Then counsel for the insurance company submits that they're ready to pay an amount of rupees 80,000 in addition to what has been paid, what has been awarded by the tribunal, and they'll file a memo before the joint memo before the Lok Adalat. List this matter on Friday. Yes, next 6.
Cell number 6. Cell number 6. Nataraj, HP, Anup Sita Ram Rao.
No liability on you. No liability on the insurance company. What is that? Liability. Then we will, if it is on enhancement, we'll calculate. Yes. What? Please, I'll ask you. Please answer to that. What are the injuries? 2 fractures or 1 fracture? 2 fractures. So we'll award 60,000. For 60 we'll award. Medical expenses as it is 1,10,000. Then loss of income during laid up period. How it is calculated? Then loss of future income is continuing in the job. According to the doctor, how much? 33,000. So that will take future medical expenses, 30,000. Then nourishment, it is not granted. How many days was in hospital? 21. What is the disability according to the doctor? That is 11% to the whole body. So loss of amenities, nothing is granted. So for 11% will grant 25,000. What is loss of towards future medical expenses? 20,000. There is no loss of income during the later period is done. Future attendant nourishment loss of that I've seen. Medical expenses that is added. Okay. What exactly are the medical expenses? 1 lakh? 1,000. 1 lakh, 1,000. So we are granting 20. So 1 lakh 1 plus 21 is 1 lakh 23,000. That we will add it in that only. 1 lakh 23,000 plus 1 lakh 23,000 plus 0. It's coming to 3,43,333 against 2,65,333. Yes, Sriram General Insurance only. This also. Then counsel for the insurance company submits that they're ready to pay an amount of rupees. They're ready. They're an amount of rupees 3,43,333 against an amount of rupees 2,65,333. Both the parties shall file a joint memo before the Lok Adalat Friday. Because this is all, we are not granting anything extra at 6% interest. Inform the council also. On Friday, Lok Adalat. Yes, next 7.
Cell number 7, Vasantappa, for petitioner B. Pradeep.
Yes, what about this? Case of death or injury. Huh? Switch on both those mics. Yes, what do you say about this? Look at the file.
B. Pradeep.
No.
Vehicle damage.
Damages to the vehicle. Court has granted 1,25,000. Tara? You do one thing, you look at it, what would be the amount, we'll have it in tomorrow's list. Calculate and tell. 2 lakh? What is it they're claiming? What is it they're claiming? 25,000. No, that's why I'm saying anything, what is the amount? Get instructions tomorrow. They're ready for another 25 to 30,000. This is matter tomorrow in the same list. List at 2:30. Yes, next. 8. What about this? Parties are served. I think there needs to be an order on merits. List is matter. No. Respondents are served and not appearing. So this can't be taken up in Lokatalat. Let it come before list is matter in the usual course. Yes, 9. A list along with MFA 2433. Yes.
Serial number 9. Serial number 9.
What about this? Contributory negligence. This is matter in the usual course. Yes,
Serial
10.
number 10.
Both the mics you please on. Switches are not on.
My lordship is a case of contributory negligence, my lordship. 25% is against the.
No. Is there any scope for settlement in this?
My lordship.
Is there any scope for settlement?
Settlement, take a scope.
Please talk to Mr. Krishnaswamy and come back tomorrow. It will be in the same list.
Yes, my
To
lordship.
also get instructions. Yes, 11.
Serial number 11.
Kamla DK.
My lords, the advocate on record is down with ill health. Kindly a week's time may be granted.
Let's see.
I think this is the 10th time they have taken the adjournment.
Yes.
Tell.
It's a case of
Injury, Mandal.
injury. No, there are two. MFA
620.
71115 is
Please.
arising out of
I. 7115 is 625 of 18.
number 625.
625 of 18.
Yes. So in this, let's go to 625.
It's para 21 and 22.
Para
21, 22. Disability assessed by 20% is taken, my lord.
No, where is the table?
Table
Of
para
625?
30 of the judgment.
Para 30. Table is at 32,
Please.
where 8,12,660 is granted.
Correct.
8,12,660.
2000, in this case, my lord, 2017 is the accident.
Pain and suffering, how many are the injuries?
There are 7
7 fractures.
7 injuries.
How many fractures?
Para 22 of the judgment mechanism.
Para?
22.
Yes, read.
Fracture of candidate tibia, fracture of tibia and fibula, acromial clavicle subluxation right, fracture of right
Fracture,
acetabulum,
open
pelvis.
Fracture, injury, spinal injury, facial
Correct.
injury.
Pain and
So
suffering,
1, 2, 3, 4, 5, 6, 7, all are grievous injuries. So we'll grant 1 lakh.
Please,
There's medical expenses as it is.
please.
3,56,860. How many days he was in hospital?
He was hospitalization for, according to me, my lord, 12 days.
Huh?
12 days. But 1 minute, my lord. For these injury, it is very difficult for 12 days.
That's what. For
But
these,
as per the judgment, my lord, no. First,
we'll grant 30,000.
please.
Then loss of income during later period. Which year is this accident?
17 accident.
17, it would be 11,000.
Please,
So at least 6 months for these injuries.
it can.
Huh? So it is 66,000.
Please.
Then loss of future earning. What
Please.
is, according to the doctor, what is the disability?
Quota has taken 8%.
How much?
Quota has taken.
Let's see that paragraph.
I will. Para 27.
to the extent of 20%, especially keeping in view when compared to the whole
12%.
body, the degree would be reduced. I am the one sustained partial to the extent of
18 and 30.
there is a shortening to the extent of 10%.
Please.
And what should-
12% disability is taken. Can lots of can take 20%.
20% with all this shortening of the, so 11,000 into 12, what is the multiplier?
No, disability.
What is his age?
Court has taken 20%.
No.
Court has also taken para 30.
Para?
30.
What is the evidence of the doctor that we need to see?
No, what the doctor, that's what my lad, what the doctor says that the disability assessed by the doctor, right lower limb 18%, and for the left lower limb 35%, and the total disability with respect to the right upper limb 12%.
12%.
12%.
So 12
18, 12 means that is 30 to 65% to the whole body, or the limb disability. So 21 or 22% can be.
22. So 11,000 into 12, what is the multiplier?
He was 17 is the multiplier.
17
30 years.
into 22 by 100. $11,000 into 12 into 17 into 22 divided by 100. It's coming to 4,93,680.
Amenity.
Loss of future earning, loss of amenities. What is this 10,000 granted by the court for this kind of disability?
Sometime error.
How much can be granted?
Another 50,000. And
all are covered?
No, future future medical expense.
What is the evidence of the doctor?
It is not mentioned in the judgment, my lord, but considering the nature of injury, what he has sustained, another 20 or 30,000 can be granted.
4,92,000. Yes.
Amount very high.
It would be coming to 11,26,540 against 8,12,660.
Correct.
Then comes for the insurance company submits that they're ready to pay an amount of rupees 11,26,540 against the amount of against the awarded amount of 8,12,660. The party shall file the joint memo before the local adalat on list the matter on Friday. Yes. No, what about the next one?
Next one also same
It's also a case of injury.
Next, that you pin.
Vertebra fracture.
This is?
Vertebra.
No. This is MVC?
629, so 26 mila.
626.
Para 33.
Para 30?
33, nature of injuries concerned. But compression fracture of spine.
We'll go to the table.
30. 29 mil.
What are the injuries?
The injuries are compressive fracture of spine, vertebra, and facial injury.
Facial injury, facial bone fracture.
Tooth class.
2. So court has granted 45.
45.
70.
70 is on the
because
compressive fracture is
spine.
That's what compressive fracture.
Vertebra compression.
Correct.
Facial injury.
But another 15,000 to 60,000.
That is 60,000. Medical expenses.
Please.
39,797. How many days was in hospital?
9 days.
Rightly granted. Some more amount for this injury? We'll say 15,000.
Can.
Then loss of income during later period.
3 months.
Hmm?
3 months. 33,000.
Next, loss of future income. What is the evidence of the doctor?
My lord, 8% is taken.
What is the evidence of the doctor?
Doctor regarding vertebra is concerned 20%.
Hmm.
Facial injury is concerned 6%. Total 26.
When there is an injury to the vertebra, we can't
Compress.
consider it as a limb disability.
Yeah.
It's a whole body disability. So according to the doctor, it is 20%.
20%.
20?
20.
So we'll take 11,000 into 12. What is the multiplier?
My lord, in this case also 17.
17 into 20 by 100. It comes to 4,48,800.
Amenity.
Loss of amenities. Same like in the other case.
No, my lord, 5,000, another 40,000.
What is granted?
5.
5. Another 40,000. Another 40,000 or 40,000?
Total 40,000, my lord, because
Next, loss of amenities. Then loss of income from the all are covered.
it is covered, my lord.
It's coming to 6,36,597. What was awarded is 2,45,517. Yes. Then counsel for the insurance company submits that they're ready to pay an amount of rupees 6,36,597 against the awarded amount of rupees 2,45,507. In both the cases, 6% interest. And the parties will file a joint memo Friday. Yes, next. Inform your
Serial number
senior
12.
for the joint memo.
I will.
Serial
Yes.
number 12.
3,20,000.
It's insurance company is ready to pay
20,000.
3,20,000 against or
Lump sum, my lord, in addition to what has been awarded.
is ready to pay an amount of rupees 3,20,000 in addition to what has been awarded by the tribunal. That is, it doesn't without interest.
Without it.
Without interest.
We have calculated interest also.
Without interest. Yes. It's a lump sum amount. Don't. And they will file a joint memo Friday. Next 13.
Serial number 13.
What about 13?
Shamir Ahmad.
The case of injury, my lord. The injured is a minor girl, my lord.
Then injury of a minor girl, then Master Mallikarjun's case. If you want any other calculation, we can't do it.
My lord, the doctors.
No, it is done as per Master Mallikarjun's case.
Yes.
Then in that case, no enhancement we can grant. If you can show as per the judgment it is not considered, we'll consider.
The medical bills have not been considered in the before the tribunal, my lord, because the total medical bills.
So do one thing, please have a discussion with him. We'll have it tomorrow. Yes. This is market tomorrow. Same this. Next 14.
Serial number 14. Serial number 14. Ravi Shankar Shastri.
50% liability to the Shriram, my lord, and 50% to the national insurance, my lord.
We can do it, my lord.
We can?
We can.
Dispose, my lord, income is proved, my lord, is the claimant submissions, my lord. It's not notionally.
I'm not going to pass any judicial order on this.
Then, my lord, it should be in this.
Yes. This is matter in due course.
Please.
Serial number 15. 15.
Yes, 15.
Shantraj.
Yeah, this. Pradeep, any scope?
Shantraj.
Next week. Next week or tomorrow? Tomorrow. Ask him, talk to him.
Day after tomorrow, he said one of the relative has expired today.
Then next week. Is 16?
Serial number 16.
What about this?
My lord, I am questioning the quantum, my lord.
The claimants also prepared an appeal seeking enhancement of compensation.
Oh, what is that?
5366 of 23.
List along with, so give the number.
Tomorrow.
6
List along with that number tomorrow.
5366 of 23.
Case 17.
Serial number 17.
What about this?
This is quantum. The fact is, no, my lords, it may be posted on Monday, my lords. I'll dispose it because the case is the injured has died after the 1.5 year, not due to accidental injury. No, there is one case law, my lords, Supreme Court case law, in which the same facts, but they're taking the future income.
So Shivanagoda, is anything?
No,
instead of Monday,
decision which is
instead of Monday, we'll have it tomorrow. First of all, please understand the judgment, whether it applies to the facts of the case.
Please,
if not, talk to him in some amount, whatever, if they are ready,
please,
we'll dispose it
please,
of.
Tomorrow,
the same list.
Yes.
Next.
List number 6 for order, serial number 1. List number 6, serial number 1, Girish P. Bandare.
Appearing for the appellant.
30,000 pay and recovery is equal. Global.
Has to be passed.
Yes.
I think that 2020 matter is, I'm having rostered 2020. Yes. It is submitted by the appeal is preferred by the claimant seeking enhancement of the compensation. Then counsel appearing for the respondent insurance company submits that they are ready to pay an amount of rupees.
Global 30,000.
A global compensation of 30,000. Why this pay and recovery is already awarded by the tribe, and the tribunal has already applied the principle of pay and recovery, and they'll file a joint memo in this regard.
Yes, judicial pay and recovery, I think.
No, it is already. That's what you're saying. It's already.
Yes, ma'am.
Then no, because the owner has to be here, and was he ex parte before the court?
Yes, my lordship.
Then file a memo. Seeking now itself you give.
Yes, ma'am.
A memo is filed seeking dispensation of notice. Who is the owner of the vehicle? R2.
Yes.
R1 and
2 and 3.
2 and 3.
2 and 3. They remained ex parte before the court, hence a memo is filed seeking dispensation of notice. Accordingly, notice to the respondent is dispensed with. They have not preferred any appeal against pay and recovery.
No.
Yes. Both the parties shall file a memo in this, a joint memo in this regard before the Lok Adalat on Friday.
Serial number 2. Serial number 2.
What about this?
Number 2 in this matter. ECM matter, my lord. They're seeking for medical bills. The accident is prior to the amendment 2010, my lord. So any global compensation may be granted, my lord.
That's what, if you talk to him, I'll have it tomorrow. Yes, list this matter tomorrow.
Please.
Yes, next 3.
Serial number 3.
Memo is filed seeking dispensation of notice to R1, R2 and R4. Memo is taken on record. Notice is dispensed with.
For the appellant, my lord, we are on the 2 grounds, my lord. One is, my lord, salary certificate marked and the employer examined. He was working in a sales assistant at Natural Ice Cream, my lord. My lord, however, my lord, the notional income was taken. He is
What
not.
is your income?
15,000, my lord.
Notional income is?
11,000.
Which year is the accident?
2017.
That's one ground.
One ground, and the sisters and brothers, minor sister and minor brothers, my lord, the consortium was not awarded to them. Only 2 grounds, my lord.
Even on the judicial side, we are awarding.
With regard to consortium, my lords, it is left to the court. However, one minor sister is there. The brother is a major. With regard to income, my lords, there is no proof of payment, my lords.
My lord, employer stated that, my lord, he was given.
That is not sufficient. There should be some other material before the court.
However, my lord, he is not a unskilled labor, my lord. As per the notional Lok Adalat chart, my lord, it's for the unskilled labors. Some enhancement apart from that, my lord, may be taken.
Work it out. Just speak to your officers.
I will.
Come forward with something if it happens. Otherwise, we'll hear it on the. Yes.
Tomorrow, my lord.
Tomorrow.
Please, my lord.
Yes, 4.
Serial number 4. Serial number 4.
Notice to respondent number 1 returned as refused amounts to deemed service of notice. IA number 1 of 23 is filed to condone the delay of 61 days for the reasons stated. Condone. Yes, Pradeep.
For respondent number 1 notice, it seems earlier it was refused. And I appear for on
Deemed service.
It amounts to deemed service of notice. Yes.
ಅಲ್ಲ,
6 4. On behalf of the Melody,
You are appealing for?
appellant's counsel, Melody, on behalf of the
appellant's counsel.
appellant's counsel. Melody, what he requests is Melody a week's time to take steps to the respondent number
We have
1.
already satisfied our no question of taking steps, sir.
Then tomorrow it will be kindly be taken, Melody. I do not know the
Find out what could be the
My lord, we have already satisfied the award. If my learned friend is sit with my lord, we can
That's what the
negotiate with the amount.
That's what.
Tomorrow, Melody, it can be
Let
taken.
him. Let
I
him.
will inform him, Melody,
Let
regarding.
him talk to Pradeep
Yes,
tomorrow.
Cell number 5, hearing on interlocutor application.
Why there are no other matters, Pradeep of?
Guru Prasad, acceptance of
Huh? No other matters.
Is there?
You should have given some
I will
more
give the-
matters also. Tomorrow, give it to Ravi.
I will give the list
It will be
tomorrow.
listed
Tomorrow I will give the list.
And she is from Sriram General Insurance.
No, my lord. Bajaj Alliance.
Bajaj Alliance. Where are the Bajaj Alliance matters?
List number 6 only, my lord.
Oh. Okay.
I'm seeking
Yes.
dispensation of notice for
Five.
R2.
Memo is filed seeking dispensation of notice to R2. Dispense with IA number 1 of 23 is filed to condone the delay of 297 days for the reasons stated. Delay is condoned. However, they are not entitled for the interest the set period.
My lord, in this case, my lord, connected matter is filed by the wife and children, my lord. Parents, my lord. That has been disposed of in the Lok Adalat, my lord.
Oh.
The same arising out of same accent, same MEC.
That may be called along.
MFA 7010 of 22.
List along with write on a paper and.
Please.
Otherwise, wrong bundles will come.
No, my lord, I will give it.
List along with MFA number so and so tomorrow. Yes, next 6.
Cell number 6, CR Rajagopal,
Ravi S. Samprati. Where is he?
Ravi Samprati,
Ravi Samprati is unwell.
Unwell. Tomorrow will.
Tomorrow.
Ask him to speak to the petition advocate also. Any
Cell
scope
number
for
7,
settlement? Yes, Pradeep.
Raju S. 7B Pradeep for respondent.
This matter
It's already
challenging.
Lok Adalat.
No, my lord, this matter challenging the liability, my lord. It requires for hearing, my lord, any date, my lord.
Liability is fixed on the owner of the vehicle.
No, my lord, I am challenging the liability.
Where
Insurance
is
company
your
appeal.
appeal?
Company appeal.
Where is it? 7.
Cell number 7, sir.
7, there is no company appeal.
No company appeal. Only single file.
Only claimant's appeal is listed.
Along with the
Tomorrow, my lordship, I
Talk to him
brought rank file thing.
tomorrow.
tomorrow.
Yes, call the passwords.
Passover matters. List number 1, serial number 6. Passover list number 1, serial number 6.
List number 1.
Calculations are filed.
Hmm?
The calculations as per the direction is filed. So they have filed the.
What we do is, without going into that, please argue on the merits of the matter. We'll dispose it off. As per the calculation, the execution will take place. That's what I told in the morning. We'll hear the matter itself. That's why it is adjourned, passed over. Come to the impugned order.
Then maybe. Then it may be day after.
Yes. This
Monday.
is matter on next week, whatever is the date available.
19/9.
Yes, next.
Serial number, list number 2, serial number 7. List number 2, serial number 7.
I appear for the respondent in this matter.
Yes. Please come to the impugned order.
Please, yes. Annexure G, page number 40.
Yes.
So I said a few facts, my lord.
You're for the mother.
For the mother. Lord, the daughter, my lord, was born on 3/11/2010.
3/11/2010.
Yes, she's almost 15 years old now. Lord, the parties separated on 25/8/2020. The petitioner was advised to leave the matrimonial home by the counselor who the parties were consulting. And the advice was given, my lord, in the interest of the child.
Yes.
Because the child was suffering trauma and she had suicidal tendencies, and therefore the therapist, my lord, advised both the parties. These are admitted facts. Lord, 6/4/2021,
Hmm.
the petitioner filed a complaint with the police, my lord, that's at page number 13.
Hmm.
The complaint was about the ill treatment she was facing at the hands of the respondent and how the respondent had neglected the child, abandoned the child and the petitioner, causing mental trauma. May I read, my lord, with your lordship's permission? Page 13. My lord. It is not a case where, my lord, the mother is keeping the child away from the page 13, my lord, Annexure C.
Hmm.
Lord, your lordship may come to page 14, the first paragraph.
Hmm.
The last time, this is firstly about the in-laws. The last time when they stayed with us on in 2018-19, it was a nightmare for me and my daughter. Left with no option, I approached them seeking help as my differences with my husband were growing, and he had emotionally abandoned me and my daughter for over a year in our own house. He had stopped communicating with us. He used to spend time with his friends, playing until late evening. After dinner, he used to go out until late at night or early morning on the pretext of playing poker. My daughter used to cry and roll on the floor to stop him from going out and spending time with her. I had to take her to a therapist as I was extremely worried about her mental health. Instead of helping me, they told him that I am trying to complain against him. Taking advantage of our differences, they used to abuse me and assault me. When I informed my husband, he slapped me and warned me against complaining about his parents. In spite of all this, when they came again for bypass surgery in 2019, I took care of them. Lord, next paragraph. Since I could not bear the constant harassment, intimidation, and torture, I went to my parents. I'm sorry, my lord, your lordship, may come to the following paragraph. I became helpless bearing the harassment, physical and mental torture. My daughter fell sick because of my husband's neglect, and her eating and sleeping were seriously affected. She also developed suicidal instincts. On the advice of the therapist, Dr. Pavana Rao, we started living separately. Both I and my husband agreed to the move. It was a blessing in disguise for me as also uh, and escaped the physical torture, but the mental torture continued unabated. He comes to my house and threatens my life. My in-laws have now come back and are staying with my husband for the last 2 months. I am a joint owner of the apartment, and yet he comes here and harasses me frequently. I have not gone back because I worry about the safety of my life and my daughter's well-being.
Yes.
Lord, thereafter, the respondent files a petition for custody. Lord, paragraph 9 of the petition, page 22.
Yes.
Page 22, my lord, paragraph 9.
Yes.
The respondent's custody petition. The petitioner submits that since the child's health condition was not good, thereafter the petitioner and the respondent consulted child therapist, Dr. Pavana Rao from Apollo Clinic, and on the advice of the therapist, both the petitioner and the respondent decided to bring about a temporary change in the child's environment to allow her to heal by taking her away from this house. Thereafter, the respondent had taken the child and decided living in another apartment, which is owned by the petitioner and the respondent in Bangalore.
Yes, admitted as fact.
Yes. Look, he also files an application for visitation.
Where is
That's
that?
at page number 31,
Hmm.
Annexure E.
Page number?
31, my lord, 31.
Hmm. What is it he sought for?
But he sought weekend visitation Friday to Sunday.
Friday evening.
Friday evening to Monday morning.
To his residence. Yes.
Not the response by the mother is at page number 36.
Hmm.
Not para number 7, that is regarding para at page number 37. May I not read just this one paragraph? The respondent submits that the petitioner has been absent as a husband as well as a father to the minor daughter. When the three of them were living together as a family, the petitioner spent most of its time at work, and on returning home from work, he used to go out to play badminton. On several occasions, the minor daughter has expressed to the petitioner to stay back and spend time with her. However, the petitioner turned a deaf ear to all her requests. The minor child has later expressed that she feels like a sinking boat. She feels like running away from home and feels like hurting herself. The minor child has expressed that she feels like she is not cute and lovable anymore, and hence the petitioner does not spend time with her. The minor child used to scream and shout in anger and pain. Her mental health spiraled down. The minor child was barely able to attend classes and focus on her studies. The minor child constantly complained about chest pain and uneasiness in breathing. The minor child expressed that she felt like jumping off the balcony from the third floor or running away from home. The petitioner was cold and distant, even though the minor child was feeling devastated and dismissed her behavior as a tantrum, and the respondent should not give in to her demands. The respondent, however, was aware that she needed medical intervention and took her to a therapist, Dr. Pavana Rao. The respondent submits that the petitioner did not give any attention to the minor child, which worsened things for her. As per the therapist's suggestion, and having seen no improvement in the behavior of the
Stating what was stated in the earlier one.
True. Yes, yes. But thereafter, the family court passes the order for visitation at Annexure G, page 40. Not the reasons are at page number 46.
We'll see the operative portion once.
Yes, the operative portion is that's page number 47. IA2 filed by the petitioner is partly allowed. The petitioner is permitted to exercise visitation, custody visitation rights of ward Naisha on every Sunday between 8 a.m. to 8 p.m. till the disposal of main petition. Respondent is directed to hand over the child to the petitioner on the specific time mentioned above, and the petitioner.
How the mother is agreed with this?
My lord, the child, my lord, has been, my lord, interacted with by two successive, your lordship's predecessors. But and they have the 27/8/2023, my lord, is the order passed by his lordship. This is Krishna Dixit. But he has found that the child, my lord, is capable of making her own mind. At that time, she was 13 years old. Lord, I understand that the father needs to have access to the daughter, but this is a case, my lord.
No, from what you have read.
Yes.
In all these paragraphs, the case of the mother is, father is not giving her the attention what she requires, which has ultimately led her to all this. Now, father has understood his mistake and is coming back. Now, before a therapist, wherever they are going, let the father interact for some time and understand.
Sure, my lord.
We will do that way.
Please, my lord.
Like
I am
before
always
the
ready, my
therapist,
lord.
there shall be an interaction. Let the therapist understand what's happening to her,
Yes, my lord.
because she cannot escape from the situation.
I'm sorry, madam. She says about 6 or 7 months ago, therapy has stopped. The therapist has told her that she's quite stable now.
No, it is like this. Child has a problem with regard to something. That problem has to be, we have to go to the root of the matter.
Yes.
And solve the problem.
True.
We just can't let her escape from the thought which is making her to have that kind of a mental state. So we have to deal with her problem. Her problem is the father and his lack of attention or affection that's not given to her. Let us see, let whatever that has to happen before the counselor. Counselor understand how the daughter is reacting. We'll look at it and accordingly we can pass further orders. Instead of having this 10 to 10 or 8 to 8, whatever the court has said, we will, for the time being, we do that. Then coming to the father side, what is that he is taking care of the welfare of the child? In what manner?
Lord, may I place these documents, my lord?
Give him a copy?
Yes, ma'am. I'll serve.
Take that papers.
Lord, as my learned friend have read, my lord, the order portion of the court below, Lord, that order was passed, Lord, on 20th of April 2021. But I request my lords to kindly come to the conversations over the mobile phone made by the father from my lords 17 September 2021, whatever available with me, my lord, I have placed before your lordship. From the date of order, my lord, he's been continuously trying to contact, interact, and build relation with the daughter. From 2021, my lords, there's one side messages your lordships can see. There is no response from the other side. There is no response at all, my lords. Lords, even my lords, the therapist, my lord, suggested, my lords, which is placed at my lord.
I think now at this stage, we need not go into that aspect.
Please, my lord, father is always open for the daughter, my lord. He is ready to, my lord.
We'll pass an order.
Please,
I've
ma'am.
asked you about the rights of the father. We have.
Yes, ma'am.
Yes, we have discussed on that. Now about the responsibility of the father.
Lord,
What is he doing?
Please, ma'am.
What is he doing? And what is he ready to do?
Lord, he is presently, my lord, is working as a software engineer.
What is his income?
My lord, I have already placed it before your lordships.
1.6 crores per annum.
That would be how much per month?
No, no.
I
That is
have,
not correct, my lord.
I have income tax returns with me.
Please, please.
I don't know how much it.
Yes,
The statements are made
yes,
based on
yes,
documents.
yes. Yes, sir. His earning monthly salary, my lord, is, my lord, gross is, my lord, 6,50,000. And my lord, after deduction, my lord, it is coming 2,75,000 per month.
4 lakhs is deducted per month.
Yes, my lord. There are certain, my lord, so for your lordship's consideration, Lord, the residence loan EMI is also, he is only paying, Lord, where the petitioner is residing, Lord.
No, forgetting.
I am
about that.
residing in a rented house.
No,
Yes.
let's not go into that.
Please,
Now,
Lord.
what about the expenses of the child? What are her school educational expenses, Mr. Arundam?
They have filed an application before the court below, my lords, in the MC case under section 24 and 26 of the Hindu Marriage Act, where they have given the breakups, my lord. If I if permitted to give, my lords, I'll place it.
Take
my lord.
that. Before the family court, you have filed
Yes.
this, it seems.
Maintenance application
In the application.
It is pending.
It is pending. There is no interim maintenance order is passed on the application which is filed, my lord.
2022 it was filed.
My lords, the maintenance, my lords, which is claimed in the,
No, we are not, will not go into the maintenance.
please,
aspect.
my lord.
We are only concerned as far as the child's expenses.
Yes,
are
my lord.
concerned.
If it is jointly agreeable, my
What
lords,
is she,
then
what is she earning?
she's also a working woman, my lord. I have placed the material before your lordships along with the memo.
Last 11 years, she has not worked.
No, no, my lord. That's all
Well, after
false,
the
my lord.
child was born, my lord, she was asked to stop working.
Lord, I have placed the material before your lordships, my lord. Kindly see page 8 onwards, my lord.
8 of which papers?
The earlier memo, my lord, which I have placed today, my lord, on 3/9/25.
Hmm.
Page 8 onwards, my lords,
Hmm.
is having 2 parlors, my lord, which is placed, my lord, at page 8 itself. One is in HSR layout and another is in Sarjapur main road. And thereafter, my lords, she is actively working, my lord. She is an makeup artist. And, my lord, so she is earning around 1.5 lakhs as per my instructions, my lord, per month, which your lordships could.
So these are from 10 years ago. May I make this one request, my lord?
Presently, it is active, my lord. That's why I am placing before your lordship.
May I make this one request, my lord? There's an order already passed by this honorable court on 27/7/2023.
What
Asking
was the
him,
order?
His Lordship Justice Krishna Dikshit's order. Thereafter, my lord, His Lordship Justice Nagaprasanna has passed an order directing the father to continue to pay the educational expenses and reimburse to the mother whatever educational expenses she
Was
has
it done?
paid. Sorry, my lord?
Was it done?
Yes,
Yes,
it
yes,
was
my lord.
done, my lord.
He has
It was
paid
done.
until this academic year.
My
This
lord,
academic-
on that,
For 25/26, he has not paid.
Then pay it. That order
my
is.
lord, that has to be, my lord, borne by both the parties, my lord, not only by the
No,
respondent.
that order is not
My
modified.
lord, that day, my lord, he
That
was,
order is subsisting from 23.
yes, my lord.
In the-
At that point of
at the
time, my lord,
At the time of finding the final orders, we will see that.
please, my
Now
lord.
we will grant visitation. You continue to
But
complete
I am,
it.
the respondent is also in the financial duress, my lord, because his father is a chronic treatment patient. Lord, he is going through the dialysis and all. He's having a severe kidney issues. And he is also, my lord, what exactly, my lord, what I can place before your lordship says.
No, but
Lord,
these many
for a
crores
moment,
of
my lord, for a
income
moment, my
per
lord,
year.
for a moment, my lord. He is residing in a rented house, my lord. The respondent is residing in a rented house. The petitioner
No,
is.
the expenses
Yes,
of the
ma'am.
child are
For a
coming to
moment.
how, no, how much they're coming to per annum?
Because 50%, 50/50, if it is shareable, my lords, then no issues, my lords, we
Yes,
are
Mr.
agreeable to
Arun
this.
Govind Raj,
She
how
had-
much it is coming
The educational expenses
per year?
about 7.5 lakhs. No, she has absolutely no income. What my learned friend is referring to is from 10 years ago. Lord,
No,
my
no.
only request is this.
Let them place material
My
before
lord,
the court, my
no,
lord.
very well.
Say.
Let the family court decide the maintenance application, my lord. If the family court holds that I have to reimburse medical expenses to him, I mean the educational expenses, I will reimburse. But let him pay for now.
But for a moment, my lord, may I request, my lord? 2010, if my learned friend could place a income tax return of a petitioner of 2010 itself, that itself clarifies, my lord, she was a working woman. She has she was working at that point of time. Now
We are
also she can
supposed-
work
We are
and when
supposed
she's
to look
working.
at what is 2010 income or what is the income now.
Lord, the petitioner, my lord, is suppressing that she is not working at all. I have placed a material to show
No,
that she is
I
actively working in
understand,
the.
and if you say that her income pertaining from the date of petition 3 years before that, I can understand.
Please,
Well,
Lord.
what is, how it is necessary that we have to look at 2010 income?
But presently she is earning around 1.5 lakhs per month. That is what
But
my
well, that
client's
will, our
instructions
trial
are.
court will take care of it. A coordinate bench of this court on what is the date of Justice Krishna Dikshit's order?
26/7/2023, my lord.
26/7/2023 has passed an order directing the father to pay the educational expenses and reimburse the expenses which are already borne by the mother. It is submitted by the land counsel for the petitioner wife, that petitioner mother, that already so that till 2024 he has paid the educational expenses for the academic.
May I secure instructions on this, my lord, because he's
That's what time
having,
was sought for last
he's
occasion.
having,
Record is submission.
please, my lord.
I'll record his
He's
submission.
having difficulties, my lord, at present. That is the reason I.
2024, and he has not paid the educational expenses of 2025. Land counsel appearing for the respondent father submits that he has to get instructions whether he has paid such amounts or not. Further, he submits that the wife is earning and the educational expenses have to be proportionately borne by both the parties. The said submission of the land counsel for the father is denied by the land counsel for the mother, stating that she is not earning after the birth of the child. It is also submitted that all these disputed questions of fact at this point of time cannot be decided once the same is decided by the court. If the husband is successful in proving the same, the consequences will follow. Next, coming to the visitation, according to the father, in spite of the order passed by the court, no visitation is granted to the father, and the father had no contact with the child. It is a submission of the land counsel for the mother that the child is not comfortable, and she is aged about now
15.
Now she is
now
turning
15
15.
years. She is independent and she can take her own decision. Next para. This court has the land counsel appearing for the mother has taken this court to through different different to the different proceedings and the complaints that are filed before the court as well as to the police. In all those complaints, what has been stated is the daughter is attached to the father, but the father had failed to spend any time with the girl, and which led to the girl developing psychological issues, which has to be to the extent that she has developed suicidal tendencies, and the mother.
That is completely opposite what my learned friend is not saying. What if I have placed one diary, my lord, after the consultation of the therapist, but I have placed page 3 of the memo, my lord, which happened. For a moment, my lord, this is necessary for to be, my lord, brought to the knowledge of this honorable. Page number 3 of the
Yes,
memo.
what is it?
For a moment, my lord. The diary which is written by the girl herself, the daughter herself. I may be permitted to read, my lord. Please. Dear diary, Mama is constantly going after my behavior and it infuriates me. And before this, as you have seen my writings, she is losing it. And before all this reaction, I felt like chucking a knife at myself because I am so tired and helpless. I don't know what to do. So I am, but how Mama have said no. So I am so restless and literally, I mean it. I can't sleep. I can't eat. Please, someone come and tell my mother or save me. Save me, because I can't stand this anymore.
Yes,
I
Mr.
feel
Arthur,
like
what is
crying
this?
so
What
bad
is-
and
where
can't
from it
even
is?
go to school.
Huh?
Kindly see the order.
Lord, there was one. Kindly see page number 49 of my
What
petition.
is that?
Lord, one incident when the mother told the child to do some homework or something in anger, she has written that. But kindly see page number 49.
You know, it is said that.
Well, Lord, both parties have agreed that they will live
That
separately
is
for the
not
child's
diary.
safety
The
against
diary
away
was
from the
not-
father.
Lord, the suggestion was given by the therapist herself, my lord.
And the child would have been with the father, not with the mother.
According to the father, It is because of the behavior of the mother. The girl has developed suicidal tendencies. The complaint and the looking at the other material, understand, and also what has been stated by the father that as per the advice of the therapist, they're saying separate, which has been stated in the petition filed under the JNWC. WC. This court deems it appropriate to pass the order or to pass the order pending disposal of the petition. Number one, the father shall exercise the visitation before the child comes in the mediation center, or you want to go to a particular person?
Not this, because the child has been going to this particular therapist, my lord, for the past.
Completely,
Pavana
Lord,
Rao.
from last 4 years, my lord, she is not allowed to meet the father.
Pavana
Lord,
Rao.
the position is, my lord,
Shall
completely.
exercise the visitation before the child psychologist and
Maybe
the
sent to the very same the therapist,
Where the
my lord,
parties
where
are consulting.
Pavana Rao is there. Pavana Rao, my lord, who
what
was,
I'm asking, Mr. Counsel, do you want to go to the very same
Yes.
therapist?
please, my lord, very well, very well.
Yes.
I'm ready, my lord.
To shall exercise the visitation before the very same
I'm sorry,
therapist.
Mallika, apparently the new therapist, my lord. Last 2 years she's going to Mallika.
Before Mallika, where is her?
I'll share the details.
Before Mallika, with Miss Mallika, the therapist with whom the girl is going for the therapy sessions. The subject to the availability of the therapist every week for 2 hours, the father is permitted to exercise the visitation subject to the availability of the doctor and the child, but it should be once in a week for 2 hours, and this shall go on for 4 weeks. That is, list the matter on 14th October.
Lord,
And by the time
exams are going on 24th, so I need it after 24th, my lord. The midterm exams are going on.
exams will be completed by
24th.
So if in the holidays, why not every 2 days?
Yes, ma'am.
In holidays, it is stated that the exams are from 24th. What she said?
Because of 9th standard, they're covering up portions for 10th also. She says so once a week, or like as the lordship suggested, she says would be more comfortable.
From 24th, once a week for 4 weeks, the father shall exercise the visitation. After that, the therapist shall address a report to the registrar general, to the registrar judicial, and the same shall be placed before the court. Once the report is received, this matter. Next, as per the order dated 27/7/2023, the father shall continue to pay the educational expenses of the child.
Lord,
Any default on the part of the father will be viewed seriously.
the reimbursement part also may be.
May I make one last request?
Reimbursement, my lords, may be recorded, my lords, because otherwise,
That I have already recorded
please.
in the order.
May I make one last request, my lord? Before the family court maintenance application is pending for 3 years, my lord.
Come up with the petition for that.
Very well.
Yeah.
Cell number 12, Fatima SK.
Yes.
I have filed the bank statement, Lords.
What is this?
Lords, this is regarding the maintenance.
Submitted as per the order passed for this for the bank statement is
Plus-
ready and they'll serve on the respondent. Who is the petitioner?
Plus petitioner is the husband.
Where is the impugned order?
Plus impugned order is at annexure
Page number?
69 to 73. I will come to the end portion, my lords, 72,
Yes.
in page 72, my lords. May I read from the earlier?
Petition is hereby directed to pay 20,000 per month.
Yes, my lords.
On what ground you are before this
My lords,
court?
may I just read the earlier para onwards, my lords? 7.1, page 71. There is no dispute regarding marriage of the petitioner and respondent. The petitioner and respondent are qualified persons is also undisputed fact. The respondent is MSc degree holder. And her monthly expenses is mentioned as rupees 35,000 per month. She has produced bank statement wherein she had only 1,501 as on 19/12/2022. This is the crux. The petitioner in the affidavit of assets and liabilities shown his qualification as B in computer science and income is shown as 13,000 per month. It is not his income. He shows this as the interest from the bank that he is deriving. In fact, he had no income at that time. I will come to that later. The petitioner filed IT returns from 2015 to 22. In the year 2018-19, his gross income is 2,47,259. The bank statement discloses that from 2018, balance is maintained at 50,000 and odd. In the year 2020, 26,10,408 was created to his account and it was transferred to another account out of this amount. This is where I had sought permission to produce the bank statement. The petitioner is having sweep transfer and as on 7/12/2020, he had rupees 78,80,890 amount in his account. The bank statement discloses that as on 5/7/22, he was holding 1,06,97,429.50. The account statement is sufficient to hold. Petitioner is having capacity to pay the maintenance amount. It is a duty of the husband to take responsibility of the wife and her maintenance. Therefore, considering the facts of the case, even though the respondent is MSc holder, the petitioner has not produced any documents regarding her employment. Therefore, I am of the opinion that the
Why
respondent.
have you not produced the salary certificate of yours?
Plus, I was not earning at that time. I lost my job much before because of the COVID. I had lost my job.
What is your income as of now?
Plus, I've still not secured a job.
Why?
Plus, he's not able to. He's qualified as BSc Computer Science.
How is he able to live?
That is the amount that he got from the earlier this thing. Therein he had deposited. That's exactly why I sought to produce the bank
26 lakhs where from you got?
Millards?
26 lakhs.
That's exactly why I produced the bank statement. May I just urge your lordships to go to the bank statement that I've produced on 4/9, Millards? 4/9, page 13, Millards? Page 13, ink page 13. I have produced the bank statement from Union Bank of India. Millards, page 13 to 18, 19, 20 is the bank statement. 20, I'm sorry, Millards, 22. Now, relevant portion will be page 15. My lords, may kindly look at page 15 on the right hand side, 25,01,181, my lords. Page 15, ink page 15. So every time this amount was deposited when he lost the job. Let's may kindly see this was created on 6/12/2018. Now, if I may urge your lordships to come to page 17, my lords, same 7/12/2019, exactly after 1 year, the same amount reflects here, 25,8,981. Now, if I may just
Page
come,
number.
Millards,
Which page number?
page 17. Page 17, right just after 1 year, 7/12/2019. Millards will get it at page 17. The date would be 5/12/2019, Millards.
12 is not in this page. It is in the
I'm so sorry, Millards. I think probably because of the stitching, it would have been under the deposits, Millards, 25,08,000. Can I give my copy so that I've just marked? See it. Millards, on the right, after that, after 1 year, 6/12/2020, page 19, again 26 lakhs 10,408. Now, this is the amount that the court observes in the order, Millards. At page 19, what is reflected is the amount that is reflected in the order. Now, page 20, Millards, 6/12/2021, again after 1 year, he does a sweep in transfer, 25,80,000. Now, this cumulative total, Millards, if your lordship may kindly see,
transferred to self
account. Because he has produced both the bank accounts, Union Bank of India itself. In this, Millards, 1,06,02,894 is the cumulative. Now, 4 times he has taken 25 lakhs sweep in transfer, he has done. This is the cumulative. No bank will give 1 crore just for 4 years, Millards. If that is the case, all of us then would be. Now, the court has come to the conclusion that he had the balance of 1 crore odd, which is not right. Based on this, 20,000 was awarded to the respondent, who is a double graduate, refused to stay with the petitioner and lead a matrimonial life, and has forced him to live in her parents' house, which he even tried.
What has happened to this amount, 25,80,000? It is still there.
It's still there. It's still there. Still there, my lords. Out of that interest only, that is 13,000 he gets every month. That is the income that he is getting, and is, of course, looking for jobs desperately because his expectations are high.
What is the wife doing?
His wife is not earning. She is just staying at home. No children.
Then whose responsibility it is to take care of her?
But that is what she's saying. Earlier she used to earn. Now she's also not earning, is what they say.
No, but you have the bank, you have the money in the bank, 25,80,000.
No doubt, the wife who is equally qualified is also supposed
For
to.
also equally qualified and not getting a job. Same thing with her.
She does not want to lead life. She hardly stays for few months, goes back. She forces him to stay in her parents' house, which he did.
What is the MC that is pending?
Divorce petition, my lords.
Is pending.
It's pending.
Pending MC case.
Who filed MC?
I have filed. Husband has filed. Because she has refused to come and lead a matrimonial life.
What is his?
What other option?
What is her?
A petitioner submission false.
No, not
Ba-
all that.
Bank statement.
Is it that she wants to join the husband?
No.
She doesn't want
Separate.
But then in that case, why don't you? He also wants divorce.
No. Mediation failure success. Failure. 2 cases. MC case. Family case.
What is that?
I don't know.
Mediation.
Yeah, mediation failed because she refused to give divorce.
No.
She did not.
Petitioner court not attend. You are present.
In case
Learning.
he wants divorce, your client do not want to join the husband. What for they are fighting?
No.
I'm ready to keep my party present before your lordship. I have no difficulty.
No,
They
lordship.
can keep.
Family court petitioner not submit. False submission.
The partition.
Fake document.
I'll keep my party present.
On
Next state party present.
Oh, fake document you can.
Balance bank Canara Bank old.
Yes.
Yella fake document.
Yes. Next.
Cell number
Let's,
17.
On
Wednesday.
Cell number 17.
How many passports are there in this list? Yes.
A date may be fixed. They took adjournment without informing me.
No. You are appearing for the
Respondent. Please.
This court on in the morning a learned counsel for the petitioner has submitted that. He has sought for time, and on a query from the court.
Can I make one more submission? Last time your lordship had said to fulfill the obligation of pending
It is submitted
2,96,000
that
also.
the same is informed to the learned counsel for the respondent. Basing on that, this court has adjourned the matter and directed to be listed in the month of November. In the forenoon, in the afternoon, learned counsel for the respondent submits that there's no such information. No. It is not informed to him. Without informing, it is taken. The adjournment is sought. List this matter for dismissal tomorrow.
Cell number 23. 23. Jamuna Bayad for
This is what
petitioner
you
Proceedings.
my lord.
What did your client say?
He's ready to pay 15,000.
That's what I said. You were very generously saying that I will take care of educational expenses. I have entire educational expenses, medical expenses.
Because medical
Yes.
expenses insurance is there, even for both.
What do you say?
My lords, I took instructions with regard to the same. I took instructions from my client also, my lords, with regard to this 15,000. So what she told was before the trial court also, this question came up and they told for 10,000 then. So she has produced all the bills and I've also got copy of it, my lords. It is the matter of fact in the trial court as well. She says, actually for the child itself, more than 30,000 she's spending, but she's taken all those rent and all of it. Therefore, 20,000 she
Here it
wants.
is there. And the mother's income, an amount of rupees 35,000.
As per the
45,
order.
my lord.
As per the
45.
order.
Father's income is?
99,000 plus other income.
No,
Income
not
is
other.
99,000 per month. and the mother's income is an amount of rupees 35,000.
No, 45. 45, my lord.
As
I am
per the
having
Huh?
her
As per
bank
the order, my
statement.
lords, it is 35,000.
Not as per the order, your statement of assets and liability.
Statement.
No, she's not at all. She was a guest
It is not,
faculty then.
we are not concerned about not at all now. As per the
Bank statement. my
bank
lord.
statement, as per the bank statement, her, the mother's income as per the bank statement is an amount of rupees
5, my lord.
45,000, an
Yes.
amount of rupees 45,000. The child is having medical issues and the mother has to take care of the child who is suffering with the medical issues, and also she has to take care of herself. The submission that the father has paying the insurance, that will not come to the, that will not help the mother in bearing the monthly expenses. And as he, monthly expenses, the court, considering all the facts, has rightly granted maintenance of an amount of rupees 20,000, and this court finds no reasons to interfere.
20,000.
Grateful, my lords.
Accordingly dismissed. Yes, next.
Case number 28. 28.
Petitioner, my lord. Petitioner filed with the enhancement petition, my lord. Court is awarded 3,000, my lord, to child education and medical expenditure, my lord.
Yes, what is your income?
My lord,
15,000 rupees.
Huh?
15,000 rupees income.
Court had granted?
3,000 rupees,
3,000
my lord, child education. my
The
lord.
mother is also working, my lord.
My lord,
We'll
is also
increase it by another 3,000.
It is not my
Yes.
mother. The mother of the respondent is also suffering from cancer, my lord.
Oh, my lord,
He has to
no.
look after the mother
On
also.
property and
The
more
father,
than,
What is the income of the wife?
25,000 rupees, more than my income, my lord.
Huh?
25,000 rupees she has
Is it
income.
so?
no, my lord.
Well, it is
Now
there in the-
job is left, my lord, mother and
What has been recorded by the court? That's what I'm
25,000
asking.
rupees,
25,000.
My income is recorded 15,000 rupees is taken.
All
State-
affidavit filed, my
bank-
lord. Own house is there.
Statement of
And
bank I have
agricultural
produced.
income is also there, my lord. More than
Agreed with the orders passed. I number 3 in MC number 13173 of 2021, whereby the court had granted maintenance of an amount of rupees 3,000 to the wife, to the child from the date of filing of the IA number 3 till disposal of the petition. The wife is before this court seeking seeking enhancement of the maintenance to the son or daughter?
son.
man.
To the son. Both the wife and husband are working. According to the husband, his salary is 15,000. According to the wife, her salary is 25,000. According to the wife, the husband is having a own house, and he is having and other properties. According to according to her, the wife is living in a rented house.
Rented house.
Rented house. She has to bear the expenses of the child and also take care of herself. The court had granted 3,000, and according to the learned counsel to the petitioner, that is not a just and reasonable compensation. It is a case of the husband that he has to take care of his mother.
Mother, my lord. She is suffering from cancer.
She is suffering from cancer.
Document is produced.
And the amount that is awarded by the court is reasonable. Next para, having heard the counsels on either side, there is some material. Admittedly, wife is earning 25, husband is earning 15,000. Wife is the one who is taking care of the child, and admittedly, husband is having a own house. And the court had granted 3,000 in these facts and circumstances. This court is of the view that the order of the tribunal needs to be modified. Accordingly, this court is passing the following order. The order of the tribunal is order dated so and so is modified, and an amount of the maintenance is enhanced from an amount of rupees 3,000 to 5,000. Accordingly, the appeal is the petition is partly allowed. Next.
Case number 29.
For the petitioner, your ladyship.
Appearing for the
Copy of the
respondents,
reply
my lord.
affidavit to my learned friend, your ladyship. No.
My lord, we have just been served the copy of an affidavit that they have filed.
Submitted the affidavit is just now served. lists the matter on 21st. Yes, 30th.
Bill number 30.
Petitioner, my lord. For the respondent in this case. My lord, there was an application for maintenance filed by the wife. In the court below, the husband had filed a petition for restitution of conjugal rights. Now, despite bringing it to the notice of the court below that there is already a maintenance order granted in a criminal miscellaneous filed by the wife.
There is impugned order.
My lord?
Impugned
Order, yes. My lord.
Difficulty is when it is in Kannada.
I have the English translation,
Please,
my lord.
Please.
Take that order.
My lord, the reasoning is at paragraph
Filed by the
18.
applicant respondent is partly granted. As a result, is ordered to pay 2,000 per month. And 5,000 are expenses. Yes. Now, what is granted is 2,000.
Yes, my lord.
And in
Plus
the other,
5,000 litigation
what
expenses.
is granted in the other proceeding?
5,000, my lord. My lords will find that order annexure G, page 52.
5,000. And all put together, it is 7,000.
Yes, my lord.
And what is your income?
I'm a daily wage worker, my lord. I am a farmer. In fact, the wife has left the husband because he's a farmer and she's refused to come back and
working.
She's working. She's refused to file her statement of liabilities and assets before the court below.
Where do you get them?
That is my statement, my lord. And in fact, I have made this statement under oath also in my objections, my lord. If I could take my lord.
Where did the court consider about this?
Yes, my lord. So when we look at the order, the impugned order, paragraph 18, my lord, there is no consideration whatsoever to the affidavit of assets or liabilities. Paragraph 18, my lords have it.
Yes.
I apologize, I haven't numbered the pages. My lords have it. As already detailed above, in fact, the reasoning is just this, 18, 19, and 20. As already stated above and closely observed, it becomes clear that there are disagreements between the applicant and the respondent as they made allegations and counter allegations against each other. However, the allegations made by the applicant against the respondent in the application, the counter allegations made by the respondent against the applicant in the written complaint can only be decided after full trial of evidence, and it is not possible to reach any conclusion at this stage.
Come to paragraph 20.
The respondent has submitted 10 RTCs to prove that the applicant has income sources, and these documents are recorded in the name of the applicant's father. Additionally, the respondent has submitted the applicant's bank statement. According to the records, it is evident that the applicant receives a salary credited every month. By submitting these documents, the respondent has proven that the applicant has income. Moreover, although the applicant claims to have health issues, he has not submitted any documents. Furthermore, the applicant has not proven that the respondent has sufficient income sources. In this situation, it cannot be denied that the respondent and her daughter incur significant expenses for their sustenance and education. Therefore, considering that an interim maintenance...
To understand this applicant, she refers to he, she, what is that? Who is applicant? Applicant is a wife.
Wife.
Then the respondent has submitted the applicant's bank statement.
My lord, I think the applicant has to be read as the original applicant in the restitution of conjugal rights petition. So the respondent will have to be the wife, my lord. Applicant is the husband.
Salary credited every month.
There is no salary, my lord. There is no salary of the husband. In fact, the husband has produced the salary slip of the wife. She is working in a tailoring firm. I've produced the document here, my lord.
How much she is receiving every month?
She is receiving about 12,000, my lord. And the husband has paid the school fees of the child.
How much?
I've produced an annexure D, my lord. Page 36.
How much?
About 18,000, my lord. There are two receipts.
18,000 is almost 1,500 per month.
Yes, my lord. So the husband has paid the child's school fees. Husband is also paying maintenance under the criminal miscellaneous. Now he has been suffering from bilateral varicose veins. We produce medical records. Medical records are not looked at. We also pointed out that the RTC that is produced pertains to the joint family undivided property in which he has no right.
How many acres?
My lord, I'm not aware of that. The
It is 10
RTCs are here. RTCs are here, about 39 guntas, my lord.
10 RTCs for 39 guntas.
I have been instructed there is only 39 guntas, my lord.
Yes, Mr. Counsel.
One thing, the court considers there is income sufficient, regular income to the husband. So 2,000 is awarded, madam.
No,
Please.
you are earning 12,000 per month.
Not, I think I've not produced, I'm not aware of that.
No, court has seen it. It's recorded by the court.
No, madam, court records that applicant has produced means I think confusion whether.
That is confusion that created applicant.
Please, that's what I want to calculate with
But it is your salary. I mean, the wife's salary is 12,000.
Please.
And husband, according to him, is a daily wage laborer. There is no other evidence to prove that he is not.
Please.
Even if we take 15,000 as his income. Now, in the other proceedings, how much is granted?
5,000.
5,000. No, 5,000 with your 12,000, your income becomes 17,000.
Please.
Husband income, it becomes 10,000.
And he's paying 1,500 school fees, my lord.
Let that continue. We'll set aside this order.
Right. One request, that subject to lordship says. But it's kindly refer the mediation also. We try to talk, madam. That's the reason. I think it's my.
My lord, we've been trying to mediate and have her come stay with us.
There is a scope of settlement.
I think because
both the parties.
My colleagues
are
matter.
directed
That's the
to
reason.
appear before they stay in Bangalore.
No, my lord, in Maddur.
Both of them are directed to appear before the mediation center at Mysore.
Maddur.
Maddur,
my lord.
Mysore, it is Maddur. There won't be a mediation center. You have to go to Mysore.
Very well.
Mediation center, Mysore, on 24th of September.
20.
After the report is received from the mediation.
Obliged, my lord. Interim order may continue, my lord.
Interim order earlier granted is extended.
Deeply obliged.
Bill number 31, adjourned 32.
Yes, 32.
Leader B, petitioner Saubhagya.
The interim maintenance, lordship.
I have produced
Page
the
number
education and medical expenses
86.
of the child.
Ink page number 86 is the order portion. The interim maintenance has
In all these 25 matters, 32, 33, 34, and 35 give a date.
35 is already given.
32, 33, 34 give a date. Next week. Yes.
25, 9.
Yes.
Bill number.
Any interim order is there in that extent?
There is I'm pressing interim order. There is a 20, there is a order for the payment of the amount. The 22nd is the next date of hearing for payment.
Before 22nd,
Kindly be
this is
interim.
matter.
Kindly be interim order maybe.
This is matter before 22nd.
I will part payment. I will make, Your Honor. Kindly necessary order.
Yes. List the matter before 22nd a day. We'll dispose of finally.
Yes, ma'am.
Yes, next.
Much.
And 22nd is.
Before that.
Before that, what is it?
17 is when?
17.
Next date. 19. Yes. Call the next list.
List number 3. 19. List number 3. Cell number 1. Gurudev Prasad KT for appellant.
For the appellant in the connected.
The dispute is with regard to the contributor negligence. His contention is that there was a
It's
steel.
already calculated.
Your lordship has calculated, and his case is, so far as negligence is concerned, there was a steel barricade in the middle. He jumped that barricade, and because of his negligence only, this accident took place. That is not correct.
Some 5% is shown. 5%. What was the?
Tribunal has fixed 10%, only 10%.
Huh?
Tribunal has fixed contributing negligence of only 10%.
If it is reduced to 5%, it comes to 19,19,803.
Lord, actually, my lord, he is not supposed to cross the road, national highway. And accident has taken place in the middle of the road.
What was the compensation that was awarded?
My lord, total compensation, my lord, awarded is rupees, my lord.
18 lakhs 30,000, and after 10% deduction, 16 lakhs 47,000.
Even on that count also, you are getting good Good hike is there.
But income,
Oh.
income taken by the tribunal is only 12,000.
Now after calculate, now we have taken it as 14,000.
Yes, correct.
So with 25% future prospects, 3,500, 17,500. The deduction one third or something, 5,833.
Yes.
Your income is 11,667 into 12 into 14.
Yes.
Loss of dependency is coming to 19,60,056. 3 into 44, 1,32,000. 36,000 and 10,000. It comes to 21,05,056. So in
Yeah,
this.
one third has been deducted.
Huh?
One third has been deducted towards.
05, 056.
But as per the
1 minute, 1 minute. Six. It comes to 18 lakhs 94,000 5504. If we take 10%,
10%.
we'll take 10%.
10% is very less, my lord. It's a national highway. They should also take care of themselves. It cannot be because the national highway is meant for fast movement of the vehicle only. Otherwise, what is the purpose of investing crores of rupees, thousands of crores of rupees for
That is
erecting
why
the.
10% is fixed on.
He is not supposed to cross the road. My lord, I have relied upon the judgment of this honorable court, my lord, ILR 2004 Karnataka.
Sorry, sir.
Sorry, I have not brought the judgment. I think. But I have not brought the judgment. But in that judgment, my lord, this division bench of this honorable court, my lord.
I'll record. Please tell the citation what you are.
Please, my lord.
Agreed with the word past tense.
Please, my lord.
MVC number.
ILR 2004 Karnataka.
Write the decision. MVC number 6125/2019, dated 27 January 2021. Whereby the tribunal has awarded compensation of 18 lakhs
30,000.
18 lakh 30,000. The claimant is before this court seeking enhancement. Also, the contributory negligence that is fixed at granted 16 lakh 47,000, and also fix the contributory negligence at 10% on the deceased. Claimant is before this court by filing WP MFA number 5393 of 2022, and the KSRTC is before this court questioning the contributory negligence of 10% that is fixed.
I have referred to in para 7 and 8 of my appeal memo.
No.
Both are division bench judgments.
APSRTC.
Andhra Pradesh Road Transport Corporation.
The claim petition is filed seeking compensation of
30 lakhs.
an amount of rupees 30 lakhs for the death of the deceased in the accident. It is a case of the claimant that on 7/1/2019 at 1:30 p.m. when the husband of the first petition, when the deceased was crossing the Kolar Bangalore road slowly and carefully near Maruti car showroom, Hoskote town. At that time, one APSRTC bus driven by its driver in a rash and negligent manner.
Exhibit P4 is the sketch, my lord, kindly.
Hit the deceased and he succumbed to the same. The tribunal, where is that issue with regard to contributory negligence?
The tribunal has not framed any specific issue regarding contributory negligence, but our contention is specifically we have taken tribunal, that is why we have filed appeal.
Internal page 17.
Internal page?
17.
Para 6. In almost all MVC cases, one single issue will be there.
The court has observed that after a full-fledged investigation, the police have filed a charge sheet against the driver of the the driver of the bus. Further, court has perused the spot, marger and rough sketch of the accident took place and the deceased, as the deceased is crossing the Kola Bangalore NH road near Maruti car showroom. At the time of offending vehicle came from Kola towards Bangalore and dashed to the accused. And the perusal of the sketch discloses that the accident occurred near the divider of the main road. Therefore, in case the deceased is crossing the road, observing the vehicles on the road, definitely the accident could not have happened. When the pedestrian crossing over the road at any place other than which is meant for pedestrian crossing, the responsibility for causing the accident more often than not will have to be say pedestrian along with the vehicle driver. If at all, the deceased could have seen the offending vehicle and allowed it to pass before proceeding to her destiny, the accident would have not have occurred. The respondents have the insurance company had relied on
APSRC Corporation.
the judgment of the High Court of Karnataka, this court, in case of Mrs. Leelam Kika versus BMTC, arising out of MFA number 5546 of 2018, clubbed with MFA number 6746 of 2018. And also ILR 2003 Karnataka 1104, in case of Kosappa Pujari versus K. Sadaba. And considering the said judgments, the court has observed that the respondents, the deceased is also responsible for the accident, and the respondents have failed to prove the sole negligence of the deceased and apportioned the contributory negligence at 10% on the deceased, 90% on the insurance company. When it comes to the compensation, the court had taken the income at 12,000 and awarded the compensation as per the table given below at paragraph number 23. And as the compensation comes to rupees 18,30,000, as the liability is for 90% on the APS RTC, the respondents were directed to pay an amount of rupees 16,47,000. Next, when counsel for the claimant submits that fixing the contributory negligence of 10% is not appropriate, as no evidence is adduced by the insurance company to show.
My lord, we have examined the driver and conductor.
No evidence is adduced to show proper evidence to show that the accident had taken place solely because of the negligent driving of the negligence of the deceased. It is submitted that this accident had taken place in the year
2019,
2019. The court ought to have taken the income at 14,000, but the court had taken
12,000.
12,000 as income and granted the compensation, which is not appropriate and just and reasonable compensation. Next part. When counsel appearing for the APS RTC, relying on the aforesaid judgments before the trial court, this is a different judgment which are given to her.
Both judgment I have referred to in para, in grounds it is
And
there, my lord.
submits that when on the highway, when the place where there is no scope, where there are no pedestrian crossing, when the deceased has crossed, he himself has complete compensate, has only because of his negligence the accident had taken place, and the court ought to have held that there is negligence on the part of the deceased, and in fact it should have been 50-50%.
One case only 50%, another case recent judgment 30%. Considering that judgment,
50%.
Division bench has considered 30%.
Submitted that the negligence ought to have been 30%, and the court had taken only 10%, which is not taken 10%, and the same needs to be interfered with. It is submitted that the compensation that is awarded is just and reasonable. No enhancement is called for. Next part. For the counsels on either side, there is a material not record. The tribunal had rightly discussed about the contributory negligence and has rightly held that the deceased ought not to have crossed the road. The accident has happened in the afternoon at 1:30. If the driver of the bus, was he careful in driving the vehicle, he would have avoided the accident. And except by examining the driver, the evidence of the driver would generally be in favor of he tried to say that there is no negligence on his part. The basing on the evidence on record, the court has rightly held that there is 10% and has rightly apportioned the contributory negligence at 10%, and this court finds no reasons to interfere. Then coming to the quantum of compensation, the the accident has happened in the year 2019, taking 14%.
14,000.
14,000 as income, 25% future prospects as he is 42 years old would come to 3,500, that is 17,500. As there are three dependents, 1/3 has to be deducted towards the personal expenses, that is 5,833, and his contribution to the family would be 11,667 into 12 into 14. Under the head of loss of dependency is entitled for 19,60,056. Then the 3 into 44 towards loss of consortium, 1,32,000, funeral expenses 36,000, and legal expenses 10,000. Altogether, 21,05,056 is a compensation. As the contributory negligence is fixed at 10%, it would come to 2,10,505. The insurance, the RTC is liable to pay 18,94,504 at the interest rate 6%. Accordingly, the appeal of the insurance company, the appeal of the RTC is APS RTC, that is MFA number so and so is dismissed. Appeal of the claimant so and so is allowed. Yes, partly allowed by enhancing the compensation.
The amount, amount in deposit may be transferred to the
amount in deposit shall be forthwith transferred. Yes, next.
Number 2. Jahannavi P. Joshi for appellant. S.V. Hegde Mulkan.
On the last date of hearing, my lord, there is connected appeal which is filed by the claimant for enhancement. That is posted for dismissal today because for non-prosecution they have not appeared. Plenty of opportunities were given.
It is not in dismissal, it is in part heard.
No, 2.1, my lord, 2.1.
2.1 is not in dismissal, 3 is in dismissal.
For dismissal.
Look at the cause title. 2.1 is in part heard.
Connected with my lord. If my lord can find that.
2.1
Yes.
MFA 1406.
1406.
That is not for dismissal.
For dismissal.
But it is still listed in part.
Why, my lord, they did not appear on so many days. In fact, last hearing, my lord heard, and my lord said that if
2.1.
Yeah. Last order, my lord, 19.8. Once we can get away with this, we can proceed with the my matter. My lord, on 19.8, in MFA number 1406, lists the matter 10.9. My lord's order.
On 11/7/2025, there is no representation on behalf of the claimant, and the matter is directed to be listed
11.7, yes.
on 7/8/2025. When the matter came up on 7/8/2025, the matter was directed to be listed on 14/8. And on 14/8, they are listed to directed to be listed under the caption part heard. On 19/8, again, there is no representation on behalf of the appellant in MFA number 1406 of 2023 and directed the matter to be listed under the caption for dismissal on 10/9/2025. Today also, there is no representation on behalf of the appellants. Accordingly, the appeal is dismissed for non-prosecution. Then come to the.
Now, my lord, coming to
Yes.
my appeal.
Yes,
My lord, the
1,555. Yes,
My lord, the date of accident is 4/5.
you are the owner of the vehicle.
Erstwhile owner, my lord.
Ah.
Because
So,
as on the date of
we
accident.
come to the order.
Yes.
Where is it discussed about
My,
your liability?
my lord will find it at page number
22 paragraph
page
17.
number 41, para number 18, my lord, where the order goes against me. May I read, my lord? The respondent number 2, that is me, filed written statement. In his written statement, he has stated that the auto rickshaw bearing number KA513081 was sold by him to third respondent, and he has transferred RC and other necessary document to the third respondent, but only the insurance policy standing in his name. In support of his written contention, he has produced Xerox copy of sale receipt, transfer of insurance and delivery note. The respondent number 2 did not step into the witness box and produce original RC record to
So,
show
no,
transfer
no.
of
Date
RC.
Date of accident?
Date of accident, my lord, 4/5/2019.
When did you transfer the
28/9/2018.
transfer of RC?
RC. I have produced I have filed an IA producing this document. That is my IA number 3, my lord.
Then what is the, come to the award?
Award, my lord. Award is 6,95,000. That my lord will find that.
So pay and recovery is ordered.
Pay and recovery has been ordered.
1 minute.
Yes.
Now, which respondent is the transferee?
The third respondent is the transferee.
Has he represented before the court?
Now,
He remained
Mr.
expert.
Anand Kumar, who is R2 in this present appeal, my lord, he in the trial also, my lord, except filing wakalat, he did not participate in the trial. Even in this matter, though notice when on the address, not served, paper publication, substituted service done, all this while not appeared. He has not even filed his defense.
Yes, as far as that will clarify.
My humble submission is, your lordship may kindly appreciate, before making any statement before this honorable court, my lord, notice have been issued to him. He contested the matter before the tribunal. But my lord, except by protection.
The only reason is RC not filed. RC is filed
RC
before
and
this
no
court.
documents have been produced.
It is
It's
fine.
produced
I
41 rule
Before
27.
the tribunal, I am not saying about here. Before
But
the
fact is
sir,
not
kindly you have submitted. Wait for a minute. Before the tribunal, he has not produced any document. He has not led any evidence before the tribunal. No, first
Many
time.
times you will consider your
And that's why, my lord,
applications also
my
under
lord, no,
41
my lord,
27.
what he says is that he
I
got.
think this objection should be from the claimant, from the other owner, but insurance company cannot have any objections.
Yes.
You will
I have no
recover
objection, my lord.
either from this person or that person. So you can't have any
He
difficulty.
remained ex parte before the tribunal, my lord.
I was not ex parte.
Not you, third respondent.
Then you,
My lord,
My humble submission,
if
one
that
submission-
is the contention
My
of
humble
my
one
learned
submission,
friend.
my lord. My submission is this, my lord. Your lords may kindly appreciate. He could have done all this effort.
My lord, my humble submission.
wait, Mr.
Please.
Counsel, how many times you will submit? Let him complete. For every sentence, if you want to respond, we can't go ahead.
My apologies.
My lord, now your lords may kindly appreciate. If necessary, my lord, your lords may kindly remand the matter.
No. not
Now
necessary.
he has produced it before this honorable court. We have also no opportunity of cross-examining the parties before the tribunal, and we have to verify.
Paul, why did you not file your objections to that?
Well, question is objection, my lord. Question is not regarding the objection. They have to produce it before.
When an application is filed under order 41 rule 27,
Yes, my lord.
this objection, what you are saying, ought to have been taken long back before this court, which you
No,
have
my
not
lord,
taken.
whether objection is filed or not, facts.
If
Facts.
objection is not taken,
My
what
lord,
is there for
facts
the court?
remains, my lord. He had not, my lord, this deliberately, my lord, he had not done all this aspect, and he had not led any evidence.
Yes.
And ultimately, my lord, if your lordship is holding, my lord, the third respondent is liable, your lordship may kindly pass on liability on him.
Agreed with award for past in MEC number 3938 of 2018, dated 2nd September 2021, on the second on the appellant by the, as he is the owner of the vehicle, and also and a pay and recover order is passed by the tribunal, the second respondent in the MVC is before this court. The claim petition is filed seeking compensation of an amount of rupees 14 lakhs for the injuries sustained by the claimant in the accident. It is the case that on 4/5/2019 at about 4 p.m., the claimant was proceeding on Hero Honda Splendor Plus motorcycle. At that time, all of a sudden, Bajaj auto rickshaw bearing registration number KA 533081, driven by its driver at a high speed in a rash and negligent manner, dashed against the motorcycle. The tribunal has observed that the respondent number 2, who is the appellant herein, has filed the written statement. In his written statement, he has stated that auto rickshaw was sold by him on 3rd September and he has transferred RC and other necessary documents to the third respondent. But only the insurance policy is standing in his name. In support of his written statement contention, he has produced the Xerox copy of the sale receipt, transfer of insurance, and delivery note. The respondent number 2 did not step into the witness box and produce the original RC record to show transfer of the RC in the name of respondent number 3. There is no material before the tribunal to show that the auto rickshaw is in the name of third respondent. On perusal of the insurance policy, the court had passed an order that the appellant herein is the owner of the vehicle and is liable to pay the compensation, and the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. Then counsel appearing for the appellant submits that, in fact, the accident had taken place on 4/5/2019. On 28/9/2018 itself, he has transferred the RC. He submits that there are latches on the part of the appellant. Where is that application?
IA number 3, my lord.
That there are latches on the part of the applicant in filing the original RC before the court. He submits that now he has filed an application under Order 41, Rule 27, to receive the same as an additional document, and no objections are filed by any of the respondents. And as for the same, it is transferred on. Where do you get the date?
My lord will see the B extract. Here, my lord. Present owner Anand Kumar, and below that the address and with effect from, my lord will see. Below Francis, my lord. With effect from 28/9/2018.
What is your name?
My name is Vasvi Prasad.
Anand Kumar. Owner's name Anand Kumar.
Yes, my lord.
Date, where do you get the date?
My lord, below Francis, my lord will find.
28/9/2018. It is submitted that it makes it very clear that he is not the owner of the property and there cannot be any liability on the appellant. Next paragraph. The notice is served on the respondent. No respondent. There is no appearance on the owner. That is, who is the third respondent. Alleged third owner, the third respondent. No, though the notice is taken by way of substituted service and notice to him is held sufficient. The claimants, though filed an appeal, have not appeared before the court on several occasions. Hence, the same is dismissed for non-prosecution. The counsel appearing for the insurance company submits that the matter may be remanded to prove that whether it is a original document or not. It is further submitted that the appellant, if at all he is the owner of the he is not the owner of the vehicle, he would have appeared before the court and he would have he would have appeared before the court and he would have produced the original RC. And at this stage, he is not entitled for protection of the same. Next part, having on the conscience on either side for the material on the court. This court had perused the evidence that is placed under Order 41, Rule 27, and has no objections or filed, and this court, looking at the said document, it appears that the Anand Kumar, who is the respondent herein, is the owner, and the same was transferred to him on 28/9/2018, and the accident has taken place on 4/5/2018, at 4/5/2019. As on the day, he is the owner of the vehicle. Hence, in that view of the matter, the hence, in that view of the matter, the application, that order 41 rule 27 application is taken on record. The additional evidence is taken on record, and IA is ordered. And in the light of the same, the order of the tribunal is accordingly, this court is passing the order. The order impugned, the judgment and award passed in so and so is modified, and the amount has to be paid by which respondent he is here?
He is, my lord, R2 in this appeal.
Respondent number 2 in the appeal, who is the owner of the vehicle, is liable to pay the compensation, is liable to pay. And the court has already ordered that there is a principle of pay and recover. The insurance company shall pay the amount and recover the same from the second respondent. Yes.
My lord, I deposited 25 lakh.
The amount in deposit, the appellant is at liberty to withdraw. Yes.
Number 3.
Much of it.
Number 3.
All these dismissal matters now don't call the matters. It's already 4:50.
Yes.
Yes, delete from the caption dismissal. Or
But
else,
this matter can be
under the
disposed
same
of.
caption.
This matter can be disposed of. It is respondents are not
But
served.
not now. But not now. All these matters which are in dismissal, give it another day, where there is.
Yes, matters. On 17 19.
Yes, next
Serial
come to
number for orders.
orders.
For orders, matter serial number 8.
This also 8. Anybody's representing?
No, serial number 6 for dismissal it is posted. Serial number 6 posted for dismissal. But there is no reason to post it for dismissal because we have appeared and it was only for taking steps. Whatever it is, I am not.
No, why they have posted? I have not looked at it. I have not directed to post it. Why it is posted, I don't know. Where is it? Why should we why it is posted for dismissal?
Which one, sir?
No, there is an order.
Dismissal and
No, give the file.
Serial number, sir.
Because in all the orders where the orders are not complied with, and there is a default order, if it is not complied, it is posted under that caption.
There were 2 appeals, one for the claimant, another by the insurance company. In one case, everything was complied. In the other one, of course.
That's why what I was telling them is, unless and until there is an order of the court, don't post it for dismissal. If the orders of the court are not complied with, it need not come in dismissal. It is an order of the court whenever it has to come in dismissal. That won't come in dismissal. Why it will come in dismissal?
Serial, sir.
Serial number 6.
No,
Serial number 6.
No, 3 too. I think I have posted it for dismissal because there is no representation.
Please, madam.
Then 4.
Serial number 4.
I appear for appellant.
Why it is in dismissal?
On that
It's a
day,
bit to appear for the corporation, madam.
I was held up in the other court.
So that is, because he's saying, that's why I'm asking every matter why it is in the list. Then 5.
Serial number 5. Girish B. Baldare.
That is also because you're not there. Yes. 6.
I am for the appellant, my lord. But I was present on that day.
Next appeal 6.1.
That is mine, my lord.
Give that. What is written? There is no representation on behalf of the appellant in MFA number 5218 of 2022.
Yes.
That's why it is listed for dismissal.
I was present.
There is an order. There is no representation on behalf of the appellant in MFA number 5218 of 2022. List this matter under the caption for dismissal on 10/9/2020.
My dismissal, the other case was for taking steps.
No, are you referring to MFA 52186?
They were connected.
So he was present.
I don't
He
remember.
was present.
Even that is also not for taking steps. My case is not for taking steps.
Anyway,
Yes.
it's all right.
So there is a reason for coming up on dismissal caption. Yes, all these matters, please give one day.
8th of next.
17/9.
8th.
Serial number 8.
My lord, you want some other date, my lord?
Some other day.
Which, yes,
18.
please.
Yes, next.
8, 9. 18.
Claimants appeal. Your Lordship. Claimants also have filed appeal.
You can come a little further.
Claimants also have filed appeal.
Yes.
3130, serial number 9, Your Lordship, this is list number 3.
List along with so and so. Write it on a paper and
Yes,
give.
Your Lordship, yes.
Yes, 10.
Serial number 10.
Appellant, my lord, the appellant died, so I need some time to bring the LR submitted.
Appellant died. It is submitted that the appellant is no more for taking steps. 10 days time is granted.
Serial number 11. AM
Please.
Venkatesh.
In this case, I appeal for the appellant.
Yes.
I appeal for the appellant.
Yes. Or no release of amount returned with office of.
We are challenging the liability. Can be disposed of any date may be fixed. Pay and recovery.
Give a date. Pay and
Pay and
recovery.
17/9.
Yes.
Serial number
12.
12. Deepadvi Shastri.
In this case, involvement of vehicle is in question, my lord. Any date may be fixed for.
Some other date in August.
Any
The
date.
list is matter in the month of November. 13.
Serial number 13. Pradeep B.
I appeal for the.
For respondent number 1, 2, 3 matters.
Will condone the delay. I number
Please.
1 of 2020. Huh?
50% deposited. That I filed the application.
Are you
Have
on
any date may be fixed, my lord. I have no
district next week? Case is next week.
instruction whether
Date may be
on what ground.
They'll give the date. 14.
Serial number 14.
Appeal for respondent
Number
is
14, Lord, I'll take only 5 minutes of Lord's time. But matter is fairly covered by judgments of the High Courts as well as the Supreme Court. The word phrase owner, that is only subject matter of the Lord appreciation.
We'll give a date and hear it. Give a short date.
Yes.
Yes, 14 and 14.
22/9.
22.
Serial number 15 urgent. Serial number 16.
I am for the appellant, my lord.
You're ready now. Give a date.
16. That is also 22/9.
Yes.
Serial number 17.
The appellant, my lord, deposited the 50%.
They deposited. Non-filing counsel for the appellant submits that they have already deposited 50% of the amount. Give a date for this. Then
24/9.
18.
24/9. Serial number final hearing. Serial number 18.
Respondent, my lord. In the first case, in
24/9.
18.1, I am for appellant. Owner liability, my lord.
Liability is fixed on the owner.
Owner.
You
I
are
was
questioning the liability.
fixing the liability and the owner, and the claimants are filed the cross appeal, my lord, for announcement.
This also give a date.
20/9. Serial number 19.
I appear for appointment.
19, my lord, I appeal. I appeal.
What is that?
Climate enhancement of compensation.
Yes.
Short point is there. Short point is there, my lord. I am ready.
No, wherever Mr. Nagaraj's case comes, it's only short point.
25/9.
Do one date.
25/9.
Short date.
Ladyship, leave of this honorable court, if I may make a mention in serial number 37 of list number 2, your ladyship. Your ladyship had directed the petitioner's father to be present. We were informed that the chamber sitting had been cancelled. May I request for the presence of the petitioner and his father to be recorded, your ladyship?
No. We have already extended the interim order and all in that.
Then, since they were here, the presence could be recorded, your ladyship.
Because without anything, court said post on so and so. Because some inconvenience to the court. I have a meeting now.
Then, then
Court officer. Hello, madam.
ನಾಳೆ ಡೇಟ್ ಅಂತೆಲ್ಲ ಬರ್ತೀನಿ.
Court officer. Madam, serial number 18, list to 36.
ಫೈಲು ತನಕ ಅರುಣ್ ಸರ್ ಅದಲ್ಲೆಲ್ಲ
Madam?
ನೋಡ್ಕೊಂಡು ಬರೀ ಇವಳೆ ಆಶಾ ಲಿಸ್ಟ್ ನೋಡ್ಕೊಂಡು ಬರೀಬೇಕು ಅವರು ವೀಣಾ ಯಾರ ಹತ್ರ ಇರ್ಲಿ ಕೇಸು ನಮ್ ಕಷ್ಟ.
Court officer.
ಹೇಳಿ ಸರ್ ಏನ್ ಹೇಳಿ ಸರ್.
Madam, list to serial number 36 5 PM ಗೆ ಇದು ಇನ್ ಚೇಂಬರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆ.
ಸರ್ ಅದು 16/9 ಗೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
16/9
ಹೌದೌದು ಅಟ್ 5
Okay.
ಇನ್ ಚೇಂಬರ್ ಏನೇ 16/9 ಗೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
ಸೇಮ್ ಟೈಮ್ 5 PM, madam.
ಎಸ್
Thank you, madam.
ಓಕೆ ಸರ್ ಓಕೆ.